not an attorney representing a party to such civil action. B, inclusion of domestic and foreign entities. Subparagraph A shall apply to any third party without regard to whether such party is created or organized in the United States or under the law of the United States or any state. 3, litigation financing agreement. A, in general, the term litigation financing agreement means, with respect to any civil action, a written agreement, 1, whereby a third party agrees to provide funds to one of the named parties or any law firm affiliated with such civil action, and 2, which creates a direct or collateralized interest in the proceeds of such action by settlement, verdict, judgment, or otherwise, which 1 is based in whole or in part on a funding-based obligation to A, such civil action, B, the appearing counsel, C, any contractual co-counsel, or D, the law firm of such counsel or co-counsel, and 2 is executed with 606. A, any attorney representing a party to such civil action. B, any co-counsel in such civil action with a contingent fee interest in the representation of such party. C, any third party that has a collateral-based interest in the contingency fees of the counsel or co-counsel firm which is related in whole or in part to the fees derived from representing such party. Or D, any named party in such civil action. B, substantially similar agreements. The term litigation financing agreement shall include any contract, including any option, forward contract, futures contract, short position, swap, or similar contract, or other agreement which, as defined by the Secretary, is substantially similar to an agreement described in subparagraph A. C, exceptions. The term litigation financing agreement shall not include any agreement, 1, under which the total amount of funds described in subparagraph A1 with respect to an individual civil action is less than $10,000, or 2, in which the third party described in subparagraph A1 has a right to receive proceeds which are derived from or pursuant to such agreement that are limited to A, repayment of the principal of a loan, B, repayment of the principal of a loan plus any interest on such loan, provided that the rate of interest does not exceed the greater amount of A, 7%, or B, a rate equal to twice the average annual yield on 30-year United States Treasury securities, 608, as determined for the year preceding the date on which such agreement was executed. Or C, reimbursement of attorney's fees, or 2, bears a relationship described in section 267B to the named party receiving the payment described in subparagraph A1. 4, qualified litigation proceeds. A, in general, the term qualified litigation proceeds means, with respect to any taxable year, an amount equal to the realized gains, net income, or other profit received by a covered party during such taxable year, which is derived from or pursuant to any litigation financing agreement. B, anti-netting. Any gains, income, or profit described in subparagraph A shall not be reduced or offset by any ordinary or capital loss in the taxable year. C, prohibition on exclusion of certain amounts. In determining the amounts of realized gain under subparagraph A, amounts described in section 104A2 and 892A1 shall not be excluded. Section 5000F3, special rules. A, withholding of tax on litigation proceeds. Any applicable person having the control, receipt, or custody of any proceeds from a civil action by settlement, judgment, or otherwise, with respect to which such person had entered into a litigation financing agreement, shall deduct and withhold from such proceeds a tax equal to 15.9% of the qualified litigation proceeds, which are required to be paid to a third party pursuant to such agreement. B, applicable person. For purposes of this section, the term applicable person means any person which, 1, is a named party in a civil action or law firm affiliated with such civil action, and 2, has entered into a litigation financing agreement with respect to such civil action. C, application of withholding provisions. 1, liability for withheld tax. Every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax and is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with the provisions of this chapter. 2, withheld tax as credit to recipient of qualified litigation proceeds. Qualified litigation proceeds on which any tax is required to be withheld at the source under this chapter shall be included in the return of the recipient of such proceeds. By any amount of tax so withheld shall be credited against the amount of tax as computed in such return. 3, tax paid by recipient of qualified litigation proceeds if A, any person in violation of the provisions of this chapter fails to deduct and withhold any tax under this chapter, and B, thereafter the tax against which such tax may be credited is paid. The tax is also required to be deducted and withheld, shall not be collected from such person, but this paragraph shall in no case relieve such person from liability for interest or any penalties or additions to the tax otherwise applicable in respect of such failure to deduct and withhold. 4, refunds and credits with respect to withheld tax. Where there has been any overpayment of tax under this chapter, any refund or credit made under Chapter 6.5 shall be made to the withholding agent unless the amount of such tax was actually withheld by the withholding agent. B, exclusion from definition of capital assets. Section 1221A is amended. 1, in paragraph 7 by striking or at the end. 2, in paragraph 8 by striking the period at the end and inserting or, and 3, by striking at the end the following new paragraph. 9, any financial arrangement created by or any proceeds derived from a litigation financing agreement as defined under Section 5000F2. C, removal from gross income, Part 3 of Subchapter B of Chapter 1, as amended by the preceding provisions of this Act, is amended by inserting after Section 139L the following new section. Section 139M, qualified litigation proceeds. Gross income shall not include any qualified litigation proceeds as defined in Section 5000F2. D, clerical amendments. 1, Section 7701A16 is amended by inserting 5000F-3C1 before 1441. Two, the table of chapters for subtitle D as amended by the preceding provisions of this Act is amended by inserting after the item relating to Chapter 50B the following new item. Chapter 50C, litigation financing. 3, the table of sections for Part 3 of Subchapter B of Chapter 1 as amended by the preceding provisions of this Act is amended by inserting after the item relating to Section 139L the following new item. Section 139M, qualified litigation proceeds. E, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2025. Section 70605, excise tax on certain remittance transfers. A, in general, Chapter 36 is amended by inserting after Subchapter B the following new subchapter. Subchapter C, remittance transfers. Section 4475, imposition of tax. Section 4475, imposition of tax. A, in general, there is hereby imposed on any remittance transfer a tax equal to 1% of the amount of such transfer. B, payment of tax.
One, in general, the tax imposed by this section with respect to any remittance transfer shall be paid by the sender with respect to such transfer. 2, collection of tax. The remittance transfer provider with respect to any remittance transfer shall collect the amount of the tax imposed under subsection A with respect to such transfer from the sender and remit such tax quarterly to the Secretary at such time and in such manner as provided by the Secretary. 3, secondary liability. Where any tax imposed by subsection A is not paid at the time the transfer is made, then to the text that such tax is not collected, such tax shall be paid by the remittance transfer provider. C, tax limited to cash and similar instruments. The tax imposed under subsection A shall apply only to any remittance transfer to which the sender provides cash, a money order, a cashier's check, or any other similar physical instrument as determined by the Secretary to the remittance transfer provider. D, non-application to certain non-cash remittance transfers. Subsection A shall not apply to any remittance transfer for which the funds being transferred are withdrawn from an account held in or by a financial institution, A, which is described in subparagraphs A through H of Section 5312A2 of Title 31 United States Code, and B, that is subject to the requirements under subchapter 2 of Chapter 53 of such title, or 2, funded with a debit card or a credit card which is issued in the United States. E, definitions. For purpose of this section, 1, in general, the terms remittance transfer provider, and sender shall each have their respective meanings given such terms by Section 919G of the Electronic Fund Transfer Act, 15 U.S.C. 16930(1)G. 2, credit card. The term credit card has the same meaning given each such term under Section 920C3 of the Electronic Fund Transfer Act, 15 U.S.C. 16930(2)C3. 3, debit card. The term debit card has the same meaning given under such term such Section 920C2 of the Electronic Fund Transfer Act, 15 U.S.C. 16930(2)C2, without regard to subparagraph B of such section. F, application of anti-conduit rules for purposes of Section 7701L with respect to any multiple party arrangements involving the sender. A remittance transfer shall be treated as a financing transaction. B, conforming amendment. The table of subchapters for Chapter 36 is amended by inserting after the item relating to Subchapter B the following new item: Subchapter C, remittance transfers. C, effective date. The amendments made by this section shall apply to transfers made after December 31, 2025. Section 70606, enforcement provisions with respect to COVID-related employee retention credits. A, assessable penalty for failure to comply with due diligence requirements. 1, in general, any COVID ERTC promoters which provides aid, assistance, or advice with respect to any COVID ERTC document and which fails to comply with due diligence requirements imposed by the Secretary with respect to determining eligibility for or the amount of any credit or advance payment of a credit under Section 3134 of the Internal Revenue Code of 1986 shall pay a penalty of $1,000 for each such failure. Due diligence requirements. The due diligence requirements referred to in paragraph 1 shall be similar to the due diligence requirements imposed under Section 6695G of the Internal Revenue Code of 1986. 3, restriction to documents used in connection with returns or claims for refund. Paragraph 1 shall not apply with respect to any COVID ERTC document unless such document constitutes or relates to a return for claim for refund. 4, treatment as assessable penalty, etc. For purposes of the Internal Revenue Code of 1986, the penalty imposed under paragraph 1 shall be treated as a penalty which is imposed under Section 6695G of such code and assessed under Section 6201 of such code. 5, Secretary. For purposes of this subsection, the term Secretary means the Secretary of the Treasury or the Secretary's delegate. B, COVID ERTC promoter. For purposes of this section, 1, in general, the term COVID ERTC promoter means with respect to any COVID ERTC document, any person which provides aid, assistance, or advice with respect to such document if A, such person charges or receives a fee for such aid, assistance, or advice, which is based on the amount of the refund or credit with respect to such document and with respect to such person's taxable year in which such person provided such assistance or the preceding taxable year, the aggregate of the gross receipts of such person for aid, assistance, and advice with respect to all COVID ERTC documents exceeds 20% of the gross receipts of such person for such taxable year, or B, with respect to such person's taxable year in which such person provided such assistance or the preceding taxable year. 1, the aggregate of the gross receipts of such person for aid, assistance, and advice with respect to all COVID ERTC documents exceeds 50% of the gross receipts of such person for such taxable year, or both. 2, both. Such aggregate gross receipts exceed 20% of the gross receipts of such person for such taxable year, and 2, the aggregate of the gross receipts of such person for aid, assistance, and advice with respect to all COVID ERTC documents determined after application of paragraph 3 exceeds $500,000. 2, exception for certified professional employer organizations. The term COVID ERTC promoter shall not include a certified professional employer organization as defined in Section 7705 of the Internal Revenue Code of 1986. 3, aggregation rule. For purposes of paragraph 1, all persons treated as a single employer under subsection A or B of Section 52 of the Internal Revenue Code of 1986 or subsection M or O of Section 414 of such code shall be treated as one person. 4, Short taxable years. In the case of any taxable year of less than 12 months, a person shall be treated as a COVID ERTC promoter if such person is described in paragraph 1, either with respect to such taxable year or by treating any reference to such taxable year as a reference to the calendar year in which such taxable year begins. C, COVID ERTC document. For purposes of this section, the term COVID ERTC document means any return, affidavit, claim, or other document related to any credit or advance payment of a credit under Section 3134 of the Internal Revenue Code of 1986, including any document related to eligibility for or the calculation or determination of any amount directly related to any such credit or advance payment. D, limitation on credits and refunds. Notwithstanding Section 6511 of the Internal Revenue Code of 1986, no credit under Section 3134 of the Internal Revenue Code of 1986 shall be allowed, and no refund with respect to any such credit shall be made after the date of the enactment of this Act unless a claim for such credit or refund was filed by the taxpayer on or before January 31, 2024. E, extension of limitation on assessment. Section 3134L is amended to read as follows. 1, extension of limitation on assessment. 1, in general, notwithstanding Section 6501, the limitation on the time period for the assessment of any amount attributable to a credit claimed under this section shall not expire before the date, that is 6 years after the latest of A, the date on which the original return, which includes the calendar quarter with respect to such credit, is determined as filed, B, the date on which such return is treated as filed under Section 6501B2, or C, the date on which the claim for credit or refund with respect to such credit is made. Deduction 2, deduction for wages taken into account in determining improperly claimed credit. A, in general, notwithstanding Section 6511 in the case of an assessment attributable to a credit claimed under this section, the limitation on the time period for credit or refund of any amount attributable to a deduction for improperly claimed ERTC wages shall not expire before the time period for such assessment expires under paragraph 1. B, improperly claimed ERTC wages. For purposes of this paragraph, the term improperly claimed ERTC wages means with respect to an assessment attributable to a credit claimed under this section, the wages with respect to which a deduction would not have been allowed if the portion of the credit to which such assessment relates had been properly claimed. F, amendment to penalty for erroneous claim for refund or credit. Section 6676A is amended by striking income tax and inserting income or employment tax. G, effective dates. 1, in general, the provisions of this section shall apply to aid, assistance, and advice provided after the date of the enactment of this Act. 2, limitation on credits and refunds. Subsection D shall apply to credits and refunds allowed or made after the date of the enactment of this Act. 3, extension of limitation on assessment. The amendment made by subsection E shall apply to assessments made after the date of the enactment of this Act. 4, amendment to penalty for erroneous claim for a refund or credit. The amendment made by subsection F shall apply to claims for credit or refund after the date of the enactment of this Act. H, regulations. The Secretary, as defined in subsection A5, shall issue such regulations or other guidance as may be necessary or appropriate to carry out the purposes of this section and the amendments made by this section. Section 70607, Social Security number requirement for American Opportunity and Lifetime Learning Credits. A, Social Security number of taxpayer required. Section 25AG1 is amended to read as follows. 1, identification requirement. A, Social Security number requirement. No credit shall be allowed under subsection A to an individual unless the individual includes on the return of tax for the taxable year 1, such individual's Social Security number, and 2, in the case of a credit with respect to the qualified tuition and related expenses of an individual other than the taxpayer or the taxpayer's spouse, the name and Social Security number of such individual. B, institution. No American Opportunity tax credit shall be allowed under this section unless the taxpayer includes the employer identification number of any institution to which the taxpayer paid qualified tuition and related expenses taken into account under this section on the return of tax for the taxable year. C, Social Security number defined. For purposes of this amendment, the term Social Security number shall have the meaning given such term in section 24H7. B, omission treated as mathematical or clerical error. Section 6213G2J is amended by striking TIN and inserting Social Security number or employer identification number. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2025. Section 70608, Task force on the replacement of direct file. Out of any money in the Treasury not otherwise appropriated, there is hereby appropriated for the fiscal year ending September 30, 2026, $15 million to remain available until September 2026 for necessary expenses of the Department of the Treasury to deliver to Congress within 90 days following the date of enactment of this act a report on 1, the cost of enhancing and establishing public-private partnerships which provide for free tax filing for up to 70% of all taxpayers calculated by adjusted gross income and to replace any direct e-file programs run by the Internal Revenue Service. 2, taxpayer opinions and preferences regarding a taxpayer-funded government-run service or a free service provided by the private sector. 3, assessment of the feasibility of a new approach, how to make the options consistent and simple for taxpayers across all participating providers, and how to provide features to address taxpayer needs. And 4, the cost, including options for differential coverage based on taxpayer-adjusted gross income and return complexity of developing and running a free direct e-file tax return system, including costs and build and administer such release. Subtitle B, Health, Chapter 1, Medicaid. Subchapter A, Reducing Fraud and Improving Enrollment Processes. Section 71101, Moratorium on Implementation of Rule Relating to Eligibility and Enrollment in Medicare Savings Programs. The Secretary of Health and Human Services shall not, during the period beginning on the date of enactment of this section and ending September 30, 2034, implement, administer, or enforce the provisions of the final rule published by the Centers for Medicare and Medicaid Services in September 21, 2023, entitled Streamlining Medicaid, Medicare Savings Program Eligibility, Determination, Enrollment, 88 Fed Reg 65230, and shall not implement, administer, or enforce the amendments made to the following sections of Title 42 Code of Federal Regulations. 1, Section 406.21C, 2, Section 435.4, 3, Section 435.601, 4, Section 435.909, 5, Section 435.911, 6, Section 435.952, Section 71102, moratorium on eligibility on implementation of rule relating to eligibility and enrollment for Medicaid, CHIP, and the Basic Health Program. The Secretary of Health and Human Services shall not, during the period beginning on the date of enactment of this section and ending September 30, 2024, implement, administer, or enforce the provisions of the final rule published by the Centers for Medicaid and Medicaid Services on April 2, 2024, entitled Medicaid Program, Streamlining the Medicaid Children's Health Insurance Program and Basic Health Program Application, Eligibility, Determination, Enrollment, and Renewal Processes, 89 Fed Reg 22780, and shall not implement, administer, or enforce the amendments made by the following sections of Title 42 Code of Federal Regulations. 1, Part 431A, Section 431.10, C1, 1A2, B, Section 431.10, C11A3, C, Section 431.213D. 2, Part 435, A, Section 435.222, B, Section 435.223, C, Section 435.407, D, Section 435.601, E, Section 435.608, F, Section 435.831G, G, Section 435.907, H, Section 435.911C, 1, I, Section 435.912, J, Section 435.916, K, Section 435.919, L, Section 435.940, M, Section 435.952, N, Section 435.1200, 3, Part 436, A, Section 436.601, B, Section 436.831G, 4, Part 447, Section 447.56A15, 5, Part 457, A, Section 457.65D, B, Section 457.340D, C, Section 457.340F, D, Section 457.344, E, Section 457.348, F, Section 457.350, G, Section 457.480, H, Section 457.570, I, Section 457.805, B, J, Section 457.810A, K, Section 457.960, L, Section 457.1140, D4, M, Section 457.1170, N, Section 457.1180, Section 71103, reducing duplicate enrollment under the Medicaid and CHIP programs. A, Medicaid, 1, in general, Section 1902 of the Social Security Act, 42 U.S.C. 1 1.396A is amended A in subsection A, 1, in paragraph 86 by striking "and" at the end, 2, in paragraph 87 by striking the period and inserting "and 3, by inserting after paragraph 87 the following new paragraph. 88, provide, A, beginning not later than January 1, 2027 in the case of one of the 50 states and the District of Columbia, for a process to regularly obtain address information for individuals enrolled under such plan or a waiver of such plan, and in accordance with subsection and B, beginning not later than October 1, 2029, 1, for the state to submit to the system established by the Secretary under subsection U with respect to individual enrolled or seeking to enroll under such plan not less frequently than once each month or during such determination or redetermination of the eligibility of such individual for medical assistance under such plan or waiver of such plan. 1, the Social Security number of such individual, if such individual has a Social Security number and is required to provide such number to enroll under such plan or waiver, and 2, such other information with respect to such individual as determined necessary by the Secretary for purposes of preventing individuals from simultaneously being enrolled under state plans or waivers of such plans of multiple states. 2, for the use of such system to prevent such simultaneous enrollment. And 3, in the case that such system indicates that an individual enrolled or seeking to enroll under such plan or waiver of such plan is enrolled under a state plan or waiver of such a plan of another state, for the taking of appropriate action as determined by the Secretary to identify whether such an individual resides in the state and disenroll an individual from the state plan of such state if such individual does not reside in such state unless such individual meets such an exception as the Secretary may specify, and B, by adding at the end the following new subsections. UU, prevention of enrollment under multiple state plans. 1, in general, not later than October 1, 2029, the Secretary shall establish a system to be utilized by the Secretary and states to prevent an individual from being simultaneously enrolled under the state plans of multiple states. Such system shall A, provide for the receipt of information submitted by a state under subsection A88B1, and B, not less than once each month, transmit information to a state or allow the Secretary to transmit information to a state regarding whether an individual enrolled or seeking to enroll under the state plan of such state or waiver of such plan is enrolled under the state plan or waiver of such plan of another state. 2, standards. The Secretary shall establish such standards as determined necessary by the Secretary to limit and protect information submitted under such system and ensure the privacy of such information consistent with subsection A7. 3, implementation funding. There are appropriated to the Secretary out of the amounts of the Treasury not otherwise appropriated, in addition to amounts otherwise available. For fiscal year 2026, $10 million for purposes of establishing the system and standards required under this subsection to remain available until expended, and B, for fiscal year 2029, $20 million for purposes of maintaining such system to remain available until expended. BV, process to obtain enrollee address information. 1, in general, for purposes of subsection A88A, a process to regularly obtain address information for individuals enrolled under a state plan or a waiver of such plan shall obtain address information from reliable data sources described in paragraph 2 and take such actions as the Secretary shall specify with respect to any changes to such address based on such information. 2, reliable data sources described for purposes of paragraph 1. The reliable data sources described in this paragraph are the following. A, mail returned to the state by the United States Postal Service with a forwarding address. B, the National Change of Address database maintained by the United States Postal Service. C, a managed care entity as defined in Section 1932A1B or prepaid inpatient health care or prepaid ambulatory health plan, as such terms are defined in Section 1903M9D, that has a contract under the state plan if the address information is provided to such entity or plan directly from or verified by such entity or plan directly with such individual. D, other data sources as identified by the state and approved by the Secretary. 2, conforming amendments. A, Paris, Section 1903R3 of the Social Security Act, 42 U.S.C. 1396BR3 is amended. 1, by striking in order and inserting A in order. 2, by striking through the public and inserting through 1 the public. 3, by striking the period at the end and inserting semicolon. And 2, beginning October 1, 2029, the system established by the Secretary under Section 1902 UU, and 4, by adding at the end the following new subparagraph. B, beginning October 1, 2029, the Secretary may determine that a state is not required to have in operation an eligibility determination system which provides for data matching for purposes of address verification under Section 1902 VV through the system described in subparagraph A1 to meet the requirements of this paragraph. Managed care. Section 1932 of the Social Security Act, 42 U.S.C. 1396U-2, is amended by adding at the end the following new subsection. J, transmission of address information. Beginning January 1, 2027, each contract under a state plan with a managed care entity is defined in Section 1932A1B, or with a prepaid inpatient health care or prepaid ambulatory health plan, as such terms are defined in Section 1903M9D, shall provide that such entity or plan shall promptly transmit to the state any address information for an individual enrolled in such entity or plan that is provided to such entity or plan directly from or verified by such entity or plan directly with such individual. B, CHIP. 1. In general, Section 2107E1 of the Social Security Act, 42 U.S.C. 1397GGE1, is amended, A, by redesignating subparagraphs H through U as subparagraphs I through V, 1 through 5, respectively, and B, by inserting after subparagraph G the following new subparagraph. H, Section 1902A88 relating to address information for enrollees and prevention of simultaneous enrollments. 2, managed care. Section 2103F3 of the Social Security Act, 42 U.S.C. 1397CCF3, is amended by striking and E and inserting E and J. Section 71104, ensuring deceased individuals do not remain enrolled. Section 1902 of the Social Security Act, 42 U.S.C. 1396, is amended by Section 71103, is further amended, 1, in subsection A, in paragraph 87 by striking and inserting a semicolon. B, in paragraph 88 by striking the period at the end and inserting and C, by inserting after paragraph 88 the following new paragraph. 89, provide that the state shall comply with the eligibility verification requirements under subsection WW, except that this paragraph shall apply only in the case of the 50 states and the District of Columbia, and 2, by adding at the end of the following new subsection, WW, verification of certain eligibility criteria. 1, in general, for purposes of subsection A89, the eligibility verification requirements beginning January 1, 2028 are as follows. A, quarterly screening to verify enrollee status. The state shall, not less frequently than quarterly, review the death master file, as such term is defined in Section 203D of the Bipartisan Budget Act of 2013, or a successor system that provides such information needed to determine whether any individuals enrolled for medical assistance under the state plan or waiver of such plan are deceased. B, disenrollment under state plan. If the state determines, based on information obtained from the death master file, that an individual enrolled for medical assistance under the state plan or waiver of such plan is deceased, the state shall, 1, treat such information as factual information confirming the death of a beneficiary, 2, disenroll such individual from the state plan or waiver of such plan in accordance with subsection A3, and 3, discontinue any payments for medical assistance under this title made on behalf of such individual, other than payments for any items or services furnished to such individual prior to the death of such individual. C, reinstatement of coverage in the event of error. If a state determines that an individual was misidentified as deceased based on information obtained from the death master file and was erroneously disenrolled for medical assistance under the state plan or waiver of such plan, based on such misidentification, the state shall immediately re-enroll such individual under the state plan or waiver of such plan, retroactive to the date of such disenrollment. 2, rule of construction. Nothing under this subsection shall be construed to preclude the ability of a state to use other electronic data sources to timely identify potentially deceased beneficiaries, so long as the state is also in compliance with the requirements of this subsection and all other requirements under this title relating to Medicaid eligibility determination and redetermination. Section 71105, ensuring deceased providers do not remain enrolled. Section 1902 KK1 of the Social Security Act, 42 U.S.C. 1396A KK1, is amended, 1, by striking the state and inserting A in general the state, and 2, by adding at the end the following new subparagraph. B, provider screening against death master file. Beginning January 1, 2028, as part of the enrollment or re-enrollment or revalidation of enrollment, of a provider or supplier under this title and not less frequently than quarterly during that period that such provider or supplier is so enrolled, the state conducts a check of the death master file as such term is defined in Section 203D of the Bipartisan Budget Act of 2013 to determine whether such provider or supplier is deceased. Section 71106, payment reduction related to certain erroneous excess payments under Medicaid. In general, Section 1903U1 of the Social Security Act, 42 U.S.C. 1396BU1 is amended 1 in subparagraph A by inserting for any audits conducted by the Secretary or at the option of the Secretary, audits conducted by the state after exceeds 0.03, 2 in subparagraph B, A, by striking the Secretary and inserting 1 subject to Clause 2, the Secretary, and B, by adding at the end the following new clause. 2, the amount waived under Clause 1 for a fiscal year may not exceed an amount equal to the erroneous excess payments for medical assistance described in subparagraph D1, 2, made for such fiscal year. 3, in subparagraph 2, by striking he and each place it appears and inserting the Secretary in such place. And 4, in subparagraph D1, A, in subclause 1, by striking and at the end. B, in subclause 2, by striking the period at the end of, and inserting or payments where insufficient information is available to confirm eligibility, and C, by adding at the end the following new subclause. 3, payments other than payments described in subclause 1 for items and services furnished to an individual who is not eligible for medical assistance under the state plan or a waiver of such plan with respect to such items and services or payments where insufficient information is available to confirm eligibility. B, effective date. The amendments made by subsection A shall apply beginning with respect to fiscal year 2030. Section 71107, eligibility redeterminations, A in general. Section 1902E14 of the Social Security Act, 42 U.S.C. 1396AE14, is amended by adding at the end the following new subparagraph. L, frequency of eligibility redeterminations for certain individuals. 1, in general, subject to Clause 2 with respect to redeterminations of eligibility for medical assistance under a state plan or a waiver of such plan, scheduled on or after the first day of the first quarter that begins after December 31, 2026, the state shall make such a redetermination once every 6 months for the following individuals. 1, individuals enrolled under subsection A10A18. 2, individuals described in such subsection who are the otherwise enrolled under a waiver of such plan that provides coverage that is equivalent to a minimum essential coverage as described in section 5000AF1A of the Internal Revenue Code of 1986 and determined in accordance with standards prescribed by the Secretary and regulations to all individuals described in subsection A10A18. 2, exemption. The requirements described in section 1 shall not apply to any individual described in subsection XX9A22. 3, state defined. For purposes of this subparagraph, the term state means one of the 50 states or the District of Columbia. B, guidance. Not later than 180 days after the date of enactment of this section, the Secretary of Health and Human Services, acting through the Administrator of the Centers for Medicare and Medicaid Services, shall issue guidance relating to the implementation of the amendments made by this section. Section 71108, revising home equity limit for determining eligibility for long-term care services under the Medicaid program, revising home equity limit. Section 1917F1 of the Social Security Act, 42 U.S.C. 1396PF1 is amended. 1, in subparagraph B.
A, by striking A state and inserting I, A state. B, in clause I, as inserted by subparagraph A. I, by striking $500,000 and inserting the amount specified in subparagraph A, and II, by inserting in the case of an individual's home that is located on a lot that is zoned for agricultural use after apply subparagraph A, and C, by adding at the end the following new clause. II, a state may elect, without regard to the requirements of section 1902A, 1, relating to statewideness, and section 1902A10B, relating to comparability, to apply subparagraph A in the case of an individual's home that is not described in clause I by substituting for the amount specified in such subparagraph an amount that exceeds such amount but does not exceed $1 million, and 2, in subparagraph C. A, by inserting other than the amount specified in subparagraph B, II, relating to certain non-HIFE agricultural homes after specified in this paragraph, and B, by adding at the end the following new sentence in the case that application of the preceding sentence would result in a dollar amount other than the amount specified in subparagraph BI relating to certain agricultural homes exceeding $1 million such amount shall be deemed to be equal to $1 million. B, clarification. Section 1902 of the Social Security Act, 42 U.S.C. 1396A is amended, 1, in subsection R2 by adding at the end the following new subparagraph C. This paragraph shall not be construed as permitting a state to determine the eligibility of an individual for medical assistance with respect to nursing facility services or other long-term care services without application of the limit under section 1917 F1 and 2 in subsection E14D IV A by striking subparagraphs and inserting I in general subparagraphs, and B, by adding at the end the following new subclause. II, application of home equity interest limit. Section 1917F shall apply for purposes of determining the eligibility of an individual for medical assistance with respect to nursing facility services or other long-term service care. C, effective date. The amendments made by subsection A shall apply beginning on January 1, 2028. Sec 71109, Alien Medicaid Eligibility. A, Medicaid. Section 1903V of the Social Security Act, 42 U.S.C. 1396BV is amended, 1, in paragraph 1 by striking and 4 and inserting 4 and 5 and 2 by adding at the end the following new paragraph. 5, notwithstanding the preceding paragraphs of this subsection beginning on October 1, 2026, except as provided in paragraph 2 and 4, in no event shall payment be made to a state under this section for medical assistance furnished to an individual unless such individual is a resident of one of the 50 states, the District of Columbia, or a territory of the United States, and B, either I, a citizen or national of the United States, and an alien lawfully admitted for permanent residence as an immigrant as defined by sections 101A 15 and 101A 20 of the Immigration and Nationality Act, excluding, among others, alien visitors, tourists, diplomats, and students who enter the United States temporarily with no intention of abandoning their residence in a foreign country. An alien who has been granted the status of Cuban and Haitian entrant as defined in Section 501E of the Refugee Education Assistance Act of 1980, Public Law 96422, or IB, an individual who lawfully resides in the United States in accordance with a compact of a free association referred to in Section 402B2G of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. B, CHIP, Section 2107E1 of the Social Security Act, as amended by Section 71103B, is further amended, 1, by redesignating subparagraphs R through V as paragraphs B through W, respectively, and 2, by inserting the paragraph Q the following. R, Section 1903V5 relating to payments for medical assistance furnished to aliens, except in relation to payments for services provided under Section 2105A1D II, Sec 71110. Expansion FMAP for certain states providing payments for health care furnished to certain individuals. Section 1905 of the Social Security Act, 42 U.S.C. 1396D is amended, 1, in subsection Y. A, in paragraph 1E by inserting or 4 calendar quarters beginning on or after October 1, 2027. In the case such state is a specified state with respect to such calendar quarter, 80% after thereafter, and B, in paragraph 2 by adding at the end the following new subparagraph. C, specified state. The term specified state means with respect to a quarter, a state that I, provides any form of financial assistance from a state general fund during such quarter in whole or in part, whether or not made under a state plan or a waiver of such plan, under this title or under another program established by the state to or on behalf of an alien who is not a qualified alien, is not a child or pregnant woman, who is lawfully residing in the United States and eligible for medical assistance pursuant to Section 1903V4, or for child health assistance or pregnancy-related assistance pursuant to Section 2107E1Q for the purchasing of health insurance coverage as defined in Section 2791B1 of the Public Health Service Act for an alien who is not a qualified alien and is not a child or pregnant woman, or II provides any form of comprehensive health benefits coverage except such coverage required by federal law during such quarter, whether or not under a state plan or waiver of such plan, under this title or under another program established by the state, and regardless of the source of funding for such coverage, to an alien who is not a qualified alien and is not such a child or pregnant woman. D, immigration terms. I, alien. The term alien has the meaning given such term in Section 101A of the Immigration and Nationality Act. II, qualified alien. The term qualified alien has the meaning given such term in Section 431 of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996, except that the references to, in the opinion of the agency providing such benefits in subsection C of such Section 431 shall be treated as references to, in the opinion of the state in which such comprehensive health benefits coverage or such financial assistance is provided as applicable, and to, in subsection Z2. A, in subsection A, by striking for such year and inserting for such quarter, and B, in subparagraph B, I, in the matter preceding subclause I, by striking for year and inserting for calendar quarter in a year, and II, in subclause II, by striking for the year and inserting for the quarter for the state. Sec. 71111, expansion FMAP for emergency Medicaid. Section 1905 of the Social Security Act, 42 U.S.C. 1396D, is amended by adding at the end the following new subsection. KK, FMAP for treatment of an emergency medical condition notwithstanding subsection Y and Z, beginning on October 1, 2026, the federal medical assistance percentage for payments for care and services described in paragraph 2 of subsection 1903V furnished to an alien described in paragraph 1 of such subsection shall not exceed the federal medical assistance percentage determined under subsection B for such state. Subchapter B, preventing wasteful spending. Sec. 71112, moratorium on implementation of rule relating to staffing standards for long-term care facilities under the Medicare and Medicaid programs. The Secretary of Health and Human Services shall not, during the period beginning on the date of the enactment of this section and ending September 30, 2034, implement, administer, or enforce the provisions of the final rule published by the Centers for Medicare and Medicaid Services on May 10, 2024, entitled Medicare and Medicaid Programs, Minimum Staffing Standards for Long-Term Care Facilities, and Medicaid Institutional Programs Transparency Reporting. 89, Fed Reg 40876, and shall not implement, administer, or enforce the amendments made to the following sections of Part 483 of Title 42, Code of Federal Regulations. 1, Section 483.5. 2, Section 483.35. Sec. 71113, reducing state Medicaid costs. A, in general, Section 1902A34 of the Social Security Act, 42 U.S.C. 1396A, A34, is amended to read as follows. 34, provide that in the case of any individual who has been determined to be eligible for medical assistance under the plan and A, is enrolled under paragraph 10A IV III, such assistance will be made available to the individual for care and services, including under the plan and furnished in or after the month, before the month in which the individual made application or application was made on the individual's behalf, in the case of a deceased individual. For such assistance, if such individual was, or upon application would have been eligible for such assistance at the time such care and services were furnished, or B, is not described in subparagraph A. Such assistance will be made available to the individual for care and services, including under the plan and furnished in or after the second month before the month in which the individual made an application or application was made on the individual's behalf in the case of a deceased individual. For such assistance, if such individual was, or upon application would have been eligible for such assistance at the time such care and services were furnished. B, definition of medical assistance. Section 1905A of the Social Security Act, 42 U.S.C. 1396 is amended by striking in or after the third month before the month in which the recipient makes application for assistance and inserting, with respect to an individual described in Section 1902A 34A, in or after the month before the month in which the recipient makes application for assistance and with respect to an individual described in Section 1902A 34B, in or after the second month before the month in which the recipient makes application for assistance. C, CHIP, Section 2102B1B of the Social Security Act, 42 U.S.C. 1397BB, B1B, is amended, 1, in Clause IV by striking and at the end. 2, in Clause V by striking the period and inserting semicolon and. 3, by adding at the end the following new clause. VI shall, in the case that the state elects to provide child health or pregnancy-related assistance to an individual for any period prior to the month in which the individual made application for such assistance or application was made on behalf of the individual, provide that such assistance is not made available to such individual for items and services included under the state child health plan or waiver of such plan that are furnished before the second month preceding the month in which such individual made application or application was made on behalf of such individual for assistance. D, effective date. The amendments made by this section shall apply to medical assistance, child health assistance, and pregnancy-related assistance with respect to individuals whose eligibility or such assistance, child health assistance, or pregnancy-related assistance is based on an application made on or after the first day of the first quarter that begins after December 31st, 2026. Sec 71114, prohibiting federal Medicaid and CHIP funding for certain items and services. A, Medicaid, Section 1903I of the Social Security Act, 42 U.S.C. 1396b1, is amended, 1, in paragraph 26 by striking and inserting a semicolon. 2, in paragraph 27 by striking the period at the end and inserting colon or. 3, by inserting paragraph 27, the following new paragraph, 28, with respect to any amount expanded for specified gender transition procedures as defined in section 1905 LL, furnished to an individual enrolled in a state plan or waiver of such plan, and 4, in the flush left matter at the end by striking and 18 and inserting 18 and 28. B, CHIP, section 2107E 1 of the Social Security Act, 42 US 1397 GGE10, as redesignated by section 71103B 1A, is amended by striking and 17 and inserting 17 and 28. C, specified gender transition procedures defined. Section 1905 of the Social Security Act, 42 USC 1396D, is amended by adding at the end the following new subsection. LL, specified gender transition procedures. 1, in general, for purposes of section 1903 I-28, except as provided in paragraph 2, the term specified gender transition procedure means, with respect to an individual, any of the following when performed for the purpose of intentionally changing the body of such individual, including by disrupting the body's development, inhibiting its natural functions, or modifying its appearance to no longer correspond to the individual's sex. A, performing any surgery including I, castration, II, sterilization, III, orchiectomy, IV, serotoplasty, V, vasectomy, VI, tubal litigation, VII, hysterectomy, V, tripi, oophorectomy, IX, ovariectomy, X, medoidoplasty, XI, clitoroplasty, XII, reconstruction of the fixed part of the urethra with or without a medoidoplasty or a phalloplasty, X tripi, penectomy, XIV, phalloplasty, XV, vaginoplasty, XVI, vaginectomy, XVI, vulvoplasty, XV, tripi, reduction, thyrochondroplasty, XIX, chondrolaryngoplasty, XX, mastectomy, and XXI, any plastic, cosmetic, or aesthetic surgery that feminizes or masculinizes the facial or other body features of an individual. B, any placement of chest implants to create feminine breast or any placement of erection or testicle prosthesis. C, any placement of fat or artificial implants in the gluteal region. D, administering, prescribing, or dispensing to an individual medications including I, gonadotropin releasing hormone, GnRH, analogs, or other puberty-blocking drugs to stop or delay normal puberty, and II, testosterone, estrogen, or other androgens to an individual at doses that are supraphysiologic that would normally be produced endogenously in a healthy individual of the same age and sex. 2, exception. Paragraph 1 shall not apply to the following when furnished to an individual by a healthcare provider if the individual is a minor with consent of such individual's parents with or legal guardian. A, puberty suppression or blocking prescription drugs for the purpose of normalizing puberty for an individual experiencing precocious puberty. B, medically necessary procedures or treatments to correct for I, a medically verifiable disorder of sex development, including I-46XX chromosomes with viralization, II 46XY chromosomes with underviralization, and III, both ovarian and testicular tissues. II, sex chromosome structure, sex steroid hormone production of or sex hormone action if determined to be abnormal by a physician through genetic or biochemical testing. III, infection, disease, injury, or disorder caused or exacerbated by a previous procedure described in paragraph 1, or a physical disorder, physical injury, or physical illness that would, as certified by a physician, place the individual in danger of death or impairment of a major bodily function unless the procedure is performed, not including procedures performed for the alleviation of mental distress or IV procedures to restore or reconstruct the body of the individual in order to correspond to the individual's sex after one or more previous procedures described in paragraph 1, which may include the removal of a pseudophallus or breast augmentation. 3, sex. For purposes of paragraph 1, the term sex means either male or female as biologically determined and defined in paragraphs 4 and 5 respectively. 4, female. For purposes of paragraph 3, the term female means an individual who naturally has, had, will have, or would have, but for a developmental or genetic anomaly or historical accident, the reproductive system that at some point produces, transports, and utilizes eggs for fertilization. 5, male. For purposes of paragraph 3, the term male means an individual who naturally has, had, will have, or would have, but for a developmental or genetic anomaly or historical accident, the reproductive system that at some point produces, transports, and utilizes sperm for fertilization. Sec 71115, federal payments to prohibit entities. A, in general. No federal funds that are considered direct spending and provided to carry out a state plan under Title XIX of the Social Security Act or a waiver of such a plan shall be used to make payments to a prohibited entity for items and services furnished during the 1-year period beginning on the date of the enactment of this act, including any payments made directly to the prohibited entity or under a contract or other arrangement between a state and a covered organization. B, definitions in this section. 1, prohibited entity. The term prohibited entity means an entity including its affiliates, subsidiaries, successors, and clinics. A, that as of the first day of the first quarter beginning after the date of enactment of this act, I, as an organization described in section 501c3 of the Internal Revenue Code of 1986 and exempt from tax under section 501a of such code, II as an essential community provider described in section 156.235 of Title 45 Code of Federal Regulations as in effect on the date of enactment of this act that is primarily engaged in family planning services, reproductive health, and related medical care. And III provides for abortions other than an abortion, I, if the pregnancy is a result of an act of rape or incest, or II in the case where a woman suffers from a physical disorder, physical injury, or physical illness, including a life-endangering physical condition caused by or arising from the pregnancy itself. That would, as certified by a physician, place the woman in danger of death unless an abortion is performed, and B, for which the total amount of federal and state expenditures under the Medicaid program under Title XIX of the Social Security Act for medical assistance furnished in fiscal year 2023, made directly or by a covered organization to the entity or to any affiliates, subsidiaries, successors, or clinics of the entity, or made to the entity or to any affiliates, subsidiaries, successors, or clinics of the entity as part of a nationwide healthcare provider network, exceeded $800,000. 2, direct spending. The term direct spending has the meaning given the term under Section 250C of the Balanced Budget and Emergency Deficit Control Act of 1985, 2 USC 900C. 3, covered organization. The term covered organization means a managed care entity as defined in Section 1932A1B of the Social Security Act 42 USC 1396U to A1B, or a prepaid inpatient health plan or prepaid ambulatory health plan, as such terms are defined in Section 1903M9D of such Act 42 USC 1396 M9D. 4, state. The term state has the meaning given such term in Section 1101 of Social Security Act 42 USC 1301. Subchapter C, stopping abusive financing practices. Sec 71116, sunsetting increased FMAP incentive. Section 1905 II3 of the Social Security Act 42 USC 1396D II3 is amended 1 by striking which has not and inserting the following which. A has not. 2 in subparagraph A as so inserted by striking the period at the end and inserting and. 3 by adding at the end the following new subparagraph. B begins to expend amounts for all such individuals prior to January 1, 2026. Sec 71117, provider taxes. A, changes in threshold for hold harmless provisions of broad-based health care related taxes. Section 1903 W4 of the Social Security Act 42 USC 1396B W4 is amended 1. In subparagraph C, II by inserting and for fiscal years beginning on or after October 1, 2026, the applicable percent determined under subparagraph D shall be substituted for 6%. each place it appears, after each place it appears, and 2, by inserting the subparagraph C, II, the following new subparagraph, DI. For purposes of subparagraph C, II, the applicable percent determined under this subparagraph is I. In the case of a non-expansive estate and a class of health care items or services described in Section 443.56A of Title 42 Code of Federal Regulations as in effect on May 1, 2025. AA. If on the date of enactment of this subparagraph, the non-expansive state has enacted a tax and imposes such tax on such class, and the Secretary determines that the tax is within the hold harmless health threshold as of that date, the applicable percent of net patient revenue attributable to such class has been so determined, and B, if on the date of enactment of this subparagraph, the non-expansive state has not enacted or does not impose a tax with respect to such class, 0%, and II, in the case of an expansive state and a class of healthcare items or services described in Section 433.56A of Title 42 Code of Federal Regulations as in effect on May 1, 2025, subject to Clause IV. AA, if on the date of enactment of this subparagraph, the expansion state has enacted a tax and imposes such tax on such class, and the Secretary determines that the tax is within the hold harmless threshold as of the date, the lower of AA, the applicable percent of net patient revenue attributable to such class that has been so determined, and BB, the applicable percent specified in Clause II for the fiscal year, and BB, if on the date of enactment of this subparagraph, the expansion state has not enacted or does not impose a tax with respect to such class, 0%. For purposes of Clause II, AABB, the applicable percent is I for fiscal year 2028, 5.5%, II for fiscal year 2029, 5%, III for fiscal year 2030 at 4.5%, IV for fiscal year 2031, 4%, and V for fiscal year 2032 and each subsequent year, 3.5%. III, for purposes of Clause I, expansion estate. The term expansion state means a state that, beginning on January 1, 2014, or on any date thereafter, elects to provide medical assistance to all individuals described in Section 1902 A10A I V III under the state plan under this title or under a waiver of such plan. II, non-expansion state. The term non-expansion state means a state that is not an expansion state. IV, in the case of a tax of an expansion state in effect on the date of enactment of this clause that applies to a class of healthcare. Items or services that is described in paragraph 3 or 4 of Section 433.56A of Title 42 Code of Federal Regulations as in effect on May 1, 2025, and for which, on such date of enactment, is within the hold harmless threshold as determined by the Secretary, the applicable percent of net patient revenue attributable to such class that has been so determined shall apply for a fiscal year instead of the applicable percent specified in Clause II for the fiscal year. B, non-application to territories. The amendments made by this section shall only apply with respect to a state that is one of the 50 states or the District of Columbia. C, implementation funding. For the purpose of carrying out the provisions of and the amendments made by this section, they are appropriated out of any monies in the Treasury not otherwise appropriated to the Secretary of Health and Human Services, $6 million for fiscal year 2026 to remain available until expended. Sec. 71118, State-Directed Payments, A in general. Subject to subsection B, the Secretary of Health and Human Services in this section referred to as the Secretary shall revise Section 438.6 C2 III of Title 42 Code of Federal Regulations for successor regulation such that with respect to a payment described in such section made for a service furnished during a rating period beginning on or after the date of the enactment of this act, the total payment rate for such service is limited to 1, in the case of a state that provides coverage to all individuals described in Section 1902 A10 AIV III of the Social Security Act, 42 U.S.C. 1396 A10 AIV III, that is equivalent to minimum essential coverage as described in Section 5000A F1A of the Internal Revenue Code of 1986, and determined in accordance with standards prescribed by the Secretary in regulations under the state plan or waiver of such plan of such state under Title XIX of such Act, 100% of the specified total published Medicare payment rate, or in the absence of a specified total published Medicare payment rate, the payment rate under a Medicaid state plan or under a waiver of such plan, or 2, in the case of a state other than a state described in paragraph 1, 110% of the specified total published Medicare payment rate, or in the absence of a specified total published Medicare payment rate, the payment rate under a Medicaid state plan or under a waiver of such plan. B, grandfathering certain payments in the case of a payment described in Section 438.6C2 III of Title 42 Code of Federal Regulations, or a successor regulation for which written prior approval or a good faith effort to receive such approval as determined by the Secretary was made before May 1, 2025, or a payment described in such section for a rural hospital as defined in subsection D2, for which written prior approval or a good faith effort to receive such approval as determined by the Secretary was made by the date of enactment of this Act. For the rating period occurring within 180 days of the date of the enactment of this Act, beginning with the rating period on or after January 1, 2028, the total amount of such payment shall be reduced by 10% points each year until the total payment rate for such service is equal to the rate for such service specified in subsection A. C, treatment of expansion states. The revisions described in subsection A shall provide that, with respect to a state that begins providing the coverage described in paragraph 1 of subsection on or after the date of the enactment of this Act, the limitation described in such paragraph shall apply to such state with respect to a payment described in section 438.6C2 III of Title 42 Code of Federal Regulations or a successor regulation for a service furnished during a rating period beginning on or after the date of the enactment of this Act. D, definitions in this section. 1, rating speed. Rating period. The term rating period has the meaning given such term in section 438.2 of Title 42 Code of Federal Regulations or a successor regulation. 2, rural hospital. The term rural hospital means the following. A subsection D, hospital, as defined in paragraph 1B of section 1886D, that I is located in a rural area as defined in paragraph 2D of such section. II is treated as being located in a rural area pursuant to paragraph 8E of such section, or III is located in a rural census tract of a metropolitan statistical area as determined under the most recent modification of the Goldsmith modification, originally published in the Federal Register on February 27, 1992, 57 Fed Reg 6725. B, a critical access hospital as defined in section 1861 MM1. C, a sole community hospital as defined in section 1886D 5D III. D, a Medicare dependent small rural hospital as defined in section 1886D 5G IV. E, a low volume hospital as defined in section 1886D 12C. F, a rural emergency hospital as defined in section 1861 K2. 3, state. The term state means one of the 50 states or the District of Columbia. 4, total published Medicare payment rate. The term total published Medicare payment rate means amounts calculated as payment for specified services, including the service furnished that have been developed under Part A or Part B of the Title XVIII of the Social Security Act, 42 U.S.C. 1395 et seq. 5, written prior approval. The term written prior approval has the meaning given such term in section 438.6C2I of Title 42 Code of Federal Regulations or a successor regulation. E, funding. There are appropriated out of any monies in the Treasury not otherwise appropriated $7 million for each of fiscal years 2026 through 2033 for purposes of carrying out this section to remain available until expended. Sec. 71119. Requirements regarding waiver of uniform tax requirement for Medicaid provider tax. A, in general, Section 1903W of the Social Security Act, 42 U.S.C. 1396W is amended. 1, in paragraph 3E, by inserting after clause II, the following new clause. III, for purposes of clause III, a tax is not considered to be generally redistributive if any of the following conditions apply. I, within a permissible class, the tax rate imposed on any taxpayer or tax rate group as defined in paragraph 7J, explicitly defined by its relatively lower volume or percentage of Medicaid taxable units as defined in paragraph 7H, is lower than the tax rate imposed on any other taxpayer or the tax rate group explicitly defined by its relatively higher volume or percentage of Medicaid taxable units.
2, within a permissible class, the tax rate imposed on any taxpayer or tax rate group as so defined based upon its Medicaid taxable units as so defined is higher than the tax rate imposed on any taxpayer or tax rate group based upon its non-Medicaid taxable unit as defined in paragraph 7(1). 3, the tax excludes or imposes a lower tax rate on any taxpayer or tax rate group as so defined based on or defined by any description that results in the same effect as described in subclause 1 or 2 for a taxpayer or tax rate group. Characteristics that may indicate such type of exclusion include the use of terminology to establish a tax rate group. AA, based on payments or expenditures made under the program under this title without mentioning the term Medicaid or any similar term to accomplish the same effect as described in subclause 1 or 2, or BB, that closely approximates a taxpayer or tax rate group under the program under this title to the same effect and is described in subclause 1 or 2, and 2 in paragraph 7 by adding at the end the following new subparagraphs. H, the term Medicaid taxable unit means a unit that is being taxed within a health care related tax that is applicable to the program under this title. Such term includes a unit that is used as the basis for 1, payment under the program under this title, such as Medicaid bed days. 2, Medicaid revenue. 3, costs associated with the program under this title, such as Medicaid charges, claims, or expenditures. And 4, other units associated with the program under this title as determined by the Secretary. 1, the term non-Medicaid taxable unit means a unit that is being taxed within a health care related tax that is not applicable to the program under this title. Such term includes a unit that is used as the basis for 1, payment by non-Medicaid payers, such as non-Medicaid bed days. 2, non-Medicaid revenue. 3, costs that are not associated with the program under this title, such as non-Medicaid charges, non-Medicaid claims, or non-Medicaid expenditures. And 4, other units not associated with the program under this title as determined by the Secretary. J, the term tax rate group means a group of entities contained within a permissible class of health care-related tax that are taxed at the same rate. B, non-application to territories. The amendments made by this section shall only apply with respect to the state that is one of 50 states or the District of Columbia. C, effective date. The amendments made by this section shall take effect upon the date of enactment of this act, subject to any applicable transition period determined appropriate by the Secretary of Health and Human Services, not to exceed 3 fiscal years. Section 71120, requiring budget neutrality for Medicaid demonstration projects under Section 1115. A, in general, Section 1115 of the Social Security Act, 42 U.S.C. 1315, is amended by adding at the end the following new subsection. G, requirement of budget neutrality for Medicaid demonstration projects. 1, in general, beginning January 1st, 2027, the Secretary may not approve an application for or renewal or amendment of an experimental pilot or demonstration project undertaken under subsection A to promote the objectives of Title 19 in a state in this subsection referred to as Medicaid demonstration project unless the chief actuary for the Centers for Medicare and Medicaid Services certifies that such project, based on expenditures for the state program in the preceding fiscal year, or in the case of a renewal, the duration of the preceding waiver, is not expected to result in an increase in the amount of federal expenditures compared to the amount that such expenditures would otherwise be in the absence of such project. For purposes of this subsection, expenditures for the coverage of populations and services that the state could have otherwise provided through its Medicaid state plan or other authority under Title 19, including expenditures that could be made under such authority, but for the provision of such services at a different site of service than authorized under such state plan or other authority, shall be considered expenditures in the absence of such a project. 2, treatment of savings. In the event of that expenditures with respect to a state under a Medicaid demonstration project are, during an approval period for such project, less than the amount of such expenditures that would have otherwise been made in the absence of such project, the Secretary shall specify the methodology to be used with respect to the subsequent approval period for such project for purposes of taking the difference between such expenditures into account. Implementation funding. For the purposes of carrying out the provisions of and the amendments made by this section, they are appropriated out of any monies in the Treasury not otherwise appropriated to the Secretary of Health and Human Services, $5 million for each of fiscal years 2026 and 2027 to remain available until expended. Subchapter D, increasing personal accountability. Section 71121, requirement for states to establish Medicaid community engagement requirements for certain individuals. A, in general, Section 1902 of the Social Security Act, 42 U.S.C. 1396A, as amended by Section 71103 and 71104, Further amended by adding at the end of the following new subsection. 20, community engagement requirement for applicable individuals. 1, in general, except as provided in paragraph 11, beginning not later than the first day of the first quarter that begins after December 30th, 2026, or at the option of the state under a waiver or demonstration project under section 1115 of the state plan, such earlier date as the state may specify, subject to the succeeding provisions of this subject, a state shall provide, as a condition of eligibility for medical assistance for an applicable individual, that such individual is required to demonstrate community engagement under paragraph 2. A, in the case of an applicable individual who has filed an application for medical assistance under a state plan or a waiver of such plan under this title for one or more but not more than 3, as specified by the state, consecutive months immediately preceding the months during which such individual applies for such medical assistance, and B, in the case of an applicable individual enrolled and receiving medical assistance under a state plan or under a waiver of such plan under this title for one or more as specified by the state months, whether or not consecutive. 1, during the period between such individual's most recent determination or redetermination as applicable of eligibility and such individual's next regularly scheduled redetermination of eligibility, as verified by the state as part of such regularly scheduled redetermination of eligibility, or 2, in the case of a state that has elected under paragraph 4 to conduct more frequent verifications of compliance with the requirement to demonstrate community engagement during this period between the most recent and next such verification with respect to such individual. 2, community engagement compliance described. Subject to paragraph 3, an applicable individual demonstrates a community engagement under this paragraph for a month if such individual meets one or more of the following conditions with respect to such month, as determined in accordance with criteria established by the Secretary through regulation. A, the individual works not less than 80 hours. B, the individual completes not less than 80 hours of community service. C, the individual participates in a work program for not less than 80 hours. D, the individual is enrolled in an educational program at least half time. E, the individual engages in any combination of the activities described in subparagraphs A through D for a total of not less than 80 hours. F, the individual has a monthly income that is not less than the applicable minimum wage standard under Section 6 of the Fair Labor Standards Act of 1938, multiplied by 80 hours. G, the individual had an average monthly income over the preceding 6 months that is not less than the applicable minimum wage requirement under Section 6 of the Fair Labor Standards Act of 1938, multiplied by 80 hours, and is a seasonal worker, as described in Section 45RD5B of the Internal Revenue Code of 1986. 3, exceptions. A, mandatory exception for certain individuals. The state shall deem an applicable individual to have demonstrated community engagement under paragraph 2 for a month and may elect to not require an individual to verify information resulting in such deeming if 1, for part of all such month, the individual 1 was a specified excluded individual as defined in paragraph 9A2, or 2 was AA under the age of 19, BB entitled to or enrolled for benefits under Part A of Title XVIII or enrolled for benefits under Part B of Title XVIII or CC described in any of subclasses 1 through 7 of subsection A10A1, or 2, at any point during the 3-month period ending on the first day of such month, the individual was an inmate of a public institution. B, optional exception for short-term hardship events. 1, in general, the state plan or waiver of such plan may provide, in the case of an applicable individual who experiences a short-term hardship event during a month, that the state shall, under procedures established by the state in accordance with standards specified for the Secretary, in the case of a short-term hardship event described in Clause 2.2, and upon the request of such individual, a short-term hardship event described in subclause 1 or 3 of Clause 2, deem such individual to have demonstrated community engagement under paragraph 2 for such month. 2, short-term hardship event defined. For purposes of this subparagraph, an applicable individual experiences a short-term hardship event during a month if, for part or all of such month, 1, such individual receives inpatient hospital services, nursing facility services, services in an intermediate care facility for individuals with intellectual disabilities, inpatient psychiatric hospital services, or such other services of similar acuity, including outpatient care relating to other services specified in this subclause, as the Secretary determines appropriate. 2, such individual resides in a county or equivalent unit of local government, AA, in which there exists an emergency or disaster declared by the President pursuant to the National Emergencies Act or the Robert T. Stafford Disaster Relief and Emergency Assistance Act, or BV, that subject to the request from the state to the Secretary, made in such form at such time and containing such information as the Secretary may require, has an employment rate that is at or above the lesser of AA 8% or BB 1.5 times the national unemployment rate, or 3. Such individual or their dependent must travel outside of their community for an extended period of time to receive medical services necessary to treat a serious or complex medical condition as described in paragraph 9A2VEE that are not available within their community of residence. 4. Option to conduct more frequent compliance verifications. With respect to an applicable individual enrolled in receiving medical assistance under a state plan or a waiver of such plan under this title, the state shall verify, in accordance with procedures specified by the Secretary, that each such individual has met the requirement to demonstrate community engagement under paragraph 1 during each such individual's regularly scheduled redetermination of eligibility, except that a state may provide for such verifications more frequently. 5. Ex parte verifications. For purposes of verifying that an applicable individual has met the requirement to demonstrate community engagement under paragraph 1 or determining such individual to be deemed to have demonstrated community engagement under paragraph 3, or that an individual is a specified excluded individual under paragraph 9A2, the state shall, in accordance with standards established by the Secretary, establish processes and use reliable information available to the state, such as payroll data or payments or encounter data under this title for individuals and data on payments to such individuals for the provision of services covered under this title, without requiring, where possible, the applicable individual to submit additional information. 6. Procedure in the case of noncompliance. A. In general, if a state is unable to verify that an applicable individual has met the requirement to demonstrate community engagement under paragraph 1, including, if applicable, by verifying that such individual was deemed to have demonstrated community engagement under paragraph 3, the state shall, in accordance with standards specified by the Secretary, 1. Provide such individual with the notice of noncompliance described in subparagraph B. 2. 1. Provide such individual with a period of 30 calendar days beginning on the date on which such notice of noncompliance is received by the individual. 2. AA. Make a satisfactory showing to the state of compliance with such requirement, including, if applicable, by showing that such individual was or should be deemed to have demonstrated community engagement under paragraph 3, or BB, make a satisfactory showing to the state that such requirement does not apply to such individual on the basis that such individual does not meet the definition of applicable individual under 9A, paragraph 9A, and 2, if such individual is enrolled under the state plan or a waiver of such plan under this title, continue to provide such individual with medical assistance during such 30-day calendar period, and 3, if no such satisfactory showing is made and the individual is not a specified excluded individual described in paragraph 9A2, deny such individual's application for medical assistance under the state plan or waiver of such plan, or, as applicable, disenroll such individual from the plan or waiver of such plan not later than the end of the month following the month in which such 30 calendar day period ends, provided that 1, the state first determines whether, with respect to the individual, there is any other basis for eligibility for medical assistance under the state plan or waiver of such plan, or for another insurance affordability program, and 2, the individual is provided written notice and granted an opportunity for a fair hearing in accordance with subsection A3. B. Notice. The notice of noncompliance provided to an applicable individual under the paragraph A1 shall include information in accordance with standards specified by the Secretary on 1, how such individual may make a satisfactory showing of compliance with such requirement as described in subparagraph A2, or make a satisfactory showing that such requirement does not apply to such individual on the basis that such individual does not meet the definition of applicable individual under paragraph 9A, and 2, how such individual may reapply for medical assistance under the state plan or a waiver of such plan under this title in the case that such individual's application is denied, or as applicable in the case of such individual is disenrolled from the plan or waiver. Treatment of noncompliant individuals in relation to certain other provisions. A. Certain FMAP increases. A state shall not be treated as not providing medical assistance to all individuals described in section 1902A10A18, or as not expending amounts for all such individuals under the state plan or waiver of such plan solely because such an individual is determined ineligible for medical assistance under the state plan or waiver on the basis of failure to meet requirements to demonstrate community engagement under paragraph 1. B, other provisions. For purposes of section 36BC2B of the Internal Revenue Code of 1986, an individual shall be deemed to be eligible for minimum essential coverage described in section 5000 AF1A2 of such code for a month if such individual would have been eligible for medical assistance under a state plan or a waiver of such plan under this title, but for a failure to meet the requirement to demonstrate community engagement under paragraph 1. 8, outreach. A, in general, in accordance with standards specified by the Secretary beginning not later than the date that precedes December 31st, 2026, or if the state elects under paragraph 1 to specify an earlier date, such earlier date, by the number of months specified by the state under paragraph 1A plus 3 months, and periodically thereafter, the state shall notify applicable individuals enrolled under a state plan or waiver that this title, the requirement to demonstrate community engagement under the subsection, such notice shall include information on 1, how to comply with such requirement, including an explanation of the exceptions to such requirement under paragraph 3, and the definition of the term applicable individual under paragraph 9A. 2, the consequences of noncompliance with such requirement, and 3, how to report to the state any change in the individual status that could result in 1, the applicability of an exception under paragraph 3, or the end of the applicability of such an exception, or 2, the individual qualifying as a specified excluded individual under paragraph 9A2. B, form of outreach notice. A notice required under subparagraph A shall be delivered, 1, by regular mail, or if elected by the individual, to an electronic format, and 2, in 1 or more additional forms, which may include telephone, text message, an internet website, other commonly available electronic means, and such other forms as the Secretary determines appropriate. 9, definitions in this subsection. A, applicable individual. In general, the term applicable individual means an individual other than a specified excluded individual as defined in Clause 2. 1, who is eligible to enroll or is enrolled under the state plan under subsection A10, A18, or 2, who AA is otherwise eligible to enroll or is enrolled under a waiver of such plan that provides coverage that is equivalent to minimum essential coverage as described in section 5000 AF1A of the Internal Revenue Code of 1986, and as determined in accordance with standards prescribed by the Secretary and regulations. And BB has attained the age of 19 and is under 65 years of age, is not pregnant, is not entitled to or enrolled for benefits under Part A of Title 18, or enrolled for benefits under Part B of Title 18, and is not otherwise eligible to enroll under such plan. 2, specified excluded individual. For purposes of Clause 1, the term specified excluded individual means an individual as determined by the state in accordance with standards specified by the Secretary. 1, who is described in subsection A10A19. 2, who AA is an Indian or an urban Indian, as such terms are defined in paragraphs 13 and 28 of Section 4 of the Indian Healthcare Improvement Act. BB is a California Indian described in sections 809A of such act, or CC, has otherwise been determined eligible as an Indian for the Indian Health Service under regulations promulgated by the Secretary. 3, who is the parent, guardian, caretaker, relative, or family caregiver as defined in Section 2 of the Raise Family Caregivers Act of a dependent child 13 years of age and under, or a disabled individual. 4, who is a veteran with a disability rated as total under Section 1155 of Title 38 United States Code. 5, who is medically frail or otherwise has special medical needs as defined by the Secretary, including an individual, AA, who is blind or disabled, as defined in Section 1614. BB, with a substance use disorder. CC, with a disabling mental disorder. DD, with a physical, intellectual, or developmental disability that significantly impairs their ability to perform one or more of the activities of daily living, or EE, with a serious or complex medical condition. 6, who AA is in compliance with any requirements imposed by the state pursuant to Section 407, or BB, is a member of a household that receives supplemental nutrition assistance program benefits under the Food and Nutrition Act of 2008 and is not exempt from a work requirement under such act. 7, who is participating in a drug addiction or alcoholic treatment and rehabilitation program as defined in Section 3H of the Food and Nutrition Act of 2008. 8, who is an inmate of a public institution, or 9, who is pregnant or entitled to postpartum medical assistance under paragraph 5 or 16 of subsection E. B, educational program. The term educational program includes 1, an institution of higher education as defined in Section 101 of the Higher Education Act of 1965, and 2, a program of career and technical education as defined in Section 3 of the Carl D. Perkins Career and Technical Education Act of 2006. C, state. The term state means one of the 50 states or the District of Columbia. D, work program. The term work program has the meaning given such term in Section 601 of the Food and Nutrition Act of 2008. 10, prohibiting waiver of community engagement requirements. Notwithstanding Section 1115A, the provisions of this subsection may not be waived. 11, special implementation rule. A, in general, subject to subparagraph C. The Secretary may exempt a state from compliance with the requirements of this subsection if, 1, the state submits to the Secretary a request for such exemption made in such form and at such time as the Secretary may require, and including the information specified in subparagraph B. And 2, the Secretary determines that based on such request, the state is demonstrating a good faith effort to comply with the requirements of this subsection. B, good faith effort determination. In determining whether a state is demonstrating a good faith effort for purposes of subparagraph A2, the Secretary shall consider 1, any actions taken by the state toward compliance with the requirements of this subsection. 2, any significant barriers to or challenges in meeting such requirements, including related to funding, design, development, procurement, or installation of necessary systems or resources. 3, the state's detailed plan and timeline for achieving full compliance with such requirements, including any milestones of such plan as defined by the Secretary. And 4, any other criteria determined appropriate by the Secretary. C, duration of exemption. 1, in general, an exemption granted under subparagraph A shall expire not later than December 31st, 2028, and may not be renewed beyond such date. 2, early termination. The Secretary may terminate an exemption granted under subparagraph A prior to the expiration date of such exemption if the Secretary determined that the state has 1, failed to comply with the reporting requirements described in subparagraph D, or 2, based on the information provided pursuant to subparagraph D, failed to make continued good faith efforts toward compliance with the requirements of this subsection. D, reporting requirements. A state granted an exemption under subparagraph A shall submit to the Secretary 1, quarterly progress reports on the state's status in achieving the milestones toward full compliance described in subsection B3, and 2, information on specific risks or newly identified barriers or challenges to full compliance, including the state's plan to mitigate such risks, barriers, or challenges. B, conforming amendment, section 1902A10A18 of the Social Security Act, 42 U.S.C. 1396 AA10A18 is amended by striking subject to subsection K and inserting subject to subsection K and XX. C, prohibiting conflicts of interest. A state shall not use a Medicaid managed care entity or other specified entity as such terms are defined in section 1903 M9D or other contractor to determine beneficiary compliance under such section unless the contractor has no direct or indirect financial relationship with any Medicaid managed care entity or other specified entity that is responsible for providing or arranging for coverage of medical assistance for individuals enrolled with the entity pursuant to a contract with such state. D, interim final rulemaking. Not later than June 1st, 2026, the Secretary of Health and Human Services shall promulgate an interim final rule for purposes of implementing the provisions of and the amendments made by this section. Any action taken to implement the provisions of and the amendments made by this section shall not be subject to the provisions of Section 553 of Title V United States Code. E, development of government efficiency grants to states. 1, in general, in order for states to establish systems necessary to carry out the provisions of and amendments made by this section or other sections of this chapter that pertain to conducting eligibility determinations or redeterminations, the Secretary of Health and Human Services shall A, out of the amount appropriated under paragraph 3A, award to each state a grant equal to the amount specified in paragraph 2 for such state, and B, out of amounts appropriated under paragraph 3B, distribute an equal amount among such states. 2, amounts specified. For purposes of paragraph 1A, the amount specified in this paragraph is an amount that bears the same ratio to the amount appropriated under paragraph 3A as the number of applicable individuals, as defined in section 1902 XX of the Social Security Act, as added by subsection A, residing in such states bear to the total number of such individuals residing in all states as of March 31st, 2025. Funding. There are appropriated out of any monies in the Treasury not otherwise appropriated $100 billion for fiscal year 2026 for purposes of awarding grants under paragraph 1A to remain available until expended, and B, $100 million for fiscal year 2026 for purposes of awards grants under paragraph 1B to remain available until expended. For definition, in this subsection, the term state means one of the 50 states and the District of Columbia. F, implementation funding for the purposes of carrying out the provisions of and the amendments made by this section. They are appropriated out of any monies in the Treasury not otherwise appropriated to the Secretary of Health and Human Services, $15 million for fiscal year 2026 to remain available until expended. Section 71122, modifying cost-sharing requirements for certain expansion individuals under the Medicaid program. A, in general, Section 1916 of the Social Security Act, 42 U.S.C. 1396-0 is amended, 1, in subsection A, in the matter preceding paragraph 1, by inserting, other than beginning October 1st, 2028, specified individuals as defined in subsection K3. After individuals, and 2, by adding at the end of the following new subsection K, special rules for certain expansion individuals. 1, premiums. Beginning October 1st, 2028, the state plan shall provide that in the case of a specified individual as defined in paragraph 3, who is eligible under the plan, no enrollment fee, premium, or similar charge will be imposed under the plan. 2, required imposition of cost sharing. A, in general, subject to subparagraph B, to subsection J, in the case of a specified individual, the state plan shall, beginning October 1st, 2028, provide for the imposition of such deductions, cost sharing, or similar charges determined appropriate by the state, in an amount greater than $0 with respect to certain care items or services furnished to such an individual as determined by the state. B, limitations. 1, exclusion of certain services. In no case may a deduction, cost sharing, or similar charge be imposed under the state plan with respect to care items or services described in any of the subparagraphs B through J of subsection A2, or any primary care services, mental health services, substance use disorder services, or services provided by a federally qualified health center. As defined in 1905-12, certified community behavioral health clinic as defined in section 1905-JJ2, or rural health clinic as defined in 1905-11, furnished to a specified individual. 2, item and service limitation. 1, in general, except as provided in subclause 2, in no case may a deduction, cost sharing, or similar charge imposed under the state plan with respect to care or an item or service furnished to a specified individual exceed $35. 2, special rules for prescription drugs. In no case may a deduction, cost sharing, or similar charge imposed under the state plan with respect to the prescription drug furnished to a specified individual exceed the limit that would be applicable under paragraph 2A1 or 2B of section 1916 AC with respect to such drug and individual if such drug so furnished were subject to cost sharing under such section. 3, maximum limit on cost sharing. The total aggregate amount of deductions, cost sharing, or similar charges imposed under the state plan for all individuals in the family may not exceed 5% of the family income of the family involved, as applied on a quarterly or monthly basis as specified by the state. C, cases of non-payment, notwithstanding subsection E, a state may permit a provider participating under the state plan to require as a condition for the provision of care, items, or services to a specified individual entitled to medical assistance under this title for such care, items, or services, the payment of any deductions, cost sharing, or similar charges authorized to be imposed with respect to such care, items, or services. Nothing in this subparagraph shall be construed as preventing a provider from reducing or waiving the application of such deductions, cost sharing, or similar charges on a case-by-case basis. 3, specified individual defined. For purposes of this subsection, the term specified individual means an individual who has a family income as determined in accordance with section 1902E14 that exceeds the poverty line as defined in section 2110C5, applicable to a family of the size involved, and A, is enrolled under section 1902A10A18, or B,
B is described in such subsection and otherwise enrolled under a waiver of the state plan that provides coverage that is equivalent to minimum essential coverage as described in section 5000A F1A of the Internal Revenue Code of 1986 and determined in accordance with standards prescribed by the Secretary and regulations to all individuals described in section 1902A 10A18. 4, state defined. For purposes of the subsection, the term state defined means one of the 50 states or the District of Columbia. B, conforming amendments. 1, required applications. Section 1902A14 of the Social Security Act, 42 U.S.C. 1396A, A14, is amended by inserting and provide for imposition of such deductions, cost sharing, or similar charges for care, items, or services furnished to specific individuals as defined in paragraph 3 of section 1916K, in accordance with paragraph 2 of such section after section 1916. 2, non-applicability of alternative cost sharing. Section 1916A1 of the Social Security Act, 42 U.S.C. 1396-01A1, is amended in the second sentence by striking or J and inserting J or K. Subchapter E, expanding access to care, section 71123, making certain adjustments to coverage of home or community-based services under Medicaid. A, expanding HCBS coverage under section 1915C waivers. Section 1915C of the Social Security Act, 42 U.S.C. 1396 NC, is amended, 1, in paragraph 3 by inserting paragraph 11 or before subsection H2, and 2, by adding at the end of the following new paragraph 11, expanding coverage for home or community-based services. A, in general, beginning July 1st, 2028, notwithstanding paragraph 1, the Secretary may approve a waiver that is a standalone from any other waiver approved under the subsection to include as medical assistance under the state plan of such state payment for part or all part of the cost of home or community-based services other than room and board, as described in paragraph 1, approved by the Secretary, which are provided pursuant to a written plan of care to individuals described in some paragraph B3. A waiver approved under this paragraph shall be for an initial term of 3 years and, upon the request of the state, shall be extended for additional 5-year periods unless the Secretary determines that the previous waiver period, the requirements specified under this subsection, excluding those accepted under subparagraph B, have not been met. B, state requirements. In addition to the requirements specified under the subsection, except for the requirements described in some paragraphs C and D of paragraph 2, and any other requirements specified under the subsection that the Secretary determines to be inapplicable to the context of a waiver that does not require individuals to have a determination described in paragraph 1, a state shall meet the following requirements as a condition of waiver approval. 1, as the date that such request a waiver, this subsection to provide home or community-based services to individuals scheduled in Clause 3, all other waivers, if any, granted under this subsection to such state meet the requirements of this subsection. 2, the state demonstrates to the Secretary that approval of a waiver under the subsection with respect to individuals described in Clause 3 will not result in a material increase of the average amount of time that individuals with respect to whom a determination described in paragraph 1 has been made will need to wait to receive home or community-based services under any other waiver granted under this subsection as determined by the Secretary. 3, the state establishes needs-based criteria subject to the approval of the Secretary regarding who will be eligible for home or community-based services under a waiver approved by this paragraph without requiring such individual to have a determination described in paragraph 1 and specifies the home or community-based services such individuals are so eligible will receive. 4, the state establishes needs-based criteria for determining whether an individual described in Clause 3 requires a level of care provided in a hospital, nursing facility, or in an intermediate care facility for individuals with developmental disabilities under the state plan or under any waiver of such plan that are more stringent than the needs-based criteria established under Clause 3 for determining eligibility for home or community-based services. 5, the state attests that the state's average per capita expenditure for medical assistance under the state plan or waiver of such plan, provided with respect to such individuals enrolled in a waiver under this paragraph, will not exceed the state's average per capita expenditure for medical assistance for individuals receiving institutional care under the state plan or waiver of such plan for the duration that the waiver under this paragraph is in effect. 6, the state provides to the Secretary data in such form and manner as the Secretary may specify regarding the number of individuals described in Clause 3 with respect to a state seeking approval of a waiver under the subsection, to whom the state will make such services available under such waiver. 7, the state agrees to provide to the Secretary, not less frequently than annually, data for purposes of paragraph 2E in such form and manner as the Secretary may specify regarding with respect to each preceding year in which a waiver under this subsection to provide home or community-based services to individuals described in Clause 3 was in effect. 1, the cost of such terms defined by the Secretary of such services furnished to individuals described in Clause 3, broken down by type of service. 2, with respect to each type of home or community-based service provided under the waiver, the length of time that such individuals have received such service. 3, a comparison between the data described in subclause 1 and any comparable data available with respect to individuals with respect to with a determination described in paragraph 1 has been made, and with respect to individuals receiving institutional care under this title. And 4, the number of individuals who have received home or community-based services under the waiver during this preceding year. C, limitation on payments. No payments made to carry out this paragraph shall be used to make payments to a third party on behalf of an individual practitioner for benefits such as health insurance, skills training, and other benefits customary for employees in the case of a class of practitioners for which the program established under this title is the primary source of revenue. B, implementation funding. 1, in general, there are appropriated out of any monies in the Treasury not otherwise appropriated to the Secretary of Health and Human Services. A, for fiscal year 2026, $50 million for purposes of carrying out the provisions of and the amendments made by this section to remain available until expended, and B, for fiscal year 2027, $100 million for purposes of making payments to states, subject to paragraph 2, to support state systems to deliver home or community-based services under section 1915C of the Social Security Act, 42 U.S.C. 1396 NC, as amended by this section, to remain available until expended. 2, payments based on the state HCBS eligible population. Payments to states from the amounts made available by paragraph 1B shall be made with respect to a state on the basis of the proportion of the population of the state that is eligible for home or community-based services under section 1915C of the Social Security Act, 42 U.S.C. 1396 NC, as amended by the section, as compared to all states. Section 71124, determination of FMAP for high poverty states. Section 1905B of the Social Security Act, 42 U.S.C. 1396D, is amended in the first sentence, 1, by striking and 6 and inserting 6, and 2, by inserting before the period the following, comma, and 7, only for purposes of payments for medical assistance under this title, excluding any such payments that are based on the enhanced FMAP described in section 2105B in the case of a state for which the Secretary issues under the authority of section 673(2) of the Omnibus Budget Reconciliation Act of 1981, a separate poverty guidance for any calendar year occurring during or after the date of enactment of this clause that is higher than the poverty guideline issued by the Secretary for such calendar year that is applicable to the majority of the states. The regular federal medical assistance percentage determined for such a state under this subsection without regard to any adjustments to such percentage for the first fiscal year quarter that begins after such date of enactment, and for each fiscal year quarter beginning thereafter, shall be increased after such determination, but prior to any increase which may be applicable, and in no case to exceed 100% by the case of the state with the highest separate poverty guideline for the calendar year. 25% of the average regular federal medical assistance percentage determined without regard to any adjustments to such percentage for the fiscal year for states which do not have a separate poverty guideline issued for them for such calendar year, and in the case of the state with the second highest separate poverty guideline for the calendar year, 15% of the average regular federal medical assistance percentage determined without regard to any adjustments to such percentage. For the fiscal year for states which do not have a separate poverty guideline issued for them for such calendar year. Chapter 2, Medicare. Subchapter A, Strengthening Eligibility Requirements. Section 71201, Limiting Medicare Coverage of Certain Individuals. Title 18 of the Social Security Act, 42 U.S.C. 1395 et sec, is amended by adding at the end of the following new section. Section 1899C, Limiting Medicare Coverage of Certain Individuals. A, in general, subject to subsection B, an individual may be entitled to or enrolled for benefits under this title only if the individual is 1, a citizen or national of the United States, 2, an alien who is lawfully admitted for permanent residence under the Immigration and Nationality Act, 3, an alien who has been granted the status of Cuban and Haitian entrant as defined in Section 501(c)(e) of the Refugee Education Assistance Act of 1980, Public Law 96-422, or 4, an individual who lawfully resides in the United States in accordance with the Compact of Free Association referred to in Section 402(b)(2)(g) of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. B, application to individuals currently entitled to or enrolled for benefits. 1, in general, in the case of an individual who is entitled for or enrolled for benefits under this title as of the date of the enactment of this section, subsection A shall apply beginning on the date that is 18 months after such date of enactment. 2, review by Commissioner or Social Security. A, in general, not later than 1 year after the date of the enactment of this section, the Commissioner of Social Security shall complete a review of individuals entitled to or enrolled for benefits under this title of such date of enactment for purposes of identifying individuals not described in any of the paragraphs 1 through 4 of subsection A. B, notice. The Commissioner of Social Security shall notify each individual identified under the review conducted under subparagraph A that such individual's entitlement to or enrollment for benefits under this title will be terminated as of the date that is 18 months after the date of the enactment of the section. Such notification shall be made as soon as practical after such identification and in the manner designed to ensure such individual's comprehension of such notification. Subchapter B, Improving Services for Seniors, Section 71202, Temporary Payment Increase under the Medicare Physical Fee Schedule to account for exceptional circumstances. A, in general, Section 1848T1 of the Social Security Act, 42 U.S.C. 1395W4T1 is amended. 1, in the matter preceding subparagraph A by striking and 2024 and inserting 2024 and 2026. 2, in subparagraph D by striking and at the end. 3, in subparagraph E by striking the period at the end and inserting semicolon and 4, by adding at the end of the new subparagraph F. Such services furnished on or after January 1, 2026 and before January 1, 2027 by 2.5%. B, conforming amendment. Section 1848C2B45 of the Social Security Act, 42 U.S.C. 1395 W4C2B45, is amended by striking or 2024 and inserting 2024 or 2026. Section 71203, expanding and clarifying the exclusion for orphan drugs under the Drug Price Negotiation Program. A, in general, Section 1192E of the Social Security Act, 42 U.S.C. 1320 F1E is amended. 1, in paragraph 1, in the matter preceding subparagraph A by striking and 3 and inserting through 4. 2, in paragraph 3A, A, by striking only one rare disease or condition and inserting one or more rare disease or conditions, and B, by striking such rare disease or condition and inserting one or more such rare diseases or conditions as such term is defined in Section 526A2 of the Federal Food, Drug, and Cosmetic Act, and 3, by adding at the end of the following new paragraph. 4. Treatment of former orphan drugs. In the case of a drug or biological product that, as of the date of approval or licensure of such drug or biological product, is a drug or biological product described in paragraph 3A, paragraph 1A2, or 1B2 as applicable, shall apply as if the reference to the date of such approval or the date of such licensure, respectively, were instead a reference to the first day after the date of such approval for which such drug is not a drug described in paragraph 3A, or the first day after the date of such licensure for which such biological product is not a biological product described in paragraph 3A, respectively. B, application. The amendments made by subsection A shall apply with respect to initial price applicability years as defined in section 1191B of the Social Security Act, 42 U.S.C. 1320 FB, beginning on or after July 1st, 2028. Section 71204, application of cost of living adjustment to non-labor related portion for hospital outpatient department services furnished in Alaska and Hawaii. Section 1833T of the Social Security Act, 42 U.S.C. 1395 LT, is amended by adding at the end the following new paragraph. 23, application of cost of living adjustment to non-labor related portion for hospital outpatient department services furnished in Alaska and Hawaii. A, in general, with respect to OPD services furnished on or after January 1st, 2027, the Secretary shall provide for adjustments to the payment amounts under the subsection for such services in the same manner that is provided under Section 1886D5H with respect to the application of the cost of living adjustment to the non-labor related portion of such payment amounts to take into account the unique circumstances of hospitals located in Alaska or Hawaii. Such adjustments shall not apply to payment amounts for a separately payable drug, biological, or medical device. B, application without regard to budget neutrality. Adjustments to payment amounts made under this paragraph. 1, shall not be considered an adjustment under paragraph 2E, and 2, shall not be implemented in a budget neutral manner. Chapter 3, Health Tax. Subchapter A, Improving Eligibility Criteria. Section 71301, Permitting Premium Tax Credit only for certain individuals. A, in general, Section 36BE1 is amended by inserting or in the case of aliens who are lawfully present are not eligible aliens, after individuals who are not lawfully present. B, eligible aliens. Section 36BE2 is amended. 1, by striking for purposes of this section an individual and inserting for purposes of this section A, in general, an individual, and 2, by adding at the end of the following new subparagraph. B, eligible aliens. An individual who is an alien and lawfully present shall be treated as an eligible alien if such individual is and is reasonably expected to be for the entire period of enrollment for which the credit under this section is being claimed. 1, an alien who is lawfully admitted for permanent residence under the Immigration and Nationality Act, 8 U.S.C. 1101 et sec. 2, an alien who has been granted the status of Cuban and Haitian entrant as defined in Section 501E of the Refugee Education Assistance Act of 1980, Public Law 96-422, or 3, an individual who lawfully resides in the United States in accordance with the Compact of Free Association referred to in Section 402B2G of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996, 8 U.S.C. 1612B2G. C, conforming amendments. 1, verification of information. Section 1411 of the Patient Protection and Affordable Care Act, 14 U.S.C. 18081 is amended. A, in subsection A, 1, in paragraph 1 by striking and section 36BE of the Internal Revenue Code, and 2, in paragraph 2, 1 in subparagraph A by striking and at the end, 2, in subparagraph B by adding and at the end, and 3, by adding at the end the following new subparagraph. C, in the case such individual is an alien lawfully present in the United States, whether such individual is an eligible alien within the meaning of Section 36B(e)(2) of such code. B, in subsection B3, by adding at the end the following new subparagraph. D, immigration status. In the case the individual's eligibility is based on an attestation of the enrollee's immigration status, an attestation that such individual is an eligible alien without the meaning of 36B(e)(2) of the Internal Revenue Code of 1986, and C, in subsection C2B2, by adding at the end the following new subclause. 3, in the case of an individual described in clause 1.1 with respect to whom a premium tax credit under Section 36B of the Internal Revenue Code of 1986 is being claimed, the attestation that the individual is an eligible alien within the meaning of Section 36B(e)(2) of such code. 2, advanced determinations. Section 1412D of the Patient Protection and Affordable Care Act, 42 U.S.C. 18082D, is amended by inserting before the period at the end the following, comma, or credits under Section 36B of the Internal Revenue Code of 1986 for aliens who are not eligible aliens within the meaning of Section 36B(e)(2) of such code. 3, effective date. The amendments made by this subsection shall apply with respect to plan years beginning on or after January 1, 2027. D, clerical amendments. 1, the heading for this section, 36BE, is amended by inserting "and not eligible aliens" after individuals not lawfully present. 2, the heading for this section, 36BE2, is amended by inserting "eligible aliens" after lawfully present. E, requirement to maintain minimum essential coverage. Section 5000A(d)(2)(d)(3) is amended by striking "an alien lawfully present in the United States" and inserting "an eligible alien" within the meaning of Section 36BE2. F, regulations. The Secretary of the Treasury and the Secretary of Health and Human Services may each prescribe such rules and other guidance as may be necessary or appropriate to carry out the amendments made by this section. G, effective date. The amendments made by this section, other than the amendments made by subsection C, shall apply to taxable years beginning after December 31st, 2026. Section 71302, disallowing premium tax credit during periods of Medicaid ineligibility due to alien status. A, in general, Section 36B(c)(1) is amended by striking subparagraph B. B, regulations. The Secretary of the Treasury and the Secretary of Health and Human Services may each prescribe such rules and other guidance as may be necessary or appropriate to carry out the amendments made by this section. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2025. Subchapter B, preventing waste, fraud, and abuse. Section 71303, requiring verification of eligibility for premium tax credit. A, in general, Section 36B(c) is amended by adding at the end the following new paragraphs. 5, exchange enrollment verification requirement. A, in general, the term coverage month shall not include with respect to any individual covered by a qualified health plan enrolled through an exchange any month beginning before the exchange verifies using applicable enrollment information that shall be provided or verified by the applicant such individuals' eligibility, 1, to enroll in the plan through the exchange, and 2, for any advance payment under Section 1412 of the Patient Protection Affordable Care Act of the credit allowed under this section. B, applicable enrollment information. For purposes of subparagraph A, applicable enrollment information shall include affirmation of at least the following information to the extent relevant in determining eligibility described in subparagraph A. 1, household income and family size. 2, whether the individual is an eligible alien. 3, any health coverage status or eligibility for coverage. 4, place of residence. 5, such other information as may be determined by the Secretary in consultation with the Secretary of Health and Human Services as necessary to the verification prescribed under subparagraph A. C, verification of past months. In the case of a month that begins before verification prescribed by subparagraph A, such month shall be treated as a coverage month if and only if the exchange verifies for such month using applicable enrollment information that shall be provided or verified by the applicant, such individual's eligibility to have so enrolled and for such advance payment. D, exchange participation. Coordination with other procedures for determining eligibility. An individual shall not, solely by reason of failing to meet the requirements of this paragraph with respect to a month, be treated for such month as ineligible to enroll in a qualified health plan through an exchange. E, waiver for certain special enrollment periods. The Secretary may waive the application of subparagraph A in the case of an individual who enrolls in a qualified health care plan through an exchange for 1 or more months in the taxable year during a special enrollment period provided by the exchange on the basis of a change in the family size of the individual. F, information and reliance on third-party sources. An exchange shall be permitted to use any data available in the exchange and any reliable third-party sources in collecting information for verification by the applicant. 6, exchange compliance with filing requirements. The term coverage month shall not include, with respect to any individual covered by a qualified health plan enrolled in through an exchange, any month for which the exchange does not meet the requirements of Section 155.305F43 of Title 45 Code of Federal Regulations as published in the Federal Registrar on June 25, 2025, 90 FR 27074, applied as though it applied to all plan years after 2025 with respect to the individual. B, pre-enrollment verification, process required. Section 36B(c)(3)A is amended, 1, by striking health plan, the term, and inserting health plan 1, in general, the term, and 2, by adding at the end of the following the new clause, 2, pre-enrollment verification process required. Such term shall not include any plan enrolled in through an exchange unless such exchange provides a process for pre-enrollment verification through which any applicant may, beginning not later than August 1st, verify with the exchange the applicant's household income and eligibility for enrollment in such plan for plans years beginning in the subsequent year. C, regulations. The Secretary of the Treasury and the Secretary of Health and Human Services may each prescribe such rules and other guidance as may be necessary or appropriate to carry out the amendments made by this section. D, effective date. The amendments made by this section shall apply to taxable years beginning after December 31st, 2027. Section 71304, disallowing premium tax credit in case of certain coverage enrolled in during special enrollment period. A, in general, Section 36B(c)(3)A, as amended by the preceding provisions of this Act, is amended by adding at the end the following new clause. 3, exception in case of certain special enrollment periods. Such term shall not include any plan enrolled in during a special enrollment period provided for by an exchange, 1, on the basis of the relationship of the individual's expected household income to such a percentage of the poverty line or such other amount as is prescribed by the Secretary of Human Services for purposes of such period, and 2, not in connection with the occurrence of an event or change in the circumstances specified by the Secretary of Health and Human Services for such purposes. B, regulations. The Secretary of the Treasury and the Secretary of Health and Human Services may each prescribe such rules and other guidance as may be necessary or appropriate to carry out the amendments made by this section. C, effective date. The amendments made by this section shall apply with respect to the plan years beginning after December 31st, 2025. Section 71305, eliminating limitation on recapture of advance payment of premium tax credit. A, in general, Section 36B(f)(2) is amended by striking subparagraph B. B, conforming amendments. 1, Section 36B(f)(2) is amended by striking advance payments and all that follows through if the advance payments and inserting the following: advance payments if the advance payments. 2, Section 35G12B2 is amended by striking then Section 36B(f)(2)B shall be applied by substituting the amount determined under Clause 1 for the amount determined under Section 36B(f)(2)A and inserting then the amount determined under Clause 1 shall be substituted for the amount determined under Section 36B(f)(2). C, special rule for creation in certain individuals treated as applicable taxpayers. Paragraph 1 of Section 36B(c) is amended by adding at the end the new following subparagraph. E, special rule for certain individuals treated as applicable taxpayers. In the case of a taxable year beginning after December 31st, 2025, if an individual, one, is determined by an exchange at the time of enrollment in a qualified health plan through such exchange to have projected annual household income for the taxable year which equals or exceeds 100% of an amount equal to the poverty line for a family of the size involved, and two, receives an advance payment of the credit under the section for 1 or more months during such taxable year under Section 1412 of the Patient Protection and Affordable Care Act, such individual shall not fail to be treated as an applicable taxpayer for such taxable year solely because the actual household income of the individual for the taxable year is less than 100% of an amount equal to the poverty line for a family of the size involved, unless the Secretary determines that the individual provided incorrect information to the exchange with intentional or reckless disregard for the facts. D, effective date. The amendments made by the section shall apply to taxable years beginning after December 31st, 2025.
Subchapter C, Enhancing Choice for Patients. Section 71306, Permanent Extension of Safe Harbor for Absence of Deductible for Telehealth Services. A, in general, subparagraph E of Section 223C2 is amended to read as follows. E, safe harbor for absence of deductible for telehealth. A plan shall not fail to be treated as a high deductible health plan by reason of failing to have a deductible for telehealth and other remote care services. B, certain coverage disregarded. Clause 2 of Section 223C1B is amended by striking in the case of months or plan years to which paragraph 2E applies. C, effective date. The amendments made by this section shall apply to plan years beginning after December 31st, 2024. Section 71307, allowance of bronze and catastrophic plans in connection with health savings accounts. A, in general, Section 223C2 is amended by adding at the end of the following new subparagraph H, bronze and catastrophic plans treated as high deductible health plans. The term high deductible health plan shall include any plan which is 1, available as individual coverage through an exchange established under Section 1311 or 1321 of the Patient Protection and Affordable Care Act, and 2, described in subsection D1A or E of Section 1302 of such act. B, effective date. The amendment made by this section shall apply to months beginning after December 31st, 2025. Section 71308, treatment of direct primary care service arrangements. A, in general, Section 223C1 is amended by adding at the end the following new subparagraph. E, treatment of direct primary care service arrangements. 1, in general, a direct primary care service arrangement shall not be treated as a health plan for purposes of subparagraph A2. 2, direct primary care service arrangement. For purposes of this subparagraph, 1, in general, the term direct primary care service arrangement means, with respect to any individual, an arrangement under which such individual is provided medical care, as defined in Section 213D, consisting solely of primary care services provided by primary care practitioners, as defined in Section 1833X2A of the Social Security Act, determined without regard to Clause 2 thereof, if the sole compensation for such care is a fixed periodic fee. 2, limitation. With respect to any individual for any month, such term shall not include any arrangement if the aggregate fees for all the direct primary care service arrangements determined without regard to this subclause with respect to such individual for such month exceed $150, twice such dollar amount in the case of an individual with any direct primary care service arrangement as so determined that covers more than one individual. 3, certain services specifically excluded from treatment as primary care services. For purposes of this subparagraph, the term primary care services shall not include 1, procedures that require the use of general anesthesia, 2, prescription drugs other than vaccines, and 3, laboratory services not typically administered in an ambulatory primary care setting. The Secretary, after consultation with the Secretary of Health and Human Services, shall issue regulations or other guidance regarding the application of this clause. B, direct primary care service arrangement fees treated as medical expenses. Section 223D2C is amended by striking or at the end of Clause 3, by striking the period at the end of Clause 4 and inserting or, and by adding at the end of the following new clause, 5, any direct primary care service arrangement. C, inflation adjustment. Section 223 G1 is amended. 1, by striking in subsections B2 and C2A and inserting in subsections B2, C2A, and in the case of taxable years beginning after 2026, C1E22. 2, in subparagraph B, by striking clause 2 in clause 1 and inserting clauses 2 and 3, by striking and at the end of clause 1, by striking the period at the end of clause 2 and inserting and by inserting after clause 2 the following new clause. 3, in the case of the dollar amount in subsection C1E22, calendar year 2025, and 3, by inserting C1E22 after B2 in the last sentence. D, effective date. The amendments made by this section shall apply to months beginning after December 31st, 2025. Chapter 4, Protecting Rural Hospitals and Providers. Section 71401, Rural Health Transformation Program. A, in general, Section 2105 of the Social Security Act 42 U.S.C. 1397EE is amended by adding at the end the following new subsection. H, Rural Health Transformation Program. 1, appropriation. A, in general, there are appropriated out of any money in the Treasury not otherwise appropriated to the administrator of the Centers for Medicare and Medicaid Services, in this subsection referred to as the administrator, to provide allotments to states for purposes of carrying out the activities described in paragraph 6. 1, $10 billion for fiscal year 2028. 2, $10 billion for fiscal year 2029. 3, $2 billion for fiscal year 2030. 4, $2 billion for fiscal year 2031. And 5, $1 billion for fiscal year 2032. B, unexpended or unobligated funds. 1, in general, any amounts appropriated under subparagraph A that are unexpected or unobligated as of October 1st, 2034 shall be returned to the Treasury of the United States. 2, redistribution of unexpended or unobligated funds. In carrying out subparagraph A, the administrator shall, not later than March 31st, 2030, and annually thereafter through March 31st, 2034, 1, determine the amount of funds, if any, that are available under such subparagraph for a previous fiscal year are unexpended or unobligated with respect to such fiscal year and will not be available to a state in the current fiscal year pursuant to clause 3. And 2, if the administrator determines that any such funds from a previous fiscal year remain, redistribute such funds in the current fiscal year to states that have an application approved under this subsection for such fiscal year in accordance with an allotment methodology specified by the administrator. 3, availability of funds. 1, in general, amounts allotted to a state under this subsection for a year shall be available for expenditure by the state through the end of the fiscal year following the fiscal year in which such amounts are allotted. 2, availability of amounts redistributed. Amounts redistributed to a state under Clause 2 with respect to a fiscal year shall be available for expenditure by the state through the end of the fiscal year following the fiscal year in which such amounts are redistributed, except in the case of amounts redistributed in fiscal year 2034, which shall only be available for expenditure through September 30th, 2034. 4, misuse of funds. If the administrator determines that a state is not using amounts allotted or redistributed to the state under this subsection in a manner consistent with the description provided by the state in its application approved under paragraph 2, the administrator may withhold payments to, or reduce payments to, or recover previous payments from the state under this subsection as the administrator deems appropriate, and any amounts so withheld or that remain after any such reduction or so recovered shall be returned to the Treasury of the United States. 2, application. A, in general, to be eligible for an allotment under this subsection, a state shall submit to the administrator during an application submission period to be specified by the administrator, but that ends not later than April 1st, 2027, an application in such form and manner as the administrator may specify. That includes 1, a detailed rural health transformation plan developed in consultation with the State Office of Rural Health. 1, to improve access to hospitals, other healthcare providers, and healthcare items and services furnished to rural residents of the state. 2, to improve healthcare outcomes of rural residents of the state. 3, to prioritize the use of new and emerging technologies that emphasize prevention and chronic disease management. 4, to initiate, foster, and strengthen local and regional strategic partnerships between rural hospitals and other healthcare providers in order to promote measurable quality improvement, increase financial stability, maximize economies of scale, and share best practices in care delivery. 5, to enhance economic opportunity for and the supply of healthcare clinicians through enhanced recruitment and training. 6, to prioritize data and technology-driven solutions that help rural hospitals and other rural healthcare providers furnish high-quality healthcare services as close to a patient's home as is possible. 7, that outlines strategies to manage long-term financial solvency and operating models of rural hospitals in the state. And 8, that identifies specific causes driving the accelerating rate of standalone rural hospitals becoming at risk of closure, conversion, or service reduction. 2, a certification that none of the amounts provided under this subsection shall be used by the state for an expenditure that is attributable to an intergovernmental transfer, certified public expenditure, or any other expenditure to finance the non-federal share of expenditures required under any provision of law, including under the state plan established under this title, the state plan established under Title XIX, or under a waiver of such plans, and 3, such other information as the administrator may require. B, deadline for approval. Not later than September 30th, 2027, the administrator shall approve or deny all applications submitted for an allotment under this subsection. C, one-time application. If an application of a state for an allotment under this subsection is approved by the administrator, the state shall be eligible for an allotment under this subsection for each of fiscal years 2028 through 2032, except as provided in paragraph 1B4. D, eligibility. Only the 50 states shall be eligible for an allotment under this subsection, and all references in this subsection to a state shall be treated as only referring to the 50 states. 3, allotments. A, in general, for each of the fiscal years 2028 through 2032, the administrator shall determine under subparagraph B the amount of the allotment for such fiscal year for each state with an approved application under this subsection. B, amount determined. From the amounts appropriated under paragraph 1A for each of fiscal years 2028 through 2032, the administrator shall allot 1, 50% of the amounts appropriated for each such fiscal year equally among all states with an approved application under this subsection, and 2, 50% of the amounts appropriated for each such fiscal year among all such states in an amount to be determined by the administrator in accordance with subparagraph C. C, considerations. In determining the amount to be allotted to a state under subparagraph B2 for a fiscal year, the administrator shall consider the following: the percentage of the state population that is located in a rural census tract of a metropolitan statistical area, as determined under the most recent modification of the Goldsmith modification, originally published in the Federal Register on February 27, 1992, 57 Federal Register 6725. 2, the proportion of rural health facilities as defined in subparagraph D in the state relative to the number of rural health facilities nationwide. 3, the situation of hospitals in the state as described in section 1902A13A4. 4, any other factors that the administrator determines appropriate. D, rural health facility defined. For the purposes of subparagraph C2, the term rural health facility means the following: 1, a subsection D hospital as defined in paragraph 1B of section 1886D, that 1 is located in a rural area as defined in paragraph 2D of such section. 2 is treated as being located in a rural area pursuant to paragraph 8E of such section. Or 3 is located in a rural census tract of a metropolitan statistical area as determined under the most recent modification of the Goldsmith modification, originally published in the Federal Register on February 27, 1992, 57 Federal Register 6725. 2, a critical access hospital as defined in section 1861MM1. 3, a sole community hospital as defined in section 1886D5D3. 4, a Medicare-dependent small rural hospital as defined in section 1886D5G4. 5, a low-volume hospital as defined in section 1886D12C. 6, a rural emergency hospital as defined in section 1861KKK2. 7, a rural health clinic as defined in section 1861AA2. 8, a federally qualified health center as defined in section 1861AA4. 9, a community mental health center as defined in section 1861FF3B. X, a health center that is receiving a grant under section 330 of the Public Health Service Act. 11, an opioid treatment program as defined in section 1861JJJ2 that is located in a rural census tract of a metropolitan statistical area as determined under the most recent modification of the Goldsmith modification, originally published in the Federal Register on February 27, 1992, 57 Federal Register 6725. 12, a certified community behavioral health clinic as defined in section 1905JJ2 that is located in a rural census tract of a metropolitan statistical area as determined under the most recent modification of the Goldsmith modification, originally published in the Federal Register on February 27, 1992, 57 Federal Register 6725. 4, no matching payment. A state approved for an allotment under this subsection for a fiscal year shall not be required to provide any matching funds as a condition for receiving payments from the allotment. 5, terms and conditions. The administrator shall specify such terms and conditions for allotments to states provided under this subsection as the administrator deems appropriate, including the following. A, each state shall submit to the administrator at a time and in a form and manner specified by the administrator, 1, a plan for the state to use its allotment to carry out 3 or more of the activities described in paragraph 6, and 2, annual reports on the use of allotments, including such additional information as the administrator determines appropriate. B, not more than 10% of the amount allotted to a state for a fiscal year may be used by the state for the administrative expenses. C, in the event that a state uses amounts from an allotment to provide payments to healthcare providers in accordance with subparagraph B or J of paragraph 6, the state shall ensure that such amounts are not used to reimburse any expense or loss that 1, has been reimbursed from any other source, or 2, any other source is obligated to reimburse. 6, use of funds. Amounts allotted to a state under this subsection shall be used for 3 or more of the following health-related activities. A, promoting evidence-based, measurable interventions to improve prevention and chronic disease management. B, providing payments to healthcare providers as defined by the administrator for the provision of healthcare items or services as specified by the administrator. C, promoting consumer-facing, technology-driven solutions for the prevention and management of chronic diseases. D, providing training and technical assistance for the development and adoption of technology-enabled solutions that improve care delivery in rural hospitals, including remote monitoring, robotics, artificial intelligence, and other advanced technologies. E, recruiting and retaining clinical workforce talent to rural areas with commitments to serve rural communities for a minimum of 5 years. F, providing technical assistance, software, and hardware for significant information technology advances designed to improve efficiency, enhance cybersecurity capability development, and improve patient health outcomes. Assisting rural communities to right-size their healthcare delivery systems by identifying needed preventative, ambulatory, pre-hospital, emergency, acute inpatient care, outpatient care, and post-acute care service lines.
Pursuant to the order of February 29th, 1960, the hour of 12 noon having arrived, the Senate having been in continuous session since yesterday, the Senate will suspend for a prayer by the Senate chaplain.
Let us pray. Lord of creation, you establish day and night and the orderly movements of the seasons. That same providence orders the lives of our senators, our nation, and our world. As our lawmakers seek to do what is right, give them the wisdom to discern what is best. Show them the pitfalls to avoid and the opportunities to seize. Lord, keep them from becoming weary in their pursuit of your purposes as they remember your promise to bring a bountiful harvest. May they cling to the enduring principles of your truth that will lead them to your desired destination. We pray in your wonderful name. Amen.
The clerk will continue reading.
H, supporting access to opioid use disorder treatment services as defined in section 1861 JJJ1, other substance use disorder treatment services and mental health services. I, developing projects that support innovative models of care that include value-based care arrangements and alternative payment models as appropriate. J, additional uses designed to promote sustainable access to high-quality rural health care services as determined by the administrator. 7, exemptions. Paragraphs 2, 3, 5, 6, 8, 10, 11, and 12 of subsection C do not apply to payments under this subsection. 8, review. There shall be no administrative or judicial review under Section 1116 or otherwise of amounts allotted or redistributed to states under this subsection, payments to states withheld or reduced under this subsection, or previous payments recovered from states under this subsection. B, conforming amendments. Title XXI of the Social Security Act, 42 U.S.C. 1397AA is amended. 1, in Section 2101, A, in subsection A, in the matter of preceding paragraph 1, by striking the purpose and inserting, except with respect to the Rural Health Transformation Program established in Section 2105H, the purpose. And B, in subsection B, in the matter preceding paragraph 1, by inserting subsection A or G of before Section 2105. 2, in Section 2105C1, by striking and may not include and inserting or to carry out the Rural Health Transformation Program established in subsection H, and, except in the case of amounts made available under subsection H, may not include and. 3, in subsection 2106A1, by inserting subsection A or G of before Section 2105. C, implementation. The administrator of the Centers for Medicare and Medicaid Services shall implement this section, including the amendments made by this section, by program instruction or other forms of program guidance. Subtitle C, increase in debt limit. Section 72001, modification of limitation on the public debt. The limitation under Section 3101B of Title 31 United States Code, as most recently increased by Section 401B of Public Law 118.5, 31 U.S.C. 3101 note, is increased by $5 trillion. Title VIII, Committee on Health, Education, Labor, and Pensions, Subtitle A, Exemption of Certain Assets. Section 80001, Exemption of Certain Assets. A, Exemption of Certain Assets. Section 480F2 of the Higher Education Act of 1965, 20 U.S.C. 1087 VV F2 is amended. 1, by striking net value of the and inserting the following, net value of A, the. 2, by striking the period at the end and inserting a semicolon. And 3, by adding at the end the following. B, a family farm on which the family resides. C, a small business with not more than 100 full-time or full-time equivalent employees, or any part of such a small business that is owned and controlled by the family. Or D, a commercial fishing business and related expenses, including fishing vessels and permits owned and controlled by the family. B, effective date and application. The amendments made by subsection A shall take effect on July 1st, 2026, and shall apply with respect to award year 2026 through 2027, and each subsequent award year as determined under the Higher Education Act of 1965, 20 U.S.C. 1001, Subtitle B, Loan Limits. Section 81001, Establishment of loan limits for graduate and professional students and parent borrowers, termination of graduate and professional plus loans. Section 455A of the Higher Education Act of 1965, 20 U.S.C. 1087EA is amended. 1, in paragraph 3A, in the paragraph heading, by inserting and federal direct plus loans after loans, by striking subparagraph A and inserting the following. A, termination of authority to make interest-subsidized loans to graduate and professional students. Subject to subparagraph B and notwithstanding any provision of this part or Part B, 1, for any period of instruction beginning on or after July 1st, 2012, a graduate or professional student shall not be eligible to receive a federal direct Stafford loan under this part. And 2, for any period of instruction beginning on July 1st, 2012 and ending on June 30th, 2026, the maximum annual amount of federal direct unsubsidized Stafford loans such a student may borrow in any academic year, as defined in Section 481A2, or its equivalent shall be the maximum annual amount for such student determined under Section 428H, plus an amount equal to the amount of federal direct Stafford loans the student would have received in the absence of this subparagraph. And C, by adding at the end the following. C, termination of authority to make federal direct plus loans to graduate and professional students. Subject to paragraph 8 and notwithstanding any provision of this part or Part B, for any period of instruction beginning on or after July 1st, 2026, a graduate or professional student shall not be eligible to receive a federal direct plus loan under this part. And 2, by adding at the end the following. 4, graduate and professional annual and aggregate limits for federal direct unsubsidized Stafford loans beginning July 1st, 2026. A, annual limits beginning July 1st, 2026. Subject to paragraphs 7A and 8, beginning on July 1st, 2026, the maximum annual amount of federal direct unsubsidized Stafford loans. 1, a graduate student who is not a professional student may borrow in any academic year or its equivalent shall be $20,500. And 2, a professional student may borrow in any academic year or its equivalent shall be $50,000. B, aggregate limits. Subject to paragraph 6, 7A, and 8, beginning on July 1st, 2026, the maximum aggregate amount of federal direct unsubsidized Stafford loans, in addition to the amount borrowed for undergraduate education that, 1, is a graduate student, 1, who is not and has not been a professional student, may borrow for programs of study described in subparagraph C1, shall be $100,000, or 2, who is or has been a professional student, may borrow for programs of study described in subparagraph C1, shall be an amount equal to AA, $200,000 minus BB, the amount such student borrowed for programs of study described in subparagraph C2, and 2, a professional student, 1, who is not and has not been a graduate student, may borrow for programs of study described in subparagraph C2, shall be $200,000, or 2, who is or has been a graduate student, may borrow for programs of study described in subparagraph C2, shall be an amount equal to AA, $200,000 minus BB, the amount such student borrowed for programs of study described in subparagraph C1. C, definitions. 1, graduate student. The term graduate student means a student enrolled in a program of study that awards a graduate credential, other than a professional degree, upon completion of the program. 2, professional student. In this paragraph, the term professional student means a student enrolled in a program of study that awards a professional degree, as defined under Section 668.2 of Title 34, Code of Federal Regulations, as in effect on the date of enactment of this paragraph, upon completion of the program. 5, parent borrower annual and aggregate limits for federal direct plus loans beginning July 1st, 2026. A, annual limits, subject to paragraph 8 and notwithstanding any provision of this part or part B, beginning on July 1st, 2026, for each dependent student, the total maximum annual amount of federal direct plus loans that may be borrowed on behalf of that dependent student by all parents of that dependent student shall be $20,000. B, aggregate limits, subject to paragraph 8 and notwithstanding any provision of this part or part B, beginning on July 1st, 2026, for each dependent student, the total maximum aggregate amount of federal direct plus loans that may be borrowed on behalf of that dependent student by all parents of that dependent student shall be $65,000, without regard to any amounts repaid, forgiven, canceled, or otherwise discharged on any such loan. 6, lifetime maximum aggregate amount for all students, subject to paragraph 8 and notwithstanding any provision of this part or part B, beginning on July 1st, 2026, the maximum aggregate amount of loans made, insured, or guaranteed under this title that a student may borrow other than a federal direct plus loan or a loan under Section 428B made to the student as a parent borrower on behalf of a dependent student shall be $257,500 without regard to any amounts repaid, forgiven, canceled, or otherwise discharged on any such loan. 7, additional rules regarding annual loan limits. A, less than full-time enrollment, notwithstanding any provision of this part or part B, in any case in which a student is enrolled in a program of study of an institution of higher education on less than a full-time basis during any academic year, the amount of a loan that student may borrow for an academic year or its equivalent shall be reduced in direct proportion to the degree to which that student is not so enrolled on a full-time basis, rounded to the nearest whole percentage point, as provided in a schedule of reductions published by the Secretary, computed for purposes of this subparagraph. B, institutionally determined limits, notwithstanding the annual loan limits established under this section, and for undergraduate students under this part and part B, beginning on July 1st, 2026, an institution of higher education, at the discretion of a financial aid administrator at the institution, may limit the total amount of loans made under this part for a program of study for an academic year that a student may borrow and that a parent may borrow on behalf of such student, as long as any such limit is applied consistently to all students enrolled in such program of study. 8, interim exception for certain students. A, application of prior limits. Paragraphs 3C, 4, 5, and 6 shall not apply, and paragraph 3A2 shall apply as such paragraph was in effect for periods of instruction ending before June 30th, 2026, during the expected time to credential described in subparagraph B, with respect to an individual who, as of June 30th, 2026, 1, is enrolled in a program of study at an institution of higher education, and 2, has received a loan, or on whose behalf a loan was made, under this part for such program of study. B, expected time to credential. For purposes of this paragraph, the expected time to credential of an individual shall be equal to the lesser of 1, 3 academic years, or 2, the period determined by calculating the difference between 1, the program length for the program of study in which the individual is enrolled, and 2, the period of such program of study that such individual has completed as of the date of the determination under this subparagraph. C, definition of program length. In this paragraph, the term program length means the minimum amount of time in weeks, months, or years that is specified in the catalog, marketing materials, or other official publications of an institution of higher education for a full-time student to complete the requirements for a specific program of study. Subtitle C, loan repayment. Section 82001, loan repayment. A, transition to income-based repayment plans. 1, selection. The Secretary of Education shall take such steps as may be necessary to ensure that before July 1st, 2028, each borrower who has one or more loans that are in a repayment status in accordance with or an administrative forbearance as associated with an income contingent repayment plan authorized under Section 455E of the Higher Education Act of 1965, referred to in this subsection as covered income contingent loans, selects one of the following income-based repayment plans that is otherwise applicable, and for which that borrower is otherwise eligible for the repayment of the covered income contingent loans of the borrower. A, the repayment assistant plan under Section 455Q of the Higher Education Act of 1965. B, the income-based repayment plan under Section 493C of the Higher Education Act of 1965. C, any other repayment plan as authorized under Section 455D1 of the Higher Education Act of 1965. 2, commencement of new repayment plan. Beginning on July 1st, 2028, a borrower described in paragraph 1 shall begin repaying the covered income contingent loans of the borrower in accordance with the repayment plan selected under paragraph 1, unless the borrower chooses to begin repaying in accordance with the repayment plan selected under paragraph 1 before such date. 3, failure to select. In the case of a borrower described in paragraph 1 who fails to select a repayment plan in accordance with such paragraph, the Secretary of Education shall A, enroll the covered income contingent loans of such borrower in 1, the repayment assistant plan under Section 455Q of the Higher Education Act of 1965 with respect to loans that are eligible for the repayment assistant plan under such subsection, or 2, the income-based repayment plan under Section 493C of such act with respect to loans that are not eligible for the repayment assistance plan, and B, require the borrower to begin repaying income contingent loans according to the plans under subparagraph A on July 1st, 2028. B, repayment plans. Section 455D of the Higher Education Act of 1965, 20 U.S.C. 1087 ED is amended. 1, in paragraph 1, A, in the matter preceding subparagraph A by inserting before July 1st, 2026, who has not received a loan made under this part or on or after July 1st, 2026, after made under this part. B, in subparagraph D, 1, by inserting before June 30th, 2028, before an income contingent repayment plan, and 2, by striking and after the semicolon. C, in subparagraph E, 1, by striking that enables borrowers who have a partial financial hardship to make a lower monthly payment.
Two, by striking a federal direct consolidation loan if the proceeds of such loan were used to discharge the liability on such federal direct plus loan or a loan under Section 428B made on behalf of a dependent student and inserting an accepted consolidation loan as defined in Section 493C A2 and 3 by striking the period at the end and inserting and D, by adding at the end of the following F, beginning on July 1, 2026, the income-based repayment assistance plan under subsection Q, provided that 1, such plan shall not be available for the repayment of accepted loans as defined in paragraph 7E, and 2, the borrower is required to pay each outstanding loan of the borrower made under this part under such repayment assistance plan, except that a borrower of an accepted loan, as defined in paragraph 7E, may repay the accepted loan separately from other loans under this part obtained by the borrower. 2, in paragraph 5, by amending subparagraph B to read as follows. B, repay the loan pursuant to an income-based repayment plan under subsection Q or section 493C as applicable. And 3, by adding at the end of the following 6, termination and limitation of repayment authority. A, sunset of repayment plans available before July 1, 2026. Paragraphs 1 through 4 of this subsection shall only apply to loans made under this part before July 1, 2026. B, prohibitions. The Secretary may not, for any loan made under this part on or after July 1, 2026, 1, authorize the borrower of such a loan to repay such loan pursuant to a repayment plan that is not described in paragraph 7A, or 2, carry out or modify a repayment plan that is not described in such paragraph. 7, repayment plans for loans made on or after July 1, 2026, A, design and selection. Beginning on July 1st, 2026, the Secretary shall offer a borrower of a loan made under this part on or after such date, including such a borrower who also has a loan made under this part before such date, 2 plans for repayment of the borrower's loans under this part, including principal and interest on such loans. The borrower shall be entitled to accelerate without penalty repayment on such loans. The borrower may choose 1, a standard repayment plan, 1, with a fixed monthly repayment amount paid over a fixed period of time equal to the applicable period determined under subclause 2, and 2, with the applicable period of time for repayment determined based on the total outstanding principal of all loans of the borrower made under this part before, on or after July 1, 2026, at the time the borrower is entering repayment under such plan as follows. AA, for a borrower with total outstanding principal of less than $25,000, a period of 10 years. BB, for a borrower with total outstanding principal of not less than $25,000 and less than $50,000, a period of 15 years. CC, for a borrower with total outstanding principal of not less than $50,000 and less than $100,000, a period of 20 years, and DD, for a borrower with total outstanding principal of $100,000 or more, a period of 25 years, or 2, the income-based repayment assistance plan under subsection Q. B, selection by Secretary. If a borrower of a loan made under this part on or after July 1, 2026 does not select a repayment plan described in subparagraph A, the Secretary shall provide the borrower with the standard repayment plan described in subparagraph A1. C, selection applies to all outstanding loans. A borrower is required to pay each outstanding loan of the borrower made under this part under the same selected repayment plan, except that a borrower who selects the repayment assistance plan and also has an accepted loan that is not eligible for repayment under such repayment assistance plan shall repay the accepted loan separately from other loans under this part obtained by the borrower. D, changes of repayment plan. A borrower may change the borrower's selection of 1, the standard repayment plan under subparagraph 4.1, or the Secretary's selection of such plan for the borrower under subparagraph B, as the case may be, to the repayment assistance plan under subparagraph A2 at any time. 2, the repayment assistance plan under subparagraph A2 to the standard repayment plan under subparagraph A1 at any time. Repayment for E, repayment for borrowers with accepted loans made on or after July 1, 2026. 1, standard repayment plan required, notwithstanding paragraphs A through D, beginning on July 1, 2026, the Secretary shall require a borrower who has received an accepted loan made on or after such date, including such a borrower who also has an accepted loan made before such date, to repay each accepted loan, including principal and interest on those accepted loans under the standard repayment plan under subparagraph A1. The borrower shall be entitled to accelerate without penalty repayment on such loans. 2, accepted loan defined. For the purposes of this paragraph, the term accepted loan means a loan with an outstanding balance that is 1, a federal direct plus loan that is made on behalf of a dependent student, or 2, a federal direct consolidation loan if the proceeds of such loan were used to discharge the liability on AA, an accepted plus loan as defined in section 493CA1, or BB, an accepted consolidation loan as such term is defined in section 493CA2A, notwithstanding subparagraph B of each section. C, elimination of authority to provide income contingent repayment plans. 1, repeal section E of Section 455 of the Higher Education Act of 1965, 20 U.S.C. 1087 EE is repealed. 2, further amendments to eliminate income contingent repayment. A, Section 428 of the Higher Education Act of 1965, 20 U.S.C. 1078 is amended. 1, in subsection B, 1D, by striking B subject to income contingent repayment in accordance with subsection M, and inserting B subject to income-based repayment in accordance with subsection M, and 2, in subsection M. 1, in the subsection heading by striking income contingent, and 2, by amending paragraph 1 to read as follows. 1, authority of secretary to require the secretary may require borrowers who have defaulted on loans made under this part that are assigned to the secretary under subsection C8 to repay those loans pursuant to an income-based repayment plan under section 493C, and 3, in the heading of paragraph 2, by striking income contingent, or B, section 28C of the Higher Education Act of 1965, 20 U.S.C. 1078-3 is amended. 1, in subsection A3B1 5AA, by striking for the purposes of obtaining income contingent repayment or income-based repayment, and inserting for the purposes of qualifying for an income-based repayment plan under section 455Q or section 493C as applicable. 2, in subsection B5, by striking be repaid either pursuant to income contingent repayment under Part D of this title, pursuant to income-based repayment under section 493C, or pursuant to any other repayment provision under this section, and inserting be repaid pursuant to an income-based repayment plan under section 493C or any other repayment provision under this section. And 3, in subsection C, 1, in paragraph 2A, by striking or by the terms of repayment pursuant to income contingent repayment offered by the secretary under subsection B5, and inserting or by the terms of repayment pursuant to an income-based repayment plan under section 493C. And 2, in paragraph 3B, by striking except as required by the terms of repayment pursuant to income contingent repayment offered by the secretary under subsection B5, and inserting except as required by the terms of repayment pursuant to an income-based repayment plan under section 493C. C, section 485D1 of the Higher Education Act of 1965, 20 U.S.C. 1092D1 is amended by striking income contingent, and D, section 494A2 of the Higher Education Act of 1965, 20 U.S.C. 1098HA2 is amended. 1, in the paragraph heading by striking income contingent and income-based and inserting income-based, and 2, in subparagraph A, 1, in the matter preceding clause 1, by striking income contingent or, and 2, in clause 2.1, by striking section 455E8 or the equivalent procedures established under section 493C 2B as applicable, and inserting section 493C2. 3, effective date. The amendments may be made by this section shall take effect on July 1, 2028. D, repayment assistance plan, section 455 of the Higher Education Act of 1965, 20 U.S.C. 1087E is amended by adding at the end of the following new subsection Q, repayment assistance plan. 1, in general, notwithstanding any other provision of this act beginning on July 1, 2026, the Secretary shall carry out an income-based repayment plan to be known as the repayment assistance plan that shall have the following terms and conditions. A, the total monthly repayment plan amount owed by a borrower for all of the loans of the borrower that are repaid pursuant to the repayment assistance plan shall be equal to the applicable monthly payment of a borrower calculated under paragraph 4B, except that the borrower may not be precluded from repaying an amount that exceeds such amount for any month. B, the Secretary shall apply the borrower's applicable monthly payment under this paragraph paragraph, first toward interest due on each such loan, next toward any fees due on each loan, and then toward the principal of each loan. C, any principal due and not paid under subparagraph B or paragraph 2B shall be deferred. D, a borrower who is not in a period of deferment or forbearance shall make an applicable monthly payment for each month until the earlier of 1, the date on which the outstanding balance of principal and interest due on all of the loans of the borrower that are repaid pursuant to the repayment assistance plan is $0, or 2, the date on which the borrower has made 360 qualifying monthly payments. E, the Secretary shall cancel any outstanding balance of principal and interest due on a loan made under this part to a borrower. 1, who for any period of time participated in the repayment assistance plan under this subsection. 2, whose most recent payment for such loan prior to the loan cancellation under this subparagraph was made under such repayment assistance plan. And 3, who has made 360 qualifying monthly payments on such loan. F, for the purposes of this subsection, the term qualifying monthly payment means any of the following. 1, an on-time applicable monthly payment under this subsection. 2, an on-time monthly payment under the standard repayment plan under subsection D7A1 of not less than the monthly payment required under such plan. 3, a monthly payment under any repayment plan, excluding the repayment assistance plan under the subsection of not less than the monthly payment that would be required under a standard repayment plan under Section 455D1A with a repayment period of 10 years. 4, a monthly payment under Section 493C of not less than the monthly payment required under such section, including a monthly payment equal to the minimum payment amount permitted under such section. 5, a monthly payment made before July 1, 2028 under an income contingent repayment plan carried out under Section 455D1D or under an alternative repayment plan in lieu of repayment under such an income contingent repayment plan, if placed in such an alternative repayment plan by the Secretary, of not less than the monthly payment required under such a plan, including a monthly payment equal to the minimum payment amount permitted under such a plan. 6, a month when the borrower did not make a payment because the borrower was in deferment under subsection F2B or due to an economic hardship described in subsection F2D. 7, a month that ended before the date of enactment of the subsection when the borrower did not make a payment because the borrower was in a period of deferment or forbearance described in section 685-209K44 of Title 34 Code of Federal Regulations as in effect on the date of enactment of this subsection. G, the procedures established by the Secretary under section 493CC shall apply for annually determining the borrower's eligibility for the repayment assistance plan, including verification of a borrower's annual income and the annual amount due on the total amount of loans eligible to be repaid under this subsection, and such other procedures as are necessary to effectively implement income-based repayment under this subsection. With respect to carrying out section 494A2, for the repayment assistance plan, an individual may elect to opt out of the disclosures required under section 491A2A2 in accordance with the procedures established under section 493C2. 2, balance assistance for distressed borrowers. A, interest subsidy with respect to a borrower of a loan made under this part for each month for which such a borrower makes an on-time applicable monthly payment required under paragraph 1A, and such monthly payment is insufficient to pay the total amount of interest that accrues for the month on all loans of the borrower repaid pursuant to the repayment assistance plan under this subsection. The amount of interest accrued and not paid for the month shall not be charged to the borrower. B, matching principal payment. With respect to a borrower of a loan made under this part and not in a period of deferment or forbearance, for each month for which a borrower makes an on-time applicable monthly payment required under paragraph 1A, and such monthly payment reduces the total outstanding principal balance of all loans of the borrower repaid pursuant to the repayment assistance plan under this subsection by less than $50, the Secretary shall reduce such outstanding principal balance of the borrower by an amount that is equal to one, the amount that is the lesser of one, $50, or two, the total amount paid by the borrower for such month pursuant to paragraph 1A, minus two, the total amount paid by the borrower for such month pursuant to paragraph 1A that is applied to such total outstanding principal balance. 3, additional documents. A borrower who chooses or is required to repay a loan under the subsection and for whom adjusted gross income is unavailable or does not reasonably reflect the borrower's current income shall provide to the Secretary other documentation of income satisfactory to the Secretary, which documentation the Secretary may use to determine repayment under this subsection. 4, definitions. In this subsection, A, adjusted gross income. The term adjusted gross income, when used with respect to a borrower, means the adjusted gross income as such term is defined in Section 62 of the Internal Revenue Code of 1986 of the borrower and the borrower's spouse as applicable for the most recent taxable year, except that in the case of a married borrower who files a separate federal income tax return, the term does not include the adjusted gross income of the borrower's spouse. B, applicable monthly payment. 1, in general, except as provided in clause 2, 3, or 6, the term applicable monthly payment means, when used with respect to a borrower, the amount equal to 1, the applicable base payment of the borrower divided by 12 minus 2, $50 for each dependent of the borrower, which in the case of a married borrower filing a separate federal income tax return shall include only each dependent that the borrower claims on that return. 2, minimum amount. In the case of a borrower with an applicable monthly payment amount calculated under Clause 1 that is less than $10, the applicable monthly payment of the borrower shall be $10. 3, final payment. In the case of a borrower whose total outstanding balance of principal and interest on all of the loans of the borrower that are repaid pursuant to the repayment assistance plan is less than the applicable monthly payment calculated pursuant to Clause 1 or 2 as applicable, then the applicable monthly payment of the borrower shall be the total outstanding balance of principal and interest on all such loans. 4, base payment. The amount of the applicable base payment for a borrower with an adjusted gross income of 1, not more than $10,000 is $120. 2, more than $10,000 and not more than $20,000 is 1% of such adjusted gross income. 3, more than $20,000 and not more than $30,000 is 2% of such adjusted gross income. 4, more than $30,000 and not more than $40,000 is 3% of such adjusted gross income. 5, more than $40,000 and not more than $50,000 is 4% of such adjusted gross income. 6, more than the $50,000 and not more than $60,000 is 5% of such adjusted gross income. 7, more than $60 and not more than $70 is 6% of such adjusted gross income. 8, more than $70,000 and not more than $80,000 is 7% of such a gross adjusted income. 9, more than $80,000 and not more than $90,000 is 8% of such adjusted gross income. 10, more than $90,000 and not more than $100,000 is 9% of such adjusted gross income, and 11, more than $100,000 is 10% of such adjusted gross income. 5, dependent. For the purposes of this paragraph, the term dependent means an individual who is a dependent under Section 152 of the Internal Revenue Code of 1986. 6, special rule. In the case of a borrower who is required by the Secretary to provide information to the Secretary to determine the applicable monthly payment of the borrower under this subparagraph and who does not comply with such requirement, the applicable monthly payment of the borrower shall be 1, the sum of the monthly payment amounts the borrower would have paid for each of the borrower's loans made under this part under a standard repayment plan with a fixed monthly repayment amount paid over a period of 10 years based on the outstanding principal due on such loan when such loan entered repayment, and 2, determined pursuant to this clause until the date on which the borrower provides such information to the Secretary. E, federal consolidation loans. Section 455G of the Higher Education Act of 1965, 20 U.S.C. 1087 EG is amended by adding at the end of the following new paragraph 3, consolidation loans made on or after July 1, 2026, a federal direct consolidation loan offered to a borrower under this part on or after July 1, 2026 may only be repaid pursuant to a repayment plan described in clause 1 or 2 of subsection D7A of this section as applicable, and the repayment schedule of such a consolidation loan shall be determined in accordance with such repayment plan. F, income-based repayment. 1, amendments. A, accepted consolidation loan defined. Section 493C(a)(2) of the Higher Education Act of 1965, 20 U.S.C. 1098 E(a)(2) is amended to read as follows. 2, accepted consolidation loan. A, in general, the term accepted consolidation loan means 1, a consolidation loan under Section 428C or a federal direct consolidation loan if the proceeds of such loan were used to discharge the liability on an accepted plus loan, or 2, a consolidation loan under Section 428C or a federal direct consolidation loan if the proceeds of such loan were used to discharge the liability on a consolidation loan under Section 428C or a federal direct consolidation loan described in Clause 1. B, exclusion. The term accepted consolidation loan does not include a federal direct consolidation loan described in paragraph A, in subparagraph A, that on any date during the period beginning on the date of enactment of the subparagraph and ending on June 30th, 2028 was being repaid. 1, pursuant to the income contingent repayment ICR plan in accordance with section 685-209B of Title 34 Code of Federal Regulations as in effect on June 30, 2023, or 2, pursuant to another income-driven repayment plan. B, termination of partial financial hardship eligibility, section 493C(a)(3) of the Higher Education Act of 1965, 20 U.S.C. 1098 E(a)(3) is amended to read as follows. 3, applicable amount. The term applicable amount means 15% of the result obtained by calculating on at least an annual basis the amount by which A, the borrower's and the borrower's spouse, if applicable, adjusted gross income exceeds B, 150% of the poverty line, applicable to the borrower's family size as determined under Section 673(2) of the Community Services Block Grant Act 42 U.S.C. 99022. C, terms of income-based repayment, Section 493CB of the Higher Education Act of 1965, 20 U.S.C. 1098 EB is amended. 1, by amending paragraph 1 to read as follows. 1, a borrower of any loan made, insured, or guaranteed under Part B or D other than accepted plus loan or accepted consolidation loan may elect to have the borrower's aggregate monthly payment for all such loans not exceed the applicable amount divided by 12. 2, by striking paragraph 6 and inserting the following. 6, if the monthly payment amount calculated under this section for all loans made to the borrower under Part B or D other than an accepted plus loan or accepted consolidation loan exceeds the monthly amount calculated under Section 428B9A1 or 455D1A based on a 10-year repayment period when the borrower first made the election described in this subsection, referred to in this paragraph as the standard monthly repayment amount, or if the borrower no longer wishes to continue the election under this subsection, then A, the maximum monthly payment required to be paid for all loans made to the borrower under Part B or D other than an accepted plus loan or accepted consolidation loan shall be the standard monthly repayment amount, and B, the amount of time the borrower is permitted to repay such loans may exceed 10 years. 3, in paragraph 7B4, by inserting, as such section was in effect on the day before the date of the repeal of section 455E, after section 455D, 1D, and 4 in paragraph 8, by inserting or the repayment assistance program under section 455Q after standard repayment plan. D, eligibility determinations, section 493CC of the Higher Education Act of 1965, 20 U.S.C. 1098 EC is amended to read as follows. C, eligibility determinations, automatic certification. 1, in general, the Secretary shall establish procedures for annually determining, in accordance with paragraph 2, the borrower's eligibility for income-based repayment, including the verification of a borrower's annual income and the annual amount due on the total amount of loans made, insured, or guaranteed under Part B or D, other than an accepted plus loan or accepted consolidation loan, and such other procedures as are necessary to effectively implement income-based repayment under this section. The Secretary shall consider, but is not limited to, the procedures established in accordance with section 455E1 as in effect on the day before the date of repeal of subsection E of section 455 or in connection with income-sensitive repayment schedules under section 428B9A3 or 428CB1E. 2, automatic recertification. A, in general, the Secretary shall establish and implement with respect to any borrower enrolled in an income-based repayment program under this section or under section 455Q procedures to 1, use return information disclosed under section 6103.113 of the Internal Revenue Code of 1986 pursuant to approval provided under section 494 to determine for repayment obligation of the borrower without further action by the borrower. 2, allow the borrower or the spouse of the borrower at any time to opt out of disclosure under such section 6103.113 and instead provide such information as the Secretary may require to determine the repayment obligation of the borrower or withdraw from the repayment plan under this section or under section 455Q as the case may be. And, okay, right there.
3, provide the borrower with an opportunity to update the return information so disclosed before the determination of the repayment obligation of the borrower. B, applicability. Subparagraph A shall apply to each borrower of a loan eligible to be repaid under this section or under section 455Q who, on or after the date on which the Secretary establishes procedures under such subparagraph A, 1, selects or is required to repay such loan pursuant to an income-based repayment plan under this section or under section 455Q, or 2, recertifies income or family size under such plan. E, special terms for new borrowers on and after July 1, 2014. Section 493CE of the Higher Education Act of 1965, 20 U.S.C. 1098EE is amended 1 in the subsection heading by inserting and before July 1, 2026 after July 1, 2014, and 2 by inserting and before July 1, 2026 after July 1, 2014. 2, effective date and application. The amendments made by this subsection shall take effect on the date of enactment of this title and shall apply with respect to any borrower who is in repayment before, on, or after the date of enactment of this title. G, FFEL adjustment, section 428B9AV of the Higher Education Act of 1965, 20 U.S.C. 1078B9AV is amended by striking who has a partial financial hardship. Section 82002, deferment forbearance. A, sunset of economic hardship and unemployment deferments, Section 455F of the Higher Education Act of 1965, 20 U.S.C. 1087EF is amended, 1, by striking the subsection heading and inserting the following: deferment forbearance. 2, in paragraph 2, A and subparagraph B, by striking not in and inserting subject to paragraph 7, not in, and B in subparagraph D by striking not in and inserting subject to paragraph 7, not in, and 3 by adding at the end the following. 7, sunset of unemployment and economic hardship deferments. A borrower who receives a loan made under this part on or after July 1, 2027 shall not be eligible to defer such loan under subparagraph B or D of paragraph 2. B, forbearance on loans made under this part on or after July 1, 2027, Section 455F of the Higher Education Act of 1965, 20 U.S.C. 1087EF, is amended by adding at the end the following. 8, forbearance of loans made under this part on or after July 1, 2027. A borrower who receives a loan made under this part on or after July 1, 2027 may only be eligible for a forbearance on such loan pursuant to Section 428C3B that does not exceed 9 months during any 24-month period. Section 82003, loan rehabilitation. A, updating loan rehabilitation limits. 1, FFEL and direct loans, Section 428FA5 of the Higher Education Act of 1965, 20 U.S.C. 1078-6A5 is amended by striking 1 time and inserting 2 times. 2, Perkins loans, Section 464H1D of the Higher Education Act of 1965, 20 U.S.C. 1087DDH1D is amended by striking once and inserting twice. 3, effective date. The amendments made by this subsection shall take effect beginning on July 1, 2027, and shall apply with respect to any loan made, insured, or guaranteed under Title IV of the Higher Education Act of 1965, 20 U.S.C. 1070 B, minimum monthly payment amount. Section 428FA1B of the Higher Education Act of 1965, 20 U.S.C. 1078-6A1B is amended by adding at the end the following. With respect to a borrower who has 1 or more loans made under Part D on or after July 1, 2027 that are described in subparagraph A, the total monthly payment of the borrower for all such loans shall not be less than $10. Section A2004, public service loan forgiveness. Section 455M1A of the Higher Education Act of 1965, 20 U.S.C. 1087EM1A is amended, 1, in Clause 3 by striking or and inserting a semicolon. 2, in Clause 4 by striking and inserting as in effect on the day before the date of the repeal of subsection E of this section, or, and 3, by adding at the end of the following new clause. 5, one-time payments under the repayment assistance plan under subsection Q, and Section 82005, student loan servicing. Paragraph 1 of Section 458A of the Higher Education Act of 1965, 20 U.S.C. 1087HA1 is amended to read as follows. 1, additional mandatory funds for servicing. There shall be available to the Secretary, in addition to any other amounts appropriated under the Appropriations Act for administrative costs under this part and Part B, and out of any money in the Treasury not otherwise appropriated, $1 billion to be obligated for administrative costs under this part and Part B, including the cost of servicing the direct loan student loan programs under this part, which shall remain available until expended. Subtitle D, Pell Grants. Section 83001, Eligibility. Foreign income and federal Pell Grant eligibility. 1, adjusted gross income defined. Section 401A2A of the Higher Education Act of 1965, 20 U.S.C. 1070AA2A is amended to read as follows. A, the term adjusted gross income means 1, in the case of a dependent student for the second tax year preceding the academic year, 1, the adjusted gross income as defined in Section 62 of the Internal Revenue Code of 1986 of the student's parents, plus 2, for federal Pell Grant determinations made for academic years beginning on or after July 1, 2026, the foreign income as described in Section 480B5 of the student's parents, and 2, in the case of an independent student for the second tax year preceding the academic year, 1, the adjusted gross income as defined in Section 62 of the Internal Revenue Code of 1986 of the student and the student's spouse, if applicable, plus 2 for federal Pell Grant determinations made for academic years beginning on or after July 1, 2026. The foreign income as described in Section 480B5 of the student and the student's spouse if applicable. 2, sunset Section 401B1D of the Higher Education Act of 1965, 20 U.S.C. 1070A-B1D is amended A, by striking a student and inserting for each academic year beginning before July 1, 2026, a student, and B, by inserting as in effect for such academic year after Section 479A-B1B-V. 3, conforming amendments. A, in general, Section 479A-B1B of the Higher Education Act of 1965, 20 U.S.C. 1087 TTB1B is amended, 1, by striking Clause 5, and 2, by redesignating Clauses 6 and 7 as Clauses 5 and 6, respectively. B, effective date. This amendment made by subparagraph A shall take effect on July 1, 2026. B, federal Pell Grant ineligibility due to a high student aid index. 1, in general, Section 401B1 of the Higher Education Act of 1965, 20 U.S.C. 1070A-B1 is amended by adding at the end the following. F, ineligibility of students with a high student aid index. Notwithstanding subparagraphs A through E, a student shall not be eligible for a federal Pell Grant under this subsection for an academic year in which the student has a student aid index that equals or exceeds twice the amount of the total maximum federal Pell Grant for such academic year. 2, effective date. The amendment made by paragraph 1 shall take effect on July 1, 2026. Section 83002, Workforce Pell Grants. A, in general, Section 401 of the Higher Education Act of 1965, 20 U.S.C. 1070A is amended by adding at the end the following. K, Workforce Pell Grant Program. 1, in general, for the award year beginning on July 1, 2026, and each subsequent award year, the Secretary shall award grants to be known as Workforce Pell Grants to eligible students under paragraph 2 in accordance with this subsection. 2, eligible students. To be eligible to receive a Workforce Pell Grant under this subsection for any period of enrollment, a student shall meet the eligibility requirements for a federal Pell Grant under this section except that the student A shall be enrolled or accepted for enrollment in an eligible program under Section 481B3 hereinafter referred to as an ineligible workforce program, and B, may not, 1, be enrolled or accepted for enrollment in a program of study that leads to a graduate credential, or 2, have attained such a credential. 3, terms and conditions of awards. The Secretary shall award Workforce Pell Grants under this subsection in the same manner and with the same terms and conditions as the Secretary awards federal Pell Grants under this section, except that A, each use of the term eligible program, except in subsection B9A, shall be substituted by eligible workforce program under Section 481B3. B, the provisions of subsection D3 shall not be applicable to eligible workforce programs. And C, a student who is eligible for a grant equal to or less than the amount of the minimum federal Pell Grant because of the eligible workforce program in which the student is enrolled or accepted for enrollment is less than an academic year in hours of instructions or weeks of duration may still be eligible for a Workforce Pell Grant in an amount that is prorated based on the length of the program. 4, prevention of double benefits. No eligible student described in paragraph 2 may concurrently receive a grant under both this subsection and A, subsection B, or B, subsection C. 5, duration limit. Any period of study covered by a Workforce Pell Grant awarded under this subsection may be included in determining a student's duration limit under subsection D5. Program eligibility for Workforce Pell Grants. Section 481B of the Higher Education Act of 1965, 20 U.S.C. 1088B is amended, 1, by redesignating paragraphs 3 and 4 as paragraphs 4 and 5 respectively, and 2, by inserting after paragraph 2 the following. 3A, a program is an eligible program for purposes of the Workforce Pell Grant Program under Section 401K only if, 1, it is a program of at least 150 clock hours of instruction but less than 600 clock hours of instruction, or an equivalent number of credit hours offered by an eligible institution during a minimum of 8 weeks, but less than 15 weeks. 2, it is not offered as a correspondence course as defined in 600.2 of Title 34 Code of Federal Regulations as in effect on July 1, 2021. 3, the governor of a state, after consultation with the state board, determines that the program 1 provides an education aligned with the requirements of high skill, high wage as identified by the state pursuant to Section 122 of the Carl D. Perkins Career and Technical Education Act, 20 U.S.C. 2342, or in-demand industry sectors or occupations. 2, meets the hiring requirements of potential employers in the sectors or occupations described in subclause 1. 3, either AA, leads to a recognized post-secondary credential that is stackable and portable across more than one employer, or BB, with respect to students enrolled in the program. AA, prepares such students for employment in an occupation for which there is only one recognized post-secondary credential, and BB requires such students with such a credential upon completion of such program. And 4, prepares students to pursue one or more certificate or degree programs at one or more institutions of higher education, which may include the eligible institution providing the program, including by ensuring AA that a student upon completion of the program and enrollment in such a related certificate or degree program will receive academic credit for the workforce Pell program that will be accepted toward meeting such certificate or degree program requirements, and BB, the acceptability of such credit toward meeting such certificate or degree program requirements, and 4, after the governor of such state makes the determination that the program meets the requirements under Clause 3, the Secretary determines that 1, the program has been offered by the eligible institution for not less than 1 year prior to the date on which the Secretary makes the determination under this clause. 2, for each award year, the program has a verified completion rate of at least 70% with 150% of the normal time for completion. 3, for each award year, the program has a verified job placement rate of at least 70% measured 180 days after completion. And 4, for each award year, the total amount of the published tuition and fees of the program for such year is an amount that does not exceed the value-added earnings of students who received federal financial aid under this title and who completed the program 3 years prior to the award year. As such earnings are determined by calculating the difference between AA, the median earnings of such students as adjusted by the state and metropolitan area regional price parities of the Bureau of Economic Analysis based on the location of such program, and BB, 150% of the poverty line applicable to a single individual as determined under Section 6732 of the Community Services Block Grant Act, 42 U.S.C. 99022 for such year. B, in this paragraph 1, the term eligible institution means an eligible institution for purposes of Section 401. 2, the term governor means the chief executive of the state. 3, the terms in-demand industry sector or occupation, recognized post-secondary credential, and state board have the meanings given such terms in Section 3 of the Workforce Innovation and Opportunity Act. C, effective date, applicability. The amendments made by this section shall take effect on July 1, 2026, and shall apply with respect to award year 2026 through 2027 and each succeeding award year. Section 83003, Pell shortfall. Section 401B7A3 of the Higher Education Act of 1965, 20 U.S.C. 1070A B7A3 is amended by striking $2,170,000,000 and inserting $12,670,000,000. Section 83004, Federal Pell Grant exclusion relating to other grant aid. Section 401D of the Higher Education Act of 1965, 20 U.S.C. 1070AD is amended by adding at the end the following. 6, exclusion. Beginning on July 1, 2026, and notwithstanding this subsection or subsection B, a student shall not be eligible for a federal Pell Grant under subsection B during any period for which the student receives grant aid from non-federal sources, including states, institutions of higher education, or private sources, in an amount that equals or exceeds the student's cost of attendance for such period. Subtitle E, accountability, Section 84001, ineligibility based on low earning outcomes. Section 454 of the Higher Education Act of 1965, 20 U.S.C. 1087D is amended 1 in subsection A, in paragraph 5 by striking and after the semicolon, B, by redesignating paragraph 6 as paragraph 7, and C, by inserting after paragraph 5 the following. 6, provide assurances that beginning on July 1, 2026, the institution will comply with all requirements of subsection C, and 2 in subsection B2 by striking and 6 and inserting 6 and 7. 3, by redesignating subsection C as subsection D, and 4 by inserting after subsection B the following. C, ineligibility for certain programs based on low earning outcomes. 1, in general, notwithstanding section 481B, an institution of higher education subject to this subsection shall not use funds under this part for student enrollment in an educational program offered by the institution that is described in paragraph 2. 2, low-earning outcome programs described. An educational program at an institution is described in this paragraph if the program awards an undergraduate degree, graduate or professional degree, or graduate certificate for which the median earnings, as determined by the Secretary of the programmatic cohort of students who received funds under this title for enrollment in such program, who completed such program during the academic year that is 4 years before the year of the determination, who are not enrolled in any institutions of higher education and who are working, are for not less than 2 or 3 years of the 3 years immediately preceding the date of the determination, less than the median earnings of a working adult described in paragraph 3 for the corresponding year. 3, calculation of median earnings. A, working adult. For purposes of applying paragraph 2 to an educational program at an institution, a working adult described in this paragraph is a working adult who, for the corresponding year, 1, is aged 25 to 34, 2, is not enrolled in an institution of higher education, and 3, 1, in the case of a determination made for an educational program that awards a baccalaureate or lesser degree, has only a high school diploma or its recognized equivalent, or 2, in the case of a determination made for a graduate or professional program, has only a baccalaureate degree. B, source of data. For purposes of applying paragraph 2 to an educational program at an institution, the median earnings of a working adult as described in subparagraph A shall be based on data from the Bureau of the Census, 1, with respect to an educational program that awards a baccalaureate or lesser degree, 1, for the state in which the institution is located, or 2, if fewer than 50% of the students enrolled in the institution reside in the state where the institution is located for the entire United States, and 2, with respect to an educational program that is a graduate or professional program, 1, for the lowest median earnings of AA, a working adult in the state in which the institution is located, BB, a working adult in the same field of study as determined by the Secretary, such as by using the 2-digit CIP code in the state in which the institution is located, and CC, a working adult in the same field of study as so determined in the entire United States, or 2, if fewer than 50% of the students enrolled in the institution reside in the state where the institution is located for the lower median earnings of AA, or working adult in the entire United States, or BB, a working adult in the same field of study as so determined in the entire United States. 4, small programmatic cohorts. For any year in which the programmatic cohort described in paragraph 2 for an educational program of an institution is fewer than 30 individuals, the Secretary shall A, first, aggregate additional years of programmatic data in order to achieve a cohort of at least 30 individuals, and B, second, in cases in which the cohort, including the individuals added under subparagraph A, is still fewer than 30 individuals, aggregate additional cohort years of programmatic data for educational programs of equivalent length in order to achieve a cohort of at least 30 individuals. 5, appeals process. An educational program shall not lose eligibility under this subsection unless the institution has had the opportunity to appeal the programmatic median earnings of students working and not enrolled determination under paragraph 2 through a process established by the Secretary. During such appeal, the Secretary may permit the educational program to continue to participate in the program under this part. 6, notice to students. A, in general, if an educational program of an institution of higher education subject to this subsection does not meet the cohort median earnings requirements as described in paragraph 2 for 1 year during the applicable covered period, but has not yet failed to meet such requirements for 2 years during such covered period, the institution shall promptly inform each student enrolled in the educational program of the eligible program's low cohort meeting earnings, and that the educational program is at risk of losing its eligibility for funds under this part. B, covered period. In this paragraph, the term covered period means the period of the 3 years immediately preceding the date of a determination made under paragraph 2. 7, regaining programmatic eligibility. The Secretary shall establish a process by which an institution of higher education has an educational program that has lost eligibility under this subsection may, after a period of not less than 2 years of such program's ineligibility, apply to regain such eligibility subject to the requirements established by the Secretary that further the purpose of this subsection. Subtitle F, regulatory relief. Section 85001, delay of the rule relating to borrower defense to repayment. A, delay. Beginning at the date of enactment of this section for loans that first originated before July 1, 2035, the provisions of Subpart D of Part 685 of Title 34 Code of Federal Regulations relating to borrower defense to repayment, as added or amended by the final regulations published by the Department of Education on November 1, 2022, entitled Institutional Eligibility under the Higher Education Act of 1965 as amended, Student Assistance General Provisions, Federal Perkins Loan Programs, Federal Family Education Loan Programs, and William D. Ford Federal Loan Program, 87 Fed Reg 65904 shall not be in effect. B, effect. Beginning on the date of enactment of this section with respect to loans that first originate before July 1, 2035, any regulations relating to borrower defense to repayment that took effect on July 1, 2020 are restored and revived as such regulations were in effect on such date. Section 85002, delay of ruling related to closed school discharges. A, delay. Beginning on the date of enactment of this section, for loans that first originate before July 1, 2035, the provisions of sections 674.33G, 682.402D, and 685.214 of Title 34 Code of Federal Regulations related to closed school discharges as added or amended by the federal regulations published by the Department of Education on November 1, 2022, entitled Institutional Eligibility under the Higher Education Act of 1965 as amended, Student Assistance General Provisions, Federal Perkins Loan Program, Federal Family Education Loan Program, and William D. Ford Federal Loan Direct Loan Program, 87 Fed Reg 65904 shall not be in effect. B, effect. Beginning on the date of enactment of this section with respect to loans that first originate before July 1, 2035, the portions of the Code of Federal Regulations described in subsection A and amended by the final regulations described in subsection A shall be in effect as of if the amendments made by such federal regulations had not been made. Subtitle G, limitation on authority. Section 86001, limitation on proposing or issuing regulations and executive actions. Part G of Title IV of the Higher Education Act of 1965, 20 U.S.C. 1088 at sec is amended by inserting after Section 492 the following. Section 492A, limitation on proposing or issuing regulations and executive actions. A, proposed or final regulations and executive actions. Beginning on the date of enactment of this section, the Secretary may not issue a proposed regulation, final regulation, or executive action to implement this title if the Secretary determines that the regulation or executive action will increase the subsidy cost as cost is defined in Section 502 of the Federal Credit Reform Act of 1990 to U.S.C. 661A of a loan program under this title by more than $100 million. B, relationship to other requirements. The requirements of subsection A shall not be construed to affect any other cost analysis required under any source of law for a regulation implementing this title. Subtitle H, Garden of Heroes, Section 87001, Garden of Heroes. In addition to amounts otherwise available, they are appropriated to the National Endowment for the Humanities for fiscal year 2025 out of any money of the Treasury not otherwise appropriated to remain available through fiscal year 2028, $40 million for the procurement of statues as described by an Executive Order 13934, 85 Fed Reg 41165, relating to building and rebuilding monuments to American heroes, Executive Order 13978, 86 Fed Reg 6809, relating to building the National Garden of American Heroes, and Executive Order 14189, 90 Fed Reg 8849, relating to celebrating America's birthday. Subtitle 1, Office of Refugee Resettlement, Section 88001, Potential Sponsor Vetting for Unaccompanied Alien Children Appropriation. A, appropriation in addition to amounts otherwise available, there is appropriated to the Office of Refugee Resettlement for fiscal year 2025 out of any money of the Treasury not otherwise appropriated, $300 million to remain available until September 30, 2028 for the purposes described in subsection B. B, use of funds. The funds made available under subsection A may only be used for the Office of Refugee Resettlement to support costs associated with 1, background checks on potential sponsors, which shall include A, the name of the potential sponsor and of all adult residents of the potential sponsor's household, B, the Social Security number or taxpayer identification number of the potential sponsor and of all adult residents of the potential sponsor's household, C, the date of birth of the potential sponsor and of all adult residents of the potential sponsor's household, D, the validated location of the residence at which the unaccompanied alien child will be placed, E, an in-person or virtual interview with and suitability study concerning the potential sponsor and all adult residents of the potential sponsor's household. F, contact information for the potential sponsor and for all adult residents of the potential sponsor's household. And G, the results of all background and criminal record checks for these potential sponsor and for all adult residents of the potential sponsor's household, which shall include at a minimum an investigation of the public records sex offender registry, a public records background check, and a national criminal history background check on fingerprints. 2, home studies of potential sponsors of unaccompanied alien children. 3, determining whether an unaccompanied alien child possesses a danger to self or others by conducting an examination of the unaccompanied alien child for gang-related tattoos and other gang-related markings and coverings. Such tattoos or markings while the child is in the care of the Office of Refugee Resettlement. 4, data systems improvement and sharing that supports the health, safety, and well-being of unaccompanied alien children by determining the appropriateness of potential sponsors of unaccompanied alien children and of adults residing in the household of the potential sponsor, and by assisting with the identification and investigation of child labor, exploitation, and child trafficking. And 5, coordinating and communicating with state child welfare agencies regarding the placement of unaccompanied alien children in such states by the Office of Refugee Settlement. C, definitions in this section. 1, potential sponsor. The term potential sponsor means an individual or entity who applies for the custody of an unaccompanied alien child. 2, unaccompanied alien child. This term, unaccompanied alien child, has the meaning given in such term in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G. Title 9, Committee on Homeland Security and Governmental Affairs, Subtitle A, Homeland Security Provisions, Section 90001, Border Infrastructure and Wall System. In addition to amounts otherwise available, there is appropriated to the Commissioner of U.S. Customs and Border Protection for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30, 2029, $46,555,000,000 for necessary expenses related to the following elements of the border infrastructure and wall system. 1, construction, installation, or improvement of new or replacement primary waterborne and secondary barriers. 2, access roads. 3, barrier system attributes, including cameras, lights, sensors, and other detection technology. 4, any work necessary to prepare the ground at or near the border to allow U.S. Customs and Border Protection to conduct its operations, including the construction and maintenance of the barrier system. Section 90002, U.S. Customs and Border Protection personnel, fleet vehicles, and facilities. In general, in addition to amounts otherwise available, there was appropriated to the Commissioner of U.S. Customs and Border Protection for fiscal year 2025 out of any money of the Treasury not otherwise appropriated the following. Personnel, $4,100,000,000 to remain available until September 30, 2029 to hire and train additional Border Patrol agents, Office of Field Operations Officers, Air and Marine agents, rehired annuitants, and U.S. Customs and Border Protection field support personnel. 2, retention, hiring, and performance bonuses, $2,052,630,000 to remain available until September 30, 2029 to provide recruitment bonuses, performance awards, or annual retention bonuses to eligible Border Patrol agents, Office of Field Operations Officers, and Air and Marine agents. 3, vehicles, $855,000,000 to remain available until September 30, 2029 for the repair of existing patrol units and the lease or acquisition of additional patrol units. 4, facilities, $5 billion for necessary expenses relating to lease acquisition, construction, design, or improvement of facilities and checkpoints owned, leased, or operated by the U.S. Customs and Border Protection. B, restriction. None of the funds made available by subsection A may be used to recruit, hire, or train personnel for the duties of processing coordinators after October 31, 2028. Section 90003, detention capacity A in general. In addition to any amounts otherwise appropriated, there is appropriated to U.S. Immigration
and custom enforcement for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. $45 billion for single adult alien detention capacity and family residential center capacity. B, duration and standards. Aliens may be detained at family residential centers as described in subsection A pending a decision under the Immigration and Nationality Act 8 U.S.C. 1101 et seq. on whether the aliens are to be removed from the United States and if such aliens are ordered removed from the United States until such aliens are removed. The detention standards for the single adult detention capacities described in subsection A shall be set in the discretion of the Secretary of Homeland Security consistent with applicable law. C, definition of family residential center. In this section, the term family residential center means a facility used by the Department of Homeland Security to detain family units of aliens, including alien children who are not unaccompanied alien children, as defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who are encountered or apprehended by the Department of Homeland Security, regardless whether the facility is licensed by the state or a political subdivision of the state in which the facility is located. Sec 9004, border security technology screening. A, in general, in addition to amounts otherwise available, there is appropriated to the Commission of U.S. Customs and Border Protection for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $6,168,000,000 for the following. 1, procurement and integration of new non-intrusive inspection equipment and associated civil works, including artificial intelligence, machine learning, and other innovative technologies, as well as other mission support to combat the entry or exit of illicit narcotics at ports of entry and along the southwest, northern, and maritime borders. 2, air and marine operations, upgrading and procurement of new platforms for rapid air marine response capabilities. 3, upgrades and procurement of border surveillance technologies along the southwest, northern, and maritime borders. 4, necessary expenses, including the deployment of technology relating to the biometric entry and exit system under Section 7208 of the Intelligence Reform and Terrorism Prevention Act of 2004, 8 U.S.C. 1365b. 5, screening persons entering or exiting the United States. 6, initial screenings of unaccompanied alien children as defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, consistent with the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008, Public Law 110457, 122, Stat 5044. 7, enhancing border security by combating drug trafficking, including fentanyl and its precursor chemicals, at the southwest, northern, and maritime borders. 8, commemorating efforts and events relating to border security. B, restrictions. None of the funds made available under subsection A may be used for the procurement or deployment of surveillance towers along the southwest border and northern border that have not been tested and accepted by U.S. Customs and Border Protection to deliver autonomous capabilities. C, definition of autonomous. In this section, with respect to capabilities, the term autonomous means a system designed to apply artificial intelligence, machine learning, computer vision, or other algorithms to accurately detect, identify, classify, and track items of interest in real time, such that the system can make operational adjustments without the active engagement of personnel or continuous human command or control. Sec 90005, state and local assistance. A, state Homeland Security grant programs. 1, in general. In addition to amounts otherwise available, there is appropriated to the Administrator of the Federal Emergency Management Agency for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, to be administered under the State Homeland Security Grant Program authorized under Section 2004 of the Homeland Security Act of 2002, 6 U.S.C. 605, to enhance state, local, and tribal security through grants, contracts, cooperative agreements, and other activities. A, $500 million for state and local capabilities to detect, identify, track, or monitor threats from unmanned aircraft systems, as such term is defined in Section 44801 of Title 49 United States Code, consistent with Titles 18 and 49 of the United States Code. B, $625 million for security and other costs relating to the 2026 FIFA World Cup. C, $1 billion for security planning and other costs related to the 2028 Olympics, and D, $450 million for the Operation Stone Garden Grant Program. 2, terms and conditions. None of the funds made available under subparagraph B or C or paragraph 1 shall be subject to the requirements of Section 2004E1 or Section 2008A12 of the Homeland Security Act of 2002, 6 U.S.C. 605E1, 609A12. B, State Border Security Reinforcement Fund. 1, establishment. There is established in the Department of Homeland Security a fund to be known as the State Border Security Reinforcement Fund. 2, purpose. The Secretary of Homeland Security shall use amounts appropriate or otherwise made available for the fund for grants to eligible states and units of local government for any of the following purposes. A, construction or installation of a border wall, border fencing, or other barrier or buoys along the southern border of the United States, which may include planning, procurement of materials, and personal costs related to such construction or installation. B, any work necessary to prepare the ground at or near land borders to allow construction and maintenance of a border wall or other barrier fencing. C, detection and interdiction of illicit substances and aliens who have unlawfully entered the United States and have committed a crime under federal, state, or local law, and transfer or referral of such aliens to the Department of Homeland Security as provided by law. D, relocation of aliens who are unlawfully present in the United States from small population centers to other domestic locations. 3, appropriation. In addition to amounts otherwise available for the purposes described in paragraph 2, there is appropriated for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to the Department of Homeland Security for the State Border Security Reinforcement Fund established by paragraph 1, $10 billion to remain available until September 30th, 2034 for qualified expenses for such purposes. 4, eligibility. The Secretary of Homeland Security may provide grants from the fund established by paragraph 1 to state agencies and units of local governments for expenditures made for completed, ongoing, or new activities in accordance with law that occurred on or after January 20th, 2021. 5, application. Each state desiring to apply for a grant under this subsection shall submit an application to the Secretary containing such information in support of the application as the Secretary may require. The Secretary shall require that each state include in its application the purposes for which the state seeks the funds and a description of how the state plans to allocate the funds. The Secretary shall begin to accept applications not later than 90 days after the date of the enactment of this act. 6, terms and conditions. Nothing in this subsection shall authorize any state or local government to exercise immigration or border security authorities reserved exclusively to the federal government under the Immigration and Nationality Act, 8 U.S.C. 1101 etc., or the Homeland Security Act of 2002, 6 U.S.C. 101 etc. The Federal Emergency Management Agency may use not more than 1% of the funds made available under this subsection for the purpose of administering grants provided for in this section. Sec 90006, Presidential Residence Protection. A, in general. In addition to amounts otherwise available, there is appropriated to the Administrator of the Federal Emergency Management Agency for fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $300 million to remain available until September 30th, 2029 for the reimbursement of extraordinary law enforcement personnel costs for protection activities directly and demonstrably associated with any residence of the President's designated pursuant to Section 3 or 4 of the Presidential Protection Assistance Act of 1976, Public Law 94524, 18 U.S.C. 3056 note, to be secured by the United States Secret Service. B, availability. Funds appropriated under this section shall be available only for costs that a state or local agency, 1, incurred or incurs on or after July 1st, 2024. 2, demonstrates to the administration of the Federal Emergency Management Agency as being A, in excess of typical law enforcement operational costs, B, directly attributable to the provision of protection described in this section, and C, associated with a non-governmental property designated pursuant to Section 3 or 4 of the Presidential Protection Assistance Act of 1976, Public Law 94524, 18 U.S.C. 3056 note, to be secured by the United States Secret Service, and 3, certifies to the Administrator as compensating protection activities requested by the United States Secret Service. C, terms and conditions. The Federal Emergency Management Agency may use not more than 3% of the funds made available under this section for the purpose of administering grants provided for in this section. Sec 90007, Department of Homeland Security Appropriations for Border Support. In addition to amounts otherwise available, there are appropriated to the Secretary of Homeland Security for fiscal year 2025 out of any money in the Treasury not otherwise appropriated, $10 billion to remain available until September 30th, 2029 for reimbursement of costs incurred in undertaking activities in support of the Department of Homeland Security's mission to safeguard the borders of the United States. Subtitle B, Governmental Affairs Provisions. Sec 90101, FEHB Improvements. A, short title. This section may be cited as the FEHB Protection Act of 2025. B, definitions in this section. 1, director. The term director means director of the Office of Personnel Management. 2, health benefit plans. Member of family, the term health benefits plan and member of family have the meanings given those terms in section 8901 of Title V United States Code. 3, open season. The term open season means an open season described in section 390.301F of Title V Code of Federal Regulations or any successor regulation. 4, program. The term program means the health insurance programs carried out under Chapter 89 of Title V United States Code, including the program carried out under Section 8903C of that title. 5, qualifying life event. The term qualifying life event has the meaning given the term in Section 892.101 of Title V Code of Federal Regulations or any successor regulation. C, verification requirements. Not later than 1 year after the date of enactment of this act, the director shall issue regulations and implement a process to verify. 1, the veracity of any qualifying life event through which an enrollee in the program seeks to add a member of family with respect to this enrollee to a health benefit plan under the program, and 2, that when an enrollee in the program seeks to add a member of family with respect to the enrollee to the health benefits plan of the enrollee under the program, including during any open season, the individual so added is a qualifying member of family with respect to the enrollee. D, fraud risk assessment. In any fraud risk assessment conducted with respect to the program on or after the date of enactment of this act, the director shall include an assessment of individuals who are enrolled in or covered under a health benefits program under the program, even though those individuals are not eligible to be so enrolled or covered. E, family member eligibility verification audit. 1, in general. During the 3-year period beginning on the date, this is 1 year after the date of enactment of this act, the director shall carry out a comprehensive audit regarding members of family who are covered under an enrollment in a health benefits plan under the program. 2, contents. With respect to the audit carried out under paragraph 1, the director shall review marriage certificates, birth certificates, and other appropriate documents that are necessary to determine eligibility to enroll in a health benefits plan under the program. F, disenrollment or removal. Not later than 180 days after the date of the enactment of this act, the director shall develop a process by which any individual enrolled in or covered under a health benefits plan under the program who is not eligible to be so enrolled or covered shall be disenrolled or removed from enrollment in or coverage under that health benefits plan. G, earned benefits and health care administrative services associated oversight and audit funding. Section 8909 of Title V United States Code is amended. 1, in subsection A2 by inserting before the period at the end the following, except that the amounts required to be set aside under subsection B2 shall be subject to the limitations that may be specified annually by Congress, and 2, in subsection B, A, by redesignating paragraph 2 as paragraph 3, and B, by inserting after paragraph 1 the following: 2, in fiscal year 2026, fiscal year 2026. In fiscal year 2026, $66 million to be derived from all contributions and to remain available until the end of fiscal year 2035 for the Director of Office to carry out subsection C through F of the FEHB Protection Act of 2025. Section 90102, Pandemic Response Accountability Committee. A, Pandemic Response Accountability Committee funding availability. In addition to amounts otherwise available, there is appropriated for fiscal year 2026 out of any money in the Treasury not otherwise appropriated, $88 million to remain available until expended for the Pandemic Response Accountability Committee to support oversight of the coronavirus response and of funds provided in this act or any other act pertaining to the coronavirus pandemic.
B, CARES Act. Section 15010 of the CARES Act, Public Law 116-136, 134, Stat 533, is amended. 1, in subsection A6, A, in subparagraph E, by striking or at the end, B, in subparagraph F, by striking and at the end and inserting or, and C, by adding at the end the following: G, the act titled An Act to Provide for Reconciliation pursuant to Title II of H. Con. Res. 14, and 2, in subsection K, by striking 2025 and inserting 2034. Section 90103, Appropriation for the Office of Management and Budget. In addition to amounts otherwise available, there is appropriated to the Office of Management and Budget for fiscal year 2025, out of any money in the Treasury not otherwise appropriated, $100 billion, to remain available until September 30th, 2029, for purposes of finding budget and accounting efficiencies in the executive branch. Title 10, Committee on the Judiciary. Subtitle A, Immigration and Law Enforcement Matters. Part 1, Immigration Fees. Section 100001, Applicability of the Immigration Laws. A, Applicability. The fees under this subtitle shall apply to aliens in the circumstances described in this subtitle. B, Terms. The terms used under this subtitle shall have the meanings given such terms in Section 101 of the Immigration and Nationality Act, 8 U.S.C. 1101. C, References to Immigration and Nationality Act. Except as otherwise expressly provided, any reference in this subtitle to a section or other provision shall be considered to be to a section or other provision of the Immigration and Nationality Act, 8 U.S.C. 1101 et sec. Section 100002, Asylum Fee. A, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security or the Attorney General, as applicable, shall require the payment of a fee equal to the amount specified in this section by any alien who files an application for asylum. Under Section 208, 8 U.S.C. 1158, at the time such application is filed. B, initial amount. During fiscal year 2025, the amount specified in this section shall be the greater of 1, $100, or 2, such amount as the Secretary or the Attorney General, as applicable, may establish by rule. C, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of 1, the amount of the fee required under this section for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in paragraph 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. D, disposition of asylum fee proceeds exceeding during each fiscal year. 1, 50% of the fees received from aliens filing applications with the Attorney General, A, shall be credited to the Executive Office for Immigration Review, and B, may be retained and expended without further appropriation. 2, 50% of fees received from alien filing applications with the Secretary of Homeland Security, A, shall be credited to the U.S. Citizenship and Immigration Services, B, shall be deposited into the Immigration Examinations Fee account established under Section 286M, 8 U.S.C. 1356M, and C, may be retained and expended without further appropriation. And 3, any amounts received in fees required under this section that were not credited to the Executive Office for Immigration Review pursuant to paragraph 1 or to U.S. Citizenship and Immigration Services pursuant to paragraph 2 shall be deposited into the general fund of the Treasury. E, no waiver fee. Fees required to be paid under the section shall not be waived or reduced. Section 10003, Employment Authorization Document Fees. A, asylum applicants. 1, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in the subsection by any alien who files any initial application for employment authorization under Section 208D2, 8 U.S.C. 1158D2, at the time such initial employment authorization application is filed. 2, initial amount. During fiscal year 2025, the amount specified in the subsection shall be the greater of A, $550, or B, such amount as the Secretary of Homeland Security may establish by rule. 3, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of A, the amount of the fee required under this section for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10.
4, disposition of employment authorization document fees. During each fiscal year, A, 25% of the fees collected pursuant to this subsection, I, shall be credited to U.S. Citizenship and Immigration Services. 2, shall be deposited into the Immigration Examinations Fee account established under Section 286M, 8 U.S.C. 1356M, and 3, may be retained and expended by U.S. Citizenship and Immigration Services without further appropriation, provided that not less than 50% is used to detect and prevent immigration benefit fraud, and B, any amounts collected pursuant to this subsection that are not credited to U.S. Citizenship and Immigration Services pursuant to subparagraph A shall be deposited into the general fund of the Treasury. 5, no fee waiver. Fees required to be paid under this subsection shall not be waived or reduced. B, parolees. 1, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in this subsection by any alien paroled into the United States for any initial application for employment authorization at the time such initial application is filed. Each initial employment authorization shall be valid for a period of 1 year or for the duration of the alien's parole, whichever is shorter. 2, initial amount. During fiscal year 2025, the amount specified in this subsection shall be the greater of A, $550, or B, such amount as the Secretary of Homeland Security may establish by rule. 3, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this subsection shall be equal to the sum of A, the amount of the fee required under this subsection for the amount recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next level, multiple of $10. 4, disposition of parolee employment authorization application fees. All of the fees collected pursuant to this subsection shall be deposited into the general fund of the Treasury. 5, no fee waiver. Fees required to be paid under this subsection shall not be waived or reduced. C, temporary protected status. 1, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in this subsection by any alien who files an initial application for employment authorization under Section 244A 1B 8 U.S.C. 1254A A 1B at the time such initial application is filed. Each initial employment authorization shall be valid for a period of 1 year or for the duration of the alien's temporary protected status, whichever is shorter. 2, initial amount. During fiscal year 2025, the amount specified in this subsection shall be the greater of A, $550, or B, such amount as the Secretary of Homeland Security may establish by rule. 3, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this subsection shall be equal to the sum of A, the amount of the fee required under this subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplications of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 4, disposition of employment authorization application fees collected from aliens granted temporary protected status. All of the fees collected pursuant to this subsection shall be deposited into the general fund of the Treasury. 5, no fee waiver. Fees required to be paid under this subsection shall not be waived or reduced. Sec 10004, immigration parolee fee. A, in general, except as provided under subsection B, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in this section, in addition to any other fee authorized by law by any alien who is paroled into the United States. B, exceptions. An alien shall not be subject to the fee otherwise required under subsection A if the alien establishes to the satisfaction of the Secretary of Homeland Security on an individual case-by-case basis that the alien is being paroled because 1A, the alien has a medical emergency, and B, the alien cannot obtain necessary treatment in the foreign state in which the alien is residing, or 2, the medical emergency is life-threatening and there is insufficient time for the alien to be admitted to the United States through the normal visa process. 2A, the alien is the parent or legal guardian of an alien described in paragraph 1, and B, the alien described in paragraph 1 is a minor. 3A, the alien is needed in the United States to donate an organ or other tissue for transplant, and B, there is insufficient time for the alien to be admitted to the United States through the normal visa process. 4A, the alien has a close family member in the United States whose death is imminent, and B, the alien could not arrive in the United States in time to see such family member alive if the alien were to be admitted to the United States during the normal visa process. 5A, the alien is seeking to attend the funeral of a close family member, and B, the alien could not arrive in the United States in time to attend such funeral if the alien were to be admitted to the United States through the normal visa process. 6, the alien is an adopted child. A, who has an urgent medical condition. B, who is in the legal custody of the petitioner for a final adoption-related visa. And C, whose medical treatment is required before the expected award of a final adoption-related visa. 7, the alien. A, is a lawful applicant for adjustment of status under Section 2458 U.S.C. 1255, and B, is returning to the United States after temporary travel abroad. 8, the alien. A, has been returned to his contiguous country pursuant to Section 235B2C, 8 U.S.C. 1225B2C, and B, is being paroled into the United States to allow the alien to attend the alien's immigration hearing. 9, the alien has been granted the status of Cuban and Haitian entrant as defined in Section 501E of the Refugee Education Assistance Act of 1980, Public Law 96-422, 8 U.S.C. 1522 note, or 10, the Secretary of Homeland Security determines that a significant public benefit has resulted or will result from the parole of an alien. A, who has assisted or will assist the United States government in a law enforcement matter. B, his presence is required by the United States government in furtherance of such law enforcement matter. And C, I, who is inadmissible or does not satisfy the eligibility requirements for admission as a non-immigrant, or 2, for which there is insufficient time for the alien to be admitted to the United States through the normal visa process. C, initial amount. For fiscal year 2025, the amount specified in this section shall be the greater of 1, $1,000, or 2, such amount as the Secretary of Homeland Security may establish by rule. D, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of 1, the amount of the fee required under this subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in paragraph 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. E, disposition of fees collected from aliens granted parole. All of the fees collected pursuant to this section shall be deposited to the general fund of the Treasury. F, no fee waiver. Except as provided in subsection B, fees required to be paid under this section shall not be waived or reduced. Set 10005, special immigrant juvenile fee. A, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in this section by any alien parent or legal guardian of an alien applying for special immigrant juvenile status under Section 101A, 27J, 8 U.S.C. 1101A, 27J. B, initial amount. For fiscal year 2025, the amount specified in this section shall be the greater of 1, $250, or 2, such amount as the Secretary of Homeland Security may establish by rule. C, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of 1, the amount of the fee required under this subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in paragraph 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of 10.
D, D, disposition of special immigrant juvenile fees. All of the fees collected pursuant to this section shall be deposited into the general fund of the Treasury. Section 10006, temporary protected status fees. Section 244C1B of the Immigration and Nationality Act, 8 U.S.C. 1254AC1B is amended. 1, by striking the Attorney General and inserting the following. 1, in general, the Attorney General. 2, in Clause 1, as redesignated by striking $50 and inserting $500, subject to the adjustments required under Clause 2. And 3, by adding at the end of the following. 2, annual adjustments for inflation. During the fiscal year 2026 and during each subsequent fiscal year, the maximum amount of the fee authorized under Clause 1 shall be equal to the sum of 1, the maximum amount of the fee authorized under this subparagraph for the most recent concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in subclause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of temporary protected status fees. All of the fees collected pursuant to this subparagraph shall be deposited into the general fund of the Treasury. 4, no fee waiver. Fees required to be paid under this subparagraph shall not be waived or reduced. Section 10007, visa integrity fee. A, visa integrity fee. 1, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in this subsection by any alien issued a non-immigrant visa at the time of such issuance. 2, initial amount for fiscal year 2025. The amount specified in this section shall be the greater of A, $250, or B, such amount as the Secretary of Homeland Security may establish by rule. 3, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of A, the amount of the fee required under this subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers but for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month for the preceding calendar year, rounded down to the nearest dollar. 4, disposition of visa integrity fees. All of the fees collected pursuant to this section that are not reimbursed pursuant to subsection B shall be deposited into the general fund of the Treasury. 5, no fee waiver. Fees required to be paid under the subsection shall not be waived or reduced. B, fee reimbursement. The Secretary of Homeland Security may provide a reimbursement to an alien of the fee required under subsection A for the issuance of a non-immigrant visa after the expiration of such non-immigrant visa's period of validity if such alien demonstrates that he or she, 1, after admission to the United States pursuant to such non-immigrant visa, complied with all conditions of such non-immigrant visa, including the condition that an alien shall not accept unauthorized employment, and 2, A, has not sought to extend his or her period of admission during such period of validity and departed the United States not later than 5 days after the last day of such period, or B, during such period of validity was granted an extension of such non-immigrant status or an adjustment to the status of a lawful permanent resident. Section 10008, Form 1, I-94 fee. A, fee authorized. In addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in subsection B by any alien who submits an application for a Form I-94 arrival departure record. B, amount specified. 1, initial amount. For fiscal year 2025, the amount specified in this section shall be the greater of A, $24, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in the section shall be equal to the sum of A, the amount of the fee required under this subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded down to the nearest dollar. C, disposition of Form I-94 fees. During each fiscal year, 1, 20% of the fees collected pursuant to this section, A, shall be deposited into the Land Border Inspection Fee account in accordance with Section 286Q2, 8 U.S.C. 1356Q2, and B, shall be made available to U.S. Customs and Border Protection to retain and spend without further appropriation for the purpose of processing Form I-94. And 2, any amounts not deposited into the Land Border Inspection Fee account pursuant to paragraph 1A shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 100009, annual asylum fee. A, fee authorized. In addition to any other fee authorized by law for each calendar year that an alien's application for asylum remains pending, the Secretary of Homeland Security or the Attorney General, as applicable, shall require the payment of a fee equal to the amount specified in subsection B by such alien. B, amount specified. 1. Initial amount for fiscal year 2025, the amount specified in this section shall be the greater of A, $100, or B, such amount as the Secretary of Homeland Security may establish by rule. 2. Annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded down to the nearest dollar. C, disposition of annual asylum fees. All of the fees collected pursuant to this section shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under the section shall not be waived or reduced. Section 100010, fee relating to renewal and extension of employment authorization for parolees. A, in general. In addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in subsection B for any parolee who seeks a renewal or extension of employment authorization based on a grant of parole. The employment authorization for each alien paroled into the United States or any renewal of extension of such parole shall be valid for a period of 1 year or for the duration of the alien's parole, whichever is shorter. B, amount specified. 1, initial amount. For fiscal year 2025, the amount specified in the subsection shall be the greater of A, $275, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this subsection shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. C, disposition of fees relating to renewal and extension of employment authorization for parolees. During each fiscal year, 1, 25% of the fees collected pursuant to this section, A, shall be credited to the U.S. Citizenship and Immigration Services. B, shall be deposited into the Immigration Examinations fee account established under sections 286M, 8 U.S.C. 1356M, and C, may be retained and expanded by U.S. Citizenship and Immigration Services without further appropriation, and 2, any amounts collected pursuant to this section are not credited to the U.S. Citizenship and Immigration Services pursuant to subparagraph A shall be deposited into the general fund of the Treasury. No fee waiver. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 100011, fee relating to renewal or extension of employment authorization for asylum applications. A, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee of not less than $275 by any alien who has applied for asylum for each renewal or extension of employment authorization based on such application. B, termination. Each initial employment authorization or renewal of extension of such authorization shall terminate. 1, immediately following the denial of an asylum application by an asylum officer unless the case is referred to an immigration judge. 2, on the date that is 30 days after the date on which an immigration judge denies an asylum application unless the alien makes a timely appeal to the Board of Immigration Appeals. Or 3, immediately following the denial of the Board of Immigration Appeals of an appeal of a denial of an asylum application. C, disposition of fees relating to renewal and extension of employment authorization for asylum applicants during each fiscal year. 1, 25% of the fees collected pursuant to this section A shall be credited to the U.S. Citizenship and Immigration Services. B, shall be deposited into the Immigration Examinations fee account established under 286M, 8 U.S.C. 1356M, and C, may be retained and expended by the U.S. Citizenship and Immigration Services without further appropriation, and 2, any amounts collected pursuant to this section that are not credited to U.S. Citizenship and Immigration Services pursuant to subparagraph A shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 100012, fee relating to renewal and extension of employment authorization for aliens granted temporary protected status. A, in general, in addition to any other fee authorized by law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in subsection B by any alien at the time such alien seeks a renewal or extension of employment authorization based on a grant of temporary protected status. Any employment authorization for an alien granted temporary protected status or any renewal of extension of such employment authorization shall be valid for a period of 1 year or for the duration of the designation of temporary protected status, whichever is shorter. B, amount specified, 1, initial amount for fiscal year 2025. The amount specified in this subsection shall be the greater of A, $275, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in the section shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in the subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. C, disposition of fees relating to renewal and extension of employment authorization for temporary protected status applicants. During each fiscal year, 1, 25% of the fees collected pursuant to this section, A, shall be credited to the U.S. Citizenship and Immigration Services. B, shall be deposited into the Immigration Examinations Fee account established under Section 286M, 8 U.S.C. 1356M, and C, may be retained and expended by U.S. Citizenship and Immigration Services without further appropriations. And 2, any amount collected pursuant to this section that are not credited to U.S. Citizenship and Immigration Services pursuant to subparagraph A shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 10013, fees relating to applications for adjustments of status. A, fee for filing an application to adjust status to that of a lawful permanent resident. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 of any alien who files an application with an immigration court to adjust the alien status to that of lawful permanent resident, or those whose application to adjust his or her status to that of lawful permanent resident is adjudicated in immigration court. Such fee shall be paid at the time of such application is filed or before such application is adjudicated by the immigration court. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $1,500, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of adjustments of status application fees. During each fiscal year, A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the Immigration Examinations Fee account established under Section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. B, fee for filing application for a waiver of grounds of inadmissibility. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court for a waiver of a ground of inadmissibility, or before such application is adjudicated by the immigration court. 2, amounts specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $1,050, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, round to the next lowest multiple of $10. 3, disposition of waiver of ground of admissibility application fees during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation. And B, any amount not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. C, fee for filing an application for temporary protected status. 1. In general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court for temporary protected status, or before such an application is adjudicated by the immigration court. 2. Amount specified. A. Initial amount. For fiscal year 2025, the amount specified in the paragraph shall be the greater of 1. $500, or 2. Such amount as the Attorney General may establish by rule. B. Annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1. The amount of the fee required under the subsection for the most recently concluded fiscal year, and 2. The product resulting from multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month the preceding calendar year, rounded to the next lowest multiple of $10. 3. Disposition of temporary protected status application fees during each fiscal year. A. Not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. D, fee for filing an appeal of a decision of an immigration judge. 1. In general, except for as provided in paragraph 3, the Attorney General shall require, in addition to any other fees authorized by law, the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an appeal from a decision of an immigration judge. 2. Amount specified. A. Initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1. $900, or 2. Such amount as the Attorney General may establish by rule. B. Annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1. The amount of the fee required under the subsection for the most recently concluded fiscal year, and 2. The product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July, preceding the date on which such adjustment takes effect, exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3. Exception. The fee required under paragraph 1 shall not apply to the appeal of a bond decision for disposition of fees for appealing immigration judge decisions during each fiscal year. A. Not more than 25% of the fees collected pursuant to the subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation. And B. Any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. E. Fee for filing an appeal from a decision of an officer of the Department of Homeland Security. 1. In general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an appeal of a decision of an officer of the Department of Homeland Security. 2. Amount specified. A. Initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1. $900, or 2. Such amount as the Attorney General may establish by rule. B. Annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1. The amount of fee required under the subsection for the most recently concluded fiscal year, and 2. The product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3. Disposition of fees for appealing Department of Homeland Security officer decisions during each fiscal year. A. Not more than 25% of the fees collected pursuant to the subsection 1 shall be derived from transfer from the immigration examinations fee account established under section 286M 8 USC 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credit pursuant to subparagraph A shall be deposited into the general fund of the Treasury. F, fee for filing an appeal from a decision of an adjudicating official in a practitioner disciplinary case. 1. In general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any practitioner at the time such practitioner files an appeal from a decision of an adjudicating official in a practitioner disciplinary case. 2. Amount specified in A, initial amount for the fiscal year 2025. The amount specified in this paragraph shall be the greater of 1, $1,325, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under this subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for appealing Department of Homeland Security officer decisions during each fiscal year. A, not more than 25% of fees collected pursuant to the subsection 1 shall be derived from transfer from the immigration examinations fee account established under section 286M 8 USC 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credit pursuant to subparagraph A shall be deposited into the general fund of the Treasury. G, fee for filing a motion to reopen or a motion to reconsider. 1, in general, except as provided in paragraph 3, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files a motion to reopen or a motion to reconsider a decision of an immigration judge or the Board of Immigration Appeals. Two, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $900, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 of the percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, exceptions. The fee required under paragraph 1 shall not apply to A, a motion to reopen a removal order entered in absentia if such motion is filed in accordance with section 240B 5C2, 8 U.S.C. 1229A-B 5C2. Or B, a motion to reopen a deportation order entered in absentia if such motion is filed in accordance with section 242B C3B prior to April 1st, 1997. 4, disposition of fees for filing certain motions. During each fiscal year, A, not more than 25% of fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under sections 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credit pursuant to subparagraph A shall be deposited into the general fund of the Treasury. H, fee for filing application for suspension of deportation. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court for suspension of deportation. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $600, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required in the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for filing application for suspension of deportation during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection shall be derived by transfer from the immigration examination fee account established under Section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. I, fee for filing application for cancellation of removal for certain permanent residents. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court, an application for cancellation of removal for an alien who is a lawful permanent resident. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $600, or 2, such amount as established by the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under this subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, round to the next lowest multiple of $10. 3, disposition of fees for filing application for cancellation of removal during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. J, fee for filing an application for cancellation of removal and adjustment of status for certain non-permanent residents. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien who is not a lawful permanent resident at the time such alien files an application with an immigration court for cancellation of removal and adjustment of status for any alien. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $1,500, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the paragraph percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for filing application for cancellation or removal during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. K, limitation of use of funds. No fees collected pursuant to the section shall be expended by the Executive Office for Immigration Review for the Legal Orientation Program or for any successor program.
Section 100014, Electronic System for Travel Authorization Fee. Section 127H3B 8 U.S.C. 1187H3B is amended. 1, in Clause 1, A, in Subclause 1 by striking and at the end, B, in Subclause 2, I, by inserting of not less than $10 after an amount, and 2, by striking the period at the end and inserting semicolon, C, by adding at the end of the following: 3, not less than $13 per travel authorization. 2, in clause 3, by striking October 31, 2028 and inserting October 31, 2034, and 3, by adding at the end the following: 4, subsequent adjustment during fiscal year 2026 and each subsequent fiscal year, the amount specified in clause 1, 2 for a fiscal year shall be equal to the sum of 1, the amount of the fee required under the subparagraph during the most recent concluded fiscal year, and 2, the product of the amount referred to in subclause 1 multiplied by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds consumer price index for all urban consumers for the same month of the preceding calendar year. Section 100015, electronic visa update system fee. A, in general, in addition to any other fee authorized by the law, the Secretary of Homeland Security shall require the payment of a fee in the amount specified in subsection B by any alien subject to the electronic visa update system at the time of such alien's enrollment in such system. B, amount specified. 1, in general, for fiscal year 2025, the amount specified in the subsection shall be the greater of A, $30, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and each subsequent fiscal year, the amount specified in the subsection shall be equal to the sum of A, the amount of the fee required under the subsection during the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage of any by which the consumer price index for all urban consumers for the month of July preceding the date on which adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the lowest multiple of 25 cents. C, disposition of electronic visa update system fees. 1, in general, section 286(8) U.S.C. 1356 is amended by adding at the end the following: W, CBP electronic visa update system account. 1, establishment. There is established in the general fund of the Treasury a separate amount which shall be known as the CPB electronic visa update system account. Refer to this in this subsection as the account. 2, deposits. There shall be deposited into the account an amount equal to the difference between A, all of the fees received pursuant to section 100015 of the Act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Congress 14, 119th Congress, and B, an amount equal to $5 multiplied by the number of payments collected pursuant to each section. 3, appropriations. Amount deposited in the account, A, are hereby appropriated to make payments and offset program costs in accordance with section 100015 of the Act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Congress 14, 119th Congress, without further appropriation, and B, shall remain available until expended for any U.S. Customs and Border Protection costs associated with administering the CBP electronic visa update system. 2, remaining fees. Of the fees collected pursuant to this section, an amount equal to $5 multiplied by the number of payments collected pursuant to this section shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 100016, fee for aliens ordered removed in absentia. A, in general, as partial reimbursement for the cost of arresting an alien described in this section, the Secretary of Homeland Security, except as provided in subsection C, shall require the payment of a fee equal to the amount specified in subsection B on any alien who, 1, is ordered removed in absentia pursuant to section 240B5, 8 U.S.C. 1229A-B5, and 2, is subsequently arrested by U.S. Immigration and Customs Enforcement. B, amount specified. 1, initial amount for the fiscal year 2025. The amount specified in this section shall be the greater of A, $5,000, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this subsection in this section shall be equal to the sum of A, the amount of the fee required under this subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple, $10. C, exception. The fee described in this section shall not apply to any alien who was ordered removed in absentia if such order was rescinded pursuant to section 240B5C, 8 U.S.C. 1229A, B5C. D, disposition of removal in absentia fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section A shall be credited to U.S. Immigration and Customs Enforcement. B, shall be deposited into the Detention and Removal Office fee account, and C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation. And 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. E, no fee waiver. Fees required to be paid under the section shall not be waived or reduced. Section 100017, inadmissible alien apprehension fee. A, in general, in addition to any other fee authorized by the law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in subsection B by any inadmissible alien at the time of such alien is apprehended between ports of entry. B, amount specified. 1, initial amount. For fiscal year 2025, the amount specified in the section shall be the greater of A, $5,000, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in the section shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded up to the next lowest multiple of $10. C, disposition of inadmissible alien apprehension fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section A shall be credited to U.S. Immigration and Customs Enforcement. B, shall be deposited into the Detention and Removal Office fee account. And C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation. And 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. D, disposition of inadmissible alien apprehension fees. All of the fees collected pursuant to the section shall be deposited into the general fund of the Treasury. Section 100018, amendment to authority to apply for asylum. Section 208D3, 8 U.S.C. 1158D3 is amended. 1, in the first sentence by striking may and inserting shall. 2, by striking such fees shall not exceed, and all that follows, and inserting the following. Nothing in this paragraph may be construed to limit the authority of the Attorney General to set additional adjudication and naturalization fees in accordance with Section 286M. Part 2, Immigration and Law Enforcement Funding, Section 100051, appropriation for the Department of Homeland Security. In addition to the amounts otherwise available, there is appropriated to the Secretary of Homeland Security for fiscal year 2025 out of any money in the Treasury not or otherwise appropriated $2,055 million to remain available through September 30th, 2029 for the following purposes. 1, immigration and enforcement activities, hiring and training of additional U.S. Customs and Border Protection Agency and the necessary support staff to carry out immigration enforcement activities. 2, departures and removal, funding for transportation costs and related costs associated with the departure of or removal of aliens. 3, personal assignments, funding for the assignment of Department of Homeland Security employees and state officers to carry out immigration enforcement activities pursuant to sections 103A and 287G of the Immigration and Nationality Act, 8 U.S.C. 1103A and 1357G. 4, background checks, hiring additional staff and investing the necessary resource to enhance screening and vetting of all aliens seeking entry into the United States, consistent with Section 212 of such Act, 8 U.S.C. 1182, or intending to remain in the United States consistent with Section 237 of such Act, 8 U.S.C. 1227. 5, protecting alien children from exploitation. In instances of alien children entering the United States without a valid visa, funding is provided for the purposes of A, collecting fingerprints in accordance with Section 262 of the Immigration and Nationality Act, 8 U.S.C. 1302, and subsections A, 3, and B of Section 235 of such Act, 8 U.S.C. 1225, and B, collecting DNA in accordance with Sections 235D and 287B of the Immigration and Nationality Act, 8 U.S.C. 1225D and 1357B. 6, transporting and return of aliens from contiguous territory. Transporting and facilitating the return pursuant to Section 235B2C of the Immigration and Nationality Act 8 U.S.C. 1225B2C of aliens arriving from contiguous territory. 7, state and local participation. Funding for state and local participation in Homeland Security efforts for the purposes of A, ending the presence of criminal gangs and criminal organizations throughout the United States. B, addressing crime and public safety threats. C, combating human smuggling and trafficking networks throughout the United States. D, supporting immigration enforcement activities. And E, providing reimbursement for state and local participation in such efforts. 8, removal of specified unaccompanied alien children. A, in general, funding removal operations for specified unaccompanied alien children. B, use of funds. Amounts made available under this paragraph shall only be used for permitting a specified unaccompanied alien child to withdraw the application for admission of the child pursuant to Section 235A4 of the Immigration and Nationality Act. 8 U.S.C. 1225A4. C, definitions. In this paragraph, 1, specified unaccompanied alien child. The term specified unaccompanied alien child means unaccompanied alien child as defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who the Secretary of Homeland Security determines on a case-by-case basis. 1, has been found by an immigration officer at a land border or port of entry of the United States and is inadmissible under the Immigration and Nationality Act 8 U.S.C. 1101 et sec. 2, has not been a victim of severe forms of trafficking in persons, and there is no credible evidence that such child is at risk of being trafficked upon return of the child to the child's country of nationality or country of last habitual residence. And 3, does not have a fear of returning to the child's country of nationality or country of last habitual residence owing to a credible fear of persecution. 2, severe forms of trafficking in persons. The term severe forms and trafficking in persons has the meaning given such term in Section 103 of the Trafficking Victims Protection Act of 2000, 22 U.S.C. 7102. 9, expedited removal of criminal aliens. Funding for the expedited removal of criminal aliens in accordance with the provisions of Section 235B1 of the Immigration and Nationality Act, 8 U.S.C. 1225B1. 10, removal of certain criminal aliens without further hearings. Funding for the removal of certain criminal aliens without further hearings in accordance with the provisions of Section 235C of the Immigration and Nationality Act, 8 U.S.C. 1225C. 11, criminal and gang checks for unaccompanied alien children. Funding for criminal and gang checks of unaccompanied alien children is defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who are 12 years of age and older, including the examination of such unaccompanied alien children for gang-related tattoos and other gang-related markings. 12, information technology. Information technology investments to support immigration purposes, including improvements to fee and revenue collections. Section 100052, appropriation for U.S. Immigration and Customs Enforcement. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for U.S. Immigration and Customs Enforcement for fiscal year 2025 out of any money in the Treasury not otherwise appropriated. $29,850,000,000 to remain available through September 30th, 2029 for the following purposes. 1, hiring and training. Hiring and training additional U.S. Immigration and Customs Enforcement personnel, including officers, agents, investigators, and support staff to carry out immigration enforcement activities, and prioritizing the streamlining and hiring of retired U.S. Immigration and Customs Enforcement personnel. 2, performance, retention, and signing bonuses. A, in general, providing performance, retention, and signing bonuses for qualified U.S. Immigration Customs Enforcement personnel in accordance with this subsection. B, performance bonuses. The Director of U.S. Immigration and Customs Enforcement at the Director's discretion may provide performance bonuses to any U.S. Immigration Customs Enforcement agent, officer, or attorney who demonstrates exemplary service. C, retention bonuses. The Director of U.S. Immigration and Customs Enforcement may provide retention bonuses to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who commits to 2 years of additional service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. D, signing bonuses. The Director of U.S. Immigration and Customs Enforcement may provide a signing bonus to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who, 1, is hired on or after the date of the enactment of this act, and 2, who commits to 5 years of service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. E, service agreement. In providing a retention or signing bonus under this paragraph, the Director of U.S. Immigration and Customs Enforcement shall provide each qualifying individual with a written service agreement that includes 1, the commencement and termination dates of the required service period or provisions of the determination of such dates, 2, the amount of the bonus, and 3, any other term or condition under which the bonus is payable subject to the requirements of this paragraph, including 1, the condition under which the agreements may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in the subclause 1. 3, recruitment, hiring, and onboarding, facilitating the recruitment, hiring, and onboarding of additional U.S. Immigration and Customs Enforcement personnel to carry out immigration enforcement activities, including by A, investing in information technology, recruitment, and marketing, and B, hiring staff necessary to carry out information technology, recruitment, and marketing activities. 4, transportation, funding for transportation costs and related costs associated with alien departure or removal operations. 5, information technology, funding for information technology investments to support enforcement and removal operations, including improvements to fee collections. 6, facility upgrades, funding for facility upgrades to support enforcement and removal operations. 7, fleet modernization, funding for fleet modernization to support enforcement and removal operations. 8, family unity, promoting family unity by A, maintaining the care and custody during the period in which a charge described in Clause 1 is pending in accordance with the applicable laws of an alien who, 1, is charged only with a misdemeanor offense under Section 275A of the Immigration and Nationality Act, 8 U.S.C. 1325A, and 2, entered the United States with the alien's child who has not attained 18 years of age, and B, detaining such an alien with the alien's child. 9, 287G agreements, expanding, facilitating, and implementing agreements under Section 287G of the Immigration and Nationality Act, 8 U.S.C. 1357G. 10, Victims of Immigration Crime Engagement Office, hiring and training additional staff to carry out the mission of the Victims of Immigration Crime Engagement Office and for providing non-financial assistance to the victims of crime perpetrated by aliens who are present in the United States without authorization. 11, Office of the Principal Legal Advisor, hiring additional attorneys and the necessary support staff within the Office of the Principal Legal Advisor to represent the Department of Homeland Security and Immigration Enforcement and Removal Proceedings. Section 100053, Appropriation for Federal Law Enforcement Training Centers. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for the Federal Law Enforcement Training Centers for fiscal year 2025 out of any money in the Treasury not otherwise appropriate, $750 million to remain available until September 30th, 2029 for the purposes described in subsection B and C. B, training. Not less than $285 million of the amounts available under subsection A shall be for supporting the training of newly hired federal law enforcement personnel employed by the Department of Homeland Security and state and local law enforcement agencies operating in support of the Department of Homeland Security. C, facilities. Not more than $465 million of the amount available under subsection A shall be for procurement, construction, and maintenance of improvements to training equipment for and related expenses of facilities to the federal law enforcement training centers. Section 100054, appropriation for the Department of Justice. In addition to amounts otherwise available, there is appropriated to the Attorney General for the Department of Justice for fiscal year 2025 out of any money in the Treasury not otherwise appropriated $3,330 million to remain available through September 30th, 2029 for the following purposes. 1, Executive Office for Immigration Review. A, in general, hiring immigration judges and necessary support staff for the Executive Office for Immigration Review to address the backlog of petitions, cases, and removals. B, staffing levels. Effective November 1, 2028, the Executive Office for Immigration Review shall be comprised of not more than 800 immigration judges along with the necessary support staff. 2, combating drug trafficking. Funding efforts to combat drug trafficking, including trafficking of fentanyl and its precursor chemicals and illegal drug use. 3, prosecution of immigration matters. Funding efforts to investigate and prosecute immigration matters, gang-related crimes involving aliens, children trafficking, and smuggling involving aliens within the United States, unlawful voting by aliens, violations of the Alien Registration Act, 1940, 54 Stat, Chapter 439, and violation of or fraud relating to Title IV of the Personal Responsibility and Work Opportunity Act of 1996, Public Law 104-193, 110 Stat 2277, including hiring additional Department of Justice personnel to investigate and prosecute such matters. 4, non-party or other injunctive relief. Hiring additional attorneys and necessary support staff for the purpose of continuing implementation of assignments by the Attorney General pursuant to Sections 516, 517, and 518 of Title 28 United States Code to conduct litigation and tend to the interests of the United States in suits pending in a court of the United States or in a court of the state in suits seeking non-party or other injunctive reliefs against the federal governments. 5, Edward Byrne Memorial Assistance Grant Fund and Office of Community-Oriented Policing. In general, increasing funds for the Edward Byrne Memorial Justice Assistance Grant Program and the Office of Community-Oriented Policing for initiatives associated with investigating and prosecuting violent crime. 2, criminal enforcement initiatives. And 3, immigration enforcement and removal efforts. B, limitations. No funds made available under the subsection shall be made available to community violence intervention and prevention initiative programs. C, eligibility. To be eligible to receive funds made available under the subsection, a state or local government shall be in full compliance as determined by the Attorney General with Section 642 of the Legal Immigration Reform and Immigrant Responsibility Act of 1996, 8 U.S.C. 1373. 6, fiscally responsible lawsuit settlements, hiring additional attorneys and necessary support staff for the purposes of maximizing lawsuit settlements that require the payment of fines and penalties to the Treasury of the United States in lieu of providing for the payment to any person or entity other than the United States, other than a payment that provides restitution or otherwise directly remedies actual harm directly in proximity caused by the party making the payment or constitutes payment for services rendered in connection with the case. 7, compensation for incarceration of criminal aliens. A, in general, providing compensation to a state or political subdivision of a state for the incarceration of criminal aliens. B, use of funds. The amounts made available under subparagraph A shall only be used to compensate a state or local subdivision of a state as appropriate with respect to the incarceration of an alien who, 1, has been convicted of a felony or 2 or more misdemeanors, and 2, 1, entered the United States without inspection or at any time or place other than designated by the Secretary of Homeland Security. 2, was the subject of removal proceedings at the time the alien was taken into custody by the state or a political subdivision of the state, or 3, was admitted as a non-immigrant and at the time the alien was taken into custody by the state or a political subdivision of the state had failed to maintain the non-immigrant status in which the alien was admitted or to which it was changed or to comply with the conditions of any such status. C, limitation. Amounts made available under the subsection shall be distributed to more than one state. The amounts made available under subparagraph A may not be used to compensate any state or political subdivision of a state if the state or political subdivision of the state prohibits or in any way restricts a federal, state, or local government entity, official, or other personnel from doing any of the following. 1, complying with the immigration laws as defined in Section 101A.17 of the Immigration and Nationality Act, 8 U.S.C. 1101A.17. 2, assisting or cooperating with federal law enforcement entities, officials, or other personnel regarding the enforcement of the immigration laws. 3, undertaking any of the following law enforcement activities as such activities relate to information regarding the citizenship or immigration status, lawful or unlawful, the admissibility or deportability, and the custody status of any individual. 1, making inquiries to any individual to obtain such information regarding such individual or any other individuals. 2, notifying the federal government regarding the presence of individuals who are encountered by law enforcement officials or other personnel of the state or political subdivision of a state. 3, complying with requests with such information from federal law enforcement entities, officials, or other personnel. Section 100055, Bridging Immigration-Related Deficits Experience Nationwide Reimbursement Fund. A, establishment. There is established within the Department of Justice a fund to be known as the Bridging Immigration-Related Deficit Experience Nationwide Biden Reimbursement Fund, referred to in this section as the fund. B, use of funds. The Attorney General shall use amounts appropriated or otherwise made available for the funds for grants to eligible states, state agencies, and units of local government pursuant to their existing statutory authorities for any of the following purposes. 1, locating and apprehending aliens who have committed a crime under federal, state, or local law in addition to being unlawfully present in the United States. 2, collection and analysis of law enforcement and investigation information within the United States to counter gang or other criminal activity. 3, investigating and prosecuting A, crimes committed by aliens within the United States, and B, drug and human trafficking crimes committed within the United States. 4, court operations related to the prosecution of A, crimes committed by aliens, and B, drug and human trafficking crimes. 5, temporary criminal detention of aliens. 6, transporting aliens described in paragraph 1 within the United States to locations related to the apprehension, detention, and prosecution of such aliens. 7, vehicle maintenance, logistics, transportation, and other support provided to law enforcement agencies by state agencies to enhance the ability to locate and apprehend aliens who have committed crimes under federal, state, or local law in addition to being unlawfully present in the United States. C, appropriation. In addition to amounts otherwise available for the purposes described in subsection B, there is appropriated to the Attorney General for fiscal year out of any money in the Treasury not otherwise appropriated, not to exceed $3.5 trillion to remain available until September, $3.5 billion to be remain available until September 30th, 2028 for the fund of qualified and documented expenses that achieve such purpose. D, grant eligibility for completed, ongoing, or new activities. The Attorney General may provide grants under this section to state agencies and units of local government for expenditures made by state agencies or local government for completed, ongoing, or new activities determined to be eligible for such grant funding that occurred on or after January 20th, 2021. Amounts made available under this section shall be distributed to more than one state. Section 100056, appropriation for the Bureau of Prisons. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of Bureau of Prisons for fiscal year 2025 out of any money in the Treasury not otherwise appropriated $5 billion to remain available through September 30th, 2029 for the purposes described in subsections B and C. Salaries and benefits, not less than $3 billion of the amount made available under subsection A shall be for hiring and training of new employees, including correctional officers, medical professionals, and facilities and maintenance employees, the necessary support staff, and for additional funding for salaries and benefits for the current workforce of the Bureau of Prisons. C, facilities, not more than $2 billion of the amount made available under subsection A shall be for addressing maintenance and repairs to facilitate, maintained, or operated by the Bureau. Repairs to facilities maintained or operated by the Bureau of Prisons. Section 10057, appropriation for the United States Secret Service. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the United States Secret Service, referred to in the section as the Director, for fiscal year 2025, out of any money in the Treasury not otherwise appropriate, $1.170 billion to remain available through September 30th, 2029 for the purpose described in subsection B. B, use of funds. Amounts made available under subsection A may only be used for 1, additional U.S. Secret Service resources, including personnel, training facilities, programming, technology, and 2, performance, retention, and signing bonuses for qualified United States Secret Service personnel in accordance with subsection C. C, performance, retention, and signing bonuses. 1, performance bonuses. The Director, at the Director's discretion, may provide performance bonuses to any Secret Service agent, officer, or analyst who demonstrates exemplary service. 2, retention bonuses. The Director may provide retention bonuses to any Secret Service agent, officer, or analyst who commits to 2 years of additional service within the Secret Service. 3, signing bonuses. The Director may provide a signing bonus to any Secret Service agent, officer, or analyst who, A, is hired on or after the date of the enactment of this act, and B, commits to 5 years of service within the United States Secret Service. 4, service agreement. In providing retention or signing bonus under the subsection, the Director shall provide each qualifying individual with a written service agreement that includes A, the commencement and termination dates of the required service period or provisions for the determination of such date, B, the amount of the bonus, and C, any other term or condition under which the bonus is payable, subject to the requirements under the subsection, including 1, the conditions under which the agreement may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in clause 1. Subtitle B, judiciary matters. I'm going to do that.
Section 100101, appropriation to the Administrative Office of the United States Courts. In addition to amounts otherwise available, there is appropriated to the Director of the Administrative Office of the United States Courts out of the amounts in the Treasury not otherwise appropriated $1,250,000 for each fiscal years 2025 through 2028 for the purpose of continuing analyses and reporting pursuant to Section 604A2 of Title 28 United States Code to examine the state of the dockets of the courts and to prepare the transmit statistical data and reports as to the business of the courts, including an assessment of the number, frequency, and related metrics of judicial orders issuing non-party relief against the federal government and their aggregate cost impact on the taxpayers of the United States, as determined by each court when imposing securities for the issuance of preliminary injunctions or temporary restraining orders against the federal government pursuant to Rule 65C of the Federal Rules of Civil Procedure. Section 100102, appropriation to the Federal Judicial Center. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the Federal Judicial Center out of amounts in the Treasury not otherwise appropriated $1 million for each of fiscal years 2025 through 2028 for the purpose described in subsection B. B, use of funds. The Federal Judicial Center shall use the amounts appropriated under subsection A for the continued implementation of programs pursuant to section 620B3 of Title 28 United States Code to stimulate, create, develop, and conduct programs of continuing education and training for personnel of the judicial branch, including training on the absence of constitutional and statutory authority, supporting legal claims that seek non-party relief against the federal government, and strategic approaches for mitigating the aggregate cost impact of such legal claims on the taxpayers of the United States. Subtitle C, Radiation Exposure Compensation Matters. Section 100201, Extension of a Fund. Section 3D of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended. 1, by striking the first sentence and inserting the fund shall terminate on December 31, 2028, and 2, by striking the end of that 2-year period and inserting such date. Section 100202, claims relating to atmospheric testing. A, leukemia claims relating to Trinity test in New Mexico and test in the Nevada site. Section 4A1A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 in Clause 1A and Subclause 1 by striking October 31, 1958 and inserting November 6, 1962. B in Subclause 2, 1 by striking in the affected area and inserting in an affected area, and 2 by striking or after the semicolon. C by redesignating Subclause 3 as Subclause 4, and D by inserting after Subclause 2 the following. 3, was physically present in an affected area for a period of at least 1 year during the period beginning on September 24, 1944 and ending on November 6, 1962, and 2 in Clause 2.1 of striking physical presence described in Subclause 1 or 2 of Clause 1 or on-site participation described in Clause 1.3 and inserting physical presence described in Subclause 1, 2, or 3 and Clause 1 or on-site participation described in Clause 1.4. B, amounts for claims relating to leukemia, Section 4A1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 in subparagraph A by striking an amount and inserting the amount. 2, by striking subparagraph B and inserting the following, B, amount. If the conditions described in subparagraph C are met, an individual who is described in subparagraph A shall receive $100,000, and 3, in subparagraph C, by adding at the end the following. 4, no payment under this paragraph previously has been made to the individual on behalf of the individual or to a survivor of the individual. C, conditions for claims related to leukemia, Section 4A1C of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 by striking Clause 1 and 2 by redesignating Clauses 2 and 3 as Clauses 1 and 2 respectively. D, specified diseases claims relating to the Trinity test in New Mexico and test at the Nevada site, Section 4A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 in subparagraph A by striking in the affected area and inserting in an affected area. B, by striking 2 years and inserting 1 year. And C, by striking October 31, 1958 and inserting November 6, 1962. 2 in subparagraph B, A, by striking in the affected area and inserting in an affected area, and B, by striking or at the end of inserting a semicolon. 3, by redesignating subparagraph C as subparagraph D, and 4, by inserting after subparagraph B the following. C, was physically present in an affected area for a period of at least 1 year during the period beginning of September 24, 1944, and ending on November 6, 1962. Or E, amounts for claims related to specified diseases, Section 4A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended in the matter following subparagraph D as redesignated by subsection D of this section. 1, by striking $50,000 in the case of an individual described in subparagraph A or B, or $75,000 in the case of an individual described in subparagraph C and inserting $100,000. 2, clause 1, by striking and inserting a semicolon. 3, in clause 2, by striking the period at the end and inserting and 4, by adding at the end the following. 3, no payment under this paragraph previously has been made to the individual or on behalf of the individual or to a survivor of the individual. F, downwind states, Section 4B1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended to read as follows. 1, affected area means A, except as provided under subparagraph B. 1, the states of New Mexico, Utah, and Idaho. 2, in the state of Nevada, the counties of White Pine, Nye, Lander, Lincoln, Eureka, and that portion of Clark County that consists of townships 13 through 16 at ranges 63 through 71. And 3, in the state of Arizona, the counties of Coconino, Yavapai, Navajo, Apache, Gila, and Mojave. And B, with respect to a claim by an individual under subsection A1, A1(3) or subsection A2C, only New Mexico, and Section 100203, claims relating to uranium mining. A, employees of mines and mills, Section 5A1A1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended to read as follows. 1, as employed in a uranium mine or uranium mill, including an individual who is employed in the transport of uranium ore or vanadium uranium ore from such mine or mill located in Colorado, New Mexico, Arizona, Wyoming, South Dakota, Washington, Utah, Idaho, North Dakota, Oregon, or Texas at any time during the period beginning on January 1, 1942 and ending on December 31, 1990, or 2, was employed as a core driller in a state referred to in a subclause 1 during the period described in such subclause, and B, minors, Section 5A1A21 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended by inserting or renal cancer or any other chronic renal disease, including nephritis and kidney tubal tissue injury after non-malignant respiratory disease. C, millers, core drillers, and ore transporters. Section 5A1A22 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1, by inserting core driller after was a miller, 2, by inserting or was involved in remediation efforts at such a uranium mine or uranium mill after ore transporter, 3, by inserting 1 after clause 1, and 4, by striking or renal cancers and all that follow and inserting or renal cancer or any other chronic renal disease, including nephritis and kidney tubal tissue injury, or D, combined work histories, Section 5A1A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 22 note, as amended by subsection C, is further amended 1 in subclause 1 by striking or at the end, and 2, by adding at the end the following. 3AA does not meet the conditions of subclause 1 or 2. BB worked during the period described in clause 1, or in 2 or more of the following positions: miner, miller, core driller, and ore transporter. CC meets the requirements under paragraph 4 and 5. And D, submits written medical documentation that the individual developed lung cancer, a non-malignant respiratory disease, renal cancer, or any other chronic renal disease, including nephritis and kidney tubal tissue injury, after exposure to radiation through work in 1 or more of the positions referred to in item B. E, special rules relating to combined work histories, Section 5A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, as amended by adding at the end the following. Special rule 4, special rule relating to combined work histories for individuals with at least 1 year of experience. An individual meets the requirements under this paragraph if the individual worked in 1 or more of the positions referred to in paragraph 1A23BB for a period of at least 1 year during the period described in paragraph 1A11. 5, special rule relating to combined work histories for minors. An individual meets the requirements of this paragraph if the individual during the period described in paragraph 1A11 worked as a minor and was exposed to such number of working level months that the Attorney General determines, when combined with the exposure of such individual to radiation through work as a miller, core driller, or transporter during the period described in paragraph 1A11, results in such individual being exposed to a total level of radiation that is greater or equal to the level of exposure of an individual described in paragraph 4. F, definition of core driller. Section 5B of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended. 1, in paragraph 7 by striking and at the end. 2, in paragraph 8 by striking the period at the end and inserting and 3, by adding at the end the following. 9, the term core driller means any individual employed to engage in the act or process of obtaining cylindrical rock samples of uranium or vanadium by means of a borehole drilling machine for the purpose of mining uranium or vanadium. Section 100204, claims relating to Manhattan Project waste. The Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended by inserting after Section 5 the following. Section 5A, claims relating to Manhattan Project waste. A, in general, a claimant shall receive compensation for a claim made under this act as described in subsection B or C if 1, a claim for compensation is filed with the Attorney General, A, by an individual described in paragraph 2, or B, on behalf of that individual by an authorized agent of that individual if the individual is deceased or incapacitated, such as 1, an executor of estate of that individual, or 2, a legal guardian conservative of that individual. 2, that individual, or if applicable, an authorized agent of that individual demonstrates that such individual, A, was physically present in an affected area for a period of at least 2 years after January 1, 1949, and B, contracted a specified disease after such period of physical presence. 3, the Attorney General certifies that the identity of that individual, and if applicable, the authorized agent of that individual is not fraudulent or otherwise misrepresented. And 4, the Attorney General determines that the claimant has satisfied the applicable requirements of this act. B, losses available to living affected individuals. 1, in general, in the event of a claim qualifying for compensation under subsection A that is submitted by the Attorney General to be eligible for compensation under this section at a time when the individual described in subsection A2 is living, the amount of compensation under this section shall be in an amount that is greater of $50,000 or the total amount of compensation for which the individual is eligible under paragraph 2. 2, losses due to medical expenses. A claimant described in paragraph 1 shall be eligible to receive upon submission of contemporaneous written medical records, reports, or billing statements created by or at the direction of a licensed medical professional who provided contemporaneous medical care to the claimant, additional compensation in the amount of all documented out-of-pocket medical expenses incurred as a result of the specified disease suffered by that claimant, such as any medical expenses not covered, paid for, or reimbursed through A, any public or private health insurance, B, any employee health insurance, C, any workers' compensation program, or D, any other public, private, or employee health program or benefit. 3, limitation. No claimant is eligible to receive compensation under this subsection with respect to medical expenses unless the submission described in paragraph 2 with respect to such expenses are submitted on or before December 31, 2028. C, payments to beneficiaries or deceased individuals in the event that an individual described in subsection A2 who qualifies for compensation under subsection A is deceased at the time of submission of the claim. 1, a surviving spouse may, upon submission of a claim and records sufficient to satisfy the requirements of subsection A with respect to the deceased individual, receive compensation in the amount of $25,000, or 2, in the event that there is no surviving spouse, their surviving children, minor or otherwise, of the deceased individual may, upon submission of a claim and records sufficient to satisfy the requirements of subsection A with respect to the deceased individual, receive compensation in the total amount of $25,000 paid in equal shares to each surviving child. D, affected areas. For purposes of this section, the term affected area means 1, in the state of Missouri, the zip codes of 63031, 63033, 63034, 63042, 63045, 63074, 63114, 63135, 63138, 63044, 63121, 63140, 63145, 63147, 63102, 63304, 63134, 63043, 63341, 63368, and 63367. 2, in the state of Tennessee, the zip codes of 37716, 37840, 37719, 37748, 37763, 37828, 37769, 37710, 37845, 37887, 37829, 37854, 37830, and 37831. 3, in the state of Alaska, the zip codes of 99546 and 99547, and 4, in the state of Kentucky, the zip codes of 42001 and 42003 and 42086. E, specified disease. For purposes of this section, the term specified disease means any of the following. A, 1, any leukemia, provided that the initial exposure occurred after 20 years of age and the onset of the disease was at least 2 years after the first exposure. 2, any of the following diseases, provided that the onset was at least 2 years after the initial exposure. A, multiple myeloma. B, lymphoma other than Hodgkin's disease. C, primary cancer of the 1, thyroid. 2, male or female breast. 3, esophagus. 4, stomach. 5, pharynx. 6, small intestine. 7, pancreas. 8, bile ducts. 9, gallbladder. 10, salivary gland. 11, urinary bladder. 12, brain. 13, colon. 14, ovary. 15, bone. 16, renal. 17, liver, except if cirrhosis or hepatitis B is indicated, or 18, lung. F, physical presence. 1, in general. For purposes of this section, the Attorney General may not determine that a claimant has satisfied the requirements under subsection A unless demonstrated by submission of A, contemporaneous written residential documentation, or at least one additional employer-issued or government-issued document or record that the claimant, for at least 2 years after January 1, 1949, was physically present in an infected area, or B, other documentation determined by the Attorney General to demonstrate that the claimant, for at least 2 years after January 1, 1949, was physically present in an affected area. 2 types of physical presence. For purposes of determining physical presence under this section, a claimant shall be considered to have been physically present in an affected area if A, the claimant's primary residence was in the affected area, B, the claimant's place of employment was in an affected area, or C, the claimant attended school in the affected area. G, disease contraction in affected areas. For purposes of this section, the Attorney General may not determine that a claimant has satisfied the requirements under subsection A unless the claimant submits 1, written medical records or reports created by or at the direction of a licensed medical professional, created contemporaneously with the provision of medical care to the claimant, that the claimant, after a period of physical presence in an affected area, contracted a specific disease, or 2, other documentation determined by the Attorney General to demonstrate that the claimant contracted a specific disease, specified disease after a period of physical presence in an affected area. Section 100205, limitations on claims, Section 8A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended by striking 2 years after the date of enactment of the RECA Extension Act of 2022 and inserting December 31, 2027.
Mr. President.
I recognize the Majority Leader.
Thank you, Mr. President. Mr. President, I would like to start by just taking a moment to thank the clerks who stayed up all night reading the amendment and getting us to this point. I know it was a long night and that we're not finished yet, but I want them to know that the Senate appreciates their dedication, their stamina, and their service. In just a moment, I'm going to make a point of order against the substitute amendment that I offered on behalf of Chairman Graham. I believe the chair should rule that there is no point of order against the amendment because the Budget Act, under the Budget Act, I should say, the Senate looks to the Budget Committee to assess the budgetary effects of an amendment. Basically, this has to do with the current policy baseline that we decided to use in the budget resolution for this bill and how we handle points of order related to it. This is an issue that I think we need to deal with right off the bat. Therefore, I make a point of order under Section 313B1E of the Congressional Budget Act against the substitute amendment number 2360.
Under the Congressional Budget Act and the precedents of the Senate, the chair must rely on determinations made by the Budget Committee in assessing the budgetary effects of the amendment. Section 312 of the Budget Act states, for the purposes of this title and Title IV, the levels of new budgetary authority, outlays, direct spending, new entitlement authority, and revenues for a fiscal year shall be determined on the basis of estimates made by the Committee on the Budget of the House of Representatives or the Senate as applicable. Unless the Budget Committee, speaking through its chairman, asserts that the amendment causes a violation of the Budget Act, the chair will not so hold. The point of order is not well taken.
Mr. President.
I recognize the Democrat leader.
I appeal the ruling of the chair, and I ask for the yeas and nays.
The yeas and nays are ordered. The appeal is debatable for 1 hour under this act. Sorry, is there a sufficient second? There appears to be. The yeas and nays are ordered.
Mr. President.
I recognize the Democrat leader.
Mr. President, first, let me thank everyone who stayed overnight to take part in the reading of this bill. My colleagues, the cloakrooms, the floor staff, everyone who made it possible. I would say this to the cloakrooms and particularly our great floor staff. You are all amazing. You're the unsung heroes of what goes on here. Without you, none of us could do our work. So thank you for your dedication, your excellence, your perseverance, your strength. Now, Senate Democrats will now commence 4 parliamentary inquiries to show the hypocrisy of what Republicans are trying to do here in the Senate, and to expose how they're trying to hide the true costs of their billionaire giveaways to the American people. I thank my colleagues who will speak momentarily, as well as all of my colleagues who have come to the floor as we debate this bill before Vote-A-Rama. So before I yield to them, I just want to hammer home exactly what is going on here in the Senate for the people back home. Republicans are about to pass the single most expensive bill in U.S. history to give tax breaks to billionaires while taking away Medicaid, SNAP benefits, and good-paying jobs for millions of people. CBO just this morning said it will explode the debt by $3.3 trillion. And they said it will likely cost more over time. More than that, closer to $4 trillion. Rather than be honest with the American people about the true costs of their billionaire giveaways, Republicans are doing something the Senate has never done before, deploying fake math and accounting gimmicks to hide the true cost of their bill. Look, Republicans can use whatever budgetary gimmicks they want to try and make the math work on paper, but you can't paper over the real-life consequences of adding tens of trillions to the debt. Sky-high interest rates, higher borrowing costs for cars, for homes, for credit cards. Americans are going to feel this, unfortunately, everywhere they look. Americans' household wealth will be permanently hobbled. There aren't enough budgetary gimmicks in the world to change that fact. And for what? Why are Republicans doing this? So that billionaires can pay less in taxes while tens of millions lose their health care benefits and pay more for everyday expenses. I now yield to my colleague from Oregon for the first parliamentary inquiry.
Mr. President.
I recognize the senator from Oregon.
Parliamentary inquiry.
The senator will state his inquiry.
When the House bill was first laid before the Senate, was the operative baseline under which it would be considered the current law baseline under Section 257 of the Balanced Budget and Emergency Deficit Control Act of 1985?
Yes.
Thank you.
I recognize the Democrat leader.
I rise for a parliamentary inquiry.
The senator will state his inquiry.
Has the Senate ever used a baseline other than current law baseline under 257 for enforcement of budget points of order, including under Section 313 of the Budget Act, during the consideration of a reconciliation measure? Has it ever been used?
No.
Mr. President.
Recognize the senator from Oregon.
Mr. President, when the Republican majority is going to the floor, what they're doing is hiding trillions of dollars in handouts to corporations and the wealthy. Trillions of dollars. If you measure this bill the way we measure every other reconciliation bill, it simply doesn't comply with the rules. But the Republican majority has figured out a trick that allows them to sidestep the parliamentarian, violate the Congressional Budget Act, and lift the filibuster for Trump's entire legislative agenda in one fell swoop. It is fakery. The budget numbers are a fraud, but the deficits will be very real. The prospect of a catastrophic debt spiral is very real. The hardship this terrible bill is going to inflict on tens of millions of Americans will be very real. So my parliamentary inquiry will proceed now. Does the score of the finance title of the Senate substitute, which the chairman asserts complies with its instruction, rely on the use of two distinct baselines, current policy for taxes and current law for health provisions like Medicaid?
Yes. I recognize the senator from Washington.
Mr. President, parliamentary inquiry.
The senator will state their inquiry.
Are the remaining 9 titles of the Senate substitute scored by CBO using a current law 257 baseline?
Yes.
Mr. President.
I recognize the senator from Washington.
Mr. President, I've been here a long time. Not only have I been the budget chair, I am the longest serving Democrat on that committee. And in my 33 years here in the United States Senate, things have never worked this way, where one party so egregiously ignores precedent, process, and the parliamentarian, and does that all in order to wipe away trillions of dollars of costs for a bill that could just be the most expensive legislation this body ever passes. Forget Senate procedure for a minute. Math, Mr. President, has never worked that way. I taught preschool, and I'll tell you, even our littlest kids knows the difference between a trillion and 0. It doesn't take a preschooler to tell you they're using magic math, or that you can't just ignore the rules you don't like. How many times have my colleagues cried about the debt? How many times have they told me, I know you want to invest in childcare, Patty, but we got to get this budget under control. But now that it's tax cuts for billionaires and corporations, suddenly the budget doesn't matter anymore. Suddenly the rules do not matter anymore. Suddenly a couple trillion goes away with a sprinkle of fairy dust. And bypassing the parliamentarian and president isn't really bypassing if you just close your eyes and just pretend real hard. Have you no shame? If you think you can look the American people in the face and tell them we have to bring down the debt after passing what might be the most expensive bill in history, if you think you can do that and then be taken seriously, well, you know what? If you believe that, maybe you are foolish enough to think that 0 and a trillion are the same. Mr. President, I can't believe this is what we're doing today, because I can tell you right now, if this happens, we will all laugh you out of the room, because we have never seen anything like this. Not in my time here in the Senate, not in my time on this planet. We are not going to let anyone forget that you're trashing the rules in order to pass this egregious bill. I yield the floor.
Mr. President.
I recognize the senator from Oregon.
Thank you. I want to share a couple comments with my colleagues, including my Republican colleagues, because I've made these points on the floor, but generally the floor is empty, and some of you are here now. In 1974, 100 senators agreed on reconciliation as a fast-track, filibuster-free, but only for one purpose, reducing the deficit. It had 3 pillars: reduce the deficit over a 10-year period. Second, reduce the deficit in each and every year after that 10-year period, in each title of the bill. And third, use honest numbers. In 1996, the Republican team was in the majority and decided on a nuclear option to allow that reconciliation process to be used to increase deficits in the 10-year window. That was unfortunate because it destroyed the agreement all 100 senators had agreed to in 1974. But now, today, if we proceed with this current policy baseline, there's 2 other pillars that you're destroying of the architecture to create fiscal discipline. The second pillar was no deficits after the 10-year period. That's being destroyed. And the third was to use honest numbers from the Congressional Budget Office on a current law basis, comparing each provision in the bill as compared to the provision not being in the bill. So here we are, taking a step that is as significant as it was in 1996. All 3 pillars will be brought down, not by Democrats, but by Republicans. It's not necessary to do this to get what you want within the 10-year period. Why tear down these additional 2 pillars of honesty about the numbers, no more smoke and mirrors, and creating deficits after the 10-year period. It's extremely unfortunate if you press forward with that vision in this bill. President.
Mr. President,
I recognize the senator from Oregon.
I want to pick up on the point that my colleague from Washington State touched on. Everybody ought to understand this is the nuclear option. It's just hidden behind a whole lot of Washington, D.C. lingo. The only difference is instead of pressing a big nuclear button right at the beginning of the Congress, Republicans decided that they'd hide behind a cloak of Senate procedure and go nuclear for every individual bill they want to pass on party lines. And I just say to my colleagues, there's going to be a lot of horrendous messes to clean up after this legislation. But my colleagues need to understand the moves, as my colleague from Washington State has said, cut both ways. I yield the floor.
Mr. President.
I recognize the Democrat leader.
I ask that debate time come off the bill unless otherwise advised.
Without objection.
Mr. President.
I recognize the senator from Rhode Island.
In this place where big money now rules and in which fakery is now the order of the day and numbers no longer have to be real, there is one point that stands out, and that is that the fakery on the floor is belied by the language of the bill. If these assertions were true, they would not need to raise the debt limit. All of this fun and games, all of this parliamentary mischief that is happening right now crashes into the fact that in real markets, in the real world, outside of this fakery, the debt limit is actually a real thing. And I will take a moment to read from page 754 of this midnight monstrosity what it actually says where it collides with the real world. Subtitle C, Increase in Debt Limit. Section 72001, Modification of Limitation on the Public Debt. Line 20. The limitation under Section 3101B of Title 31 United States Code, as most recently increased by Section 401B of Public Law 118.5, 31 U.S.C. 3101 Note, is increased by $5 trillion. $5 trillion. That's the real number here. That's where the rubber hits the road in real life. The maneuver that is being pulled right now to avoid that fact, the fact that the debt limit has to be increased by $5 trillion so that Republicans can give immense tax breaks to billionaires, has not been used for this before. I used it once. In the year 2000, a deal had been struck on how to score activities of the Power Marketing Administration. Does anybody really know about the Power Marketing Administration? It's a small thing. Over the years, the Congressional Budget Office started scoring the program differently than the Senate had agreed to in 2000. So in 2023 and 2024, Senate Budget Chair, me, and the House Budget Chair, Jody Arrington, on a bipartisan basis, invoked this section to have CBO return to the original Senate agreement and not the variation that they had created. This is what Section 312 has been used for, to resolve technical ambiguity, to advance a bipartisan appropriation deal, not to create Senate floor fakery belied by the $5 trillion debt limit hike that Republicans are obliged to pass to make good on this huge billionaire blowout that we're forcing through the Senate floor now. I yield the floor.
I recognize the senator from South Carolina.
I am using and yielding time off the bill.
Without objection.
Okay, thank you very, very much. So the debate and eventual voting on the big, beautiful bill has begun. Hallelujah. It's taken a while for us to get here, but we're going to have a debate worthy of a great country. We'll have what they think and what we think, and we're going to vote on this bill in the coming days, and I'm excited about that. I've worked a long time with my colleagues to get to where we are today. So to the American people, the debate is beginning right now regarding the big, beautiful bill, and I'll tell you why that's good news for you, but let me take a little bit of time to talk about current policy versus current law. I know everybody's on the edge of their seat at home, but here's what I would tell you about numbers and budget chairmen. I'm not the first budget chairman. There have been those who came before me. In 2008, Chairman Kent Conrad, a really nice guy from North Dakota, used a new baseline in the budget so he could get the farm bill in the budget. And Judd Gregg, really smart guy, former budget chairman, said the chairman of the budget committee declared the new baseline under a new budget. The budget chairman has a right to do that. That's what I'm doing. I'm setting the numbers. The parliamentarian said, that's my job as budget chairman. The resolution we're operating under to get us here, we voted to make that the case. So we're not doing anything sneaky. We actually voted to give me the authority to do this, and it passed. But again, I'm not the first chairman to change a baseline for different reasons. One, to get the farm bill in, and another occasion, Senator Sanders changed the baseline in 2022 when he was budget chairman under budget reconciliation to issue a budget rule allowing the numbers to change to get more money for Head Start. So Senator Sanders, as budget chairman, directed a new rule be written to get more money for Head Start. So don't tell me you've never done this before in terms of changing the baseline as budget chairman. The budget chairman under 312 sets the baseline. This has been acknowledged by Republicans and Democrats. The baseline has changed in the past based on the budget committee chairman's desire, one to get a farm bill in, and the other to change the numbers, a new rule to get Head Start spending. So this has been done before. But I'll be the first to say that what we're doing here is historic in a good way. In 2017, we passed the Trump tax cuts. They're due to expire in December. Why is that? Before I got here, current law was the way to score or implement tax policy. After 10 years, the tax cuts expired, current law. As budget chairman, I've decided to use current policy when it comes to cutting taxes. If you use current policy, they never expire. So the policies that were created in 2017 would not end in December. They would continue. And that's a good thing for the American people. That's a good thing for the economy because it gives you certainty. So I made a decision as budget chairman, working with my colleagues, to look at tax cuts, something important for the country, to give certainty to businesses and individuals, and make sure after 10 years they don't arbitrarily go away and have a cliff. So I made that decision. My colleagues backed me up, and that's in the budget resolution governing the debate that we're here today. So why do we want to make the tax cuts permanent? because if they expire in December, the average family of 4 in South Carolina will have a $1,700 increase. I don't want that, and I bet you people at home don't want that. So we have to deal with that. That cliff is coming, and not only do I want to avoid that cliff, I don't want to put us in that position ever again. So the tax cuts have generated more revenue for the government than CBO estimated in 2017. The one thing about our friends at CBO, I appreciate all your hard work, you've worked really hard. When it comes to taxing, they always get it wrong about how much revenue to be collected. So when you look at the years that have passed since 2017, on the corporate side, on the individual side, the revenue to the government has actually grown because of those tax cuts, and that's a good thing. So cutting taxes means more money for you and your family. Our friends on the other side, if you're waiting on them to cut your taxes, you're going to die waiting. So they're never going to do it. Why are we doing it? Because they won't do it. We could never get 60 votes for this. So the bottom line is we're going to make these tax cuts permanent, and that's a good thing for businesses. Expensing will be allowed so you can invest and grow in your business. You can buy new equipment. You can write it off sooner, and that will get more activity in the economy. It's not me saying that. There's a track record, Mr. President. You've been in business. This stuff works. They don't like it, but it works. If you're in business and the tax code encourages you to invest in your business, you will. This stuff literally works. And they hate it because it's money that could have gone to the government went back into the economy. What they don't realize, actually, the government gets more money. They just keep spending it. And we could do better on the spending side. And we are going to do better on the spending side. So this bill makes the 2017 tax cuts permanent. It avoids a tax increase for your family that's coming in December if we don't act now. It secures the border. One of the reasons there are more of us than our Democratic friends is how you screwed the country up for the last 4 years. We went from secure borders to completely open borders, absolute chaos, and that's why we're winning and you're losing. And you want to take us back to open borders. We're not going. We're not going back to your policies that allowed 8.3 million encounters at the border, 1.7 million gotaways, chaos to cities and communities. We're not going back to the policies that led to Laken Riley's murder in Georgia, where the man convicted for murdering her was captured several times, released because there was no detention space to hold him in Texas, and he left a free man, went to Georgia and killed this lady. That's happened too many times, and it's going to stop. Now, what are we doing to secure the border? We went from lawless borders to the most secure borders in 6 months because of President Trump. President Trump, you should be exceedingly proud. Holman, the whole team, you've locked that border down, but we want to do it in a way that it'll stay locked down for the president after you and beyond. So how do we secure the gains made by President Trump and his team? We're going to, in this bill, hire more ICE agents to expedite removal of people that shouldn't be here, particularly criminal elements, people that are dangerous. We're going to finish the wall. Not one Democrat, maybe one, no way would get 60 votes to hire more ICE agents. No way we would get Democratic help to finish the wall. And we're going to go from 40,000 detention beds to 125,000. This secure the border is about $175 billion. New technology along the border, fiber cable, so we don't go back to the days of open borders. This is in the bill. To those of you who voted for us and President Trump to secure the border, we're delivering through this bill. And they would never do what we're doing. I'll be the first to admit, when it comes to securing the border, they're never going to do what we're doing. We're hiring more ICE agents. We're finishing the wall. and we're increasing more detention beds so we don't let people out that can go and murder. I'm very proud of this. I wrote this part. This is money well spent. This will secure that border in perpetuity. President Trump, this is your plan. It is in our bill. Well done. To my friends on the other side, you had your chance and you screwed it up big time, and that's why we're in charge. Revitalize our military. The world is a dangerous place. We have $150 billion in this bill to help build out the Golden Dome, to help improve the quality of life of men and women serving in the military by improving their barracks and housing. They need the money, more weapons. It's in this bill, and we didn't have to get extorted to buy a bunch of butter to get $150 billion. We reduce government spending over a decade by $1.6 trillion. We're running deficits, national debt of $37 trillion. So what have we done here? In the last 5 years, from 2020 basically to now, Medicaid has grown by 50%. So what's happened is that Medicaid was originally intended for children and poor families, children and people who were disabled and couldn't work to provide health care. Count me in for that, makes a lot of sense. Along comes President Obama. He expands Medicaid to include able-bodied adults for the first time. And what he did was he incentivized states to include these people in Medicaid. For every new able-bodied adult, you get 90% of the cost from the federal government, 10% from the states. And Medicaid has grown 50%, is going to take over Medicare because of what President Obama did. So what are we going to do? We're going to try to deal with that in a responsible way. What about this idea? If you're not a child, if you're not disabled, you're able-bodied, and you don't have any children under 14, we're going to have a 20-hour-a-week work requirement for you to stay on Medicaid. That's a good thing. It's a good thing for the individual involved to be working. It's a good thing for the taxpayer for them to be working. But that seems to be a crime on the other side, to ask somebody to work that can work. How many people out there are listening to this? I don't know how many you are, but are you working every day? Are you going to work with kids? A lot of people do that, by the way. So one of the reforms in this bill is to introduce a work requirement to the additional population that President Obama put on Medicaid that was never intended on the original purpose of Medicaid. This work requirement is going to save a bunch of money. Finally, we're addressing the biggest scam I've seen in a very long time. Somewhere along the line, somebody figured out that at the state level, that if you tax doctors and hospitals and medical providers on the funds they get and take that revenue, you can actually get more Medicaid money. This is a money laundering scheme. It needs to come to an end as we know it. States have gone up to 6% of a provider tax. They take that tax revenue and they use it to get more money from the federal government. The hospitals and doctors don't lose, they get the money back. The state doesn't lose, they get more money. The only group that loses is the federal government, and we're deep, deep in debt. So we're going to reform the provider tax system that I think is abusive, very abusive. As to Medicaid, it's on a growth trajectory that will overtake Medicare. Now is the time to put common sense reform in place, not only to slow the growth, and we're not talking about cutting Medicaid, we're slowing the growth, but try to create some sense of fiscal responsibility. So to our chairman of the Finance Committee, you have constructed a package better than 2017. You've included some growth elements in the package that will allow the economy to grow because it will be in businesses' interest to invest. And I want to applaud you for this growth package. Now, what does this all mean? Current policy, current law. If you do what I have decided to do, make the tax cuts permanent, and you implement these reforms to Medicaid in other areas, you will, over the next 10 years, reduce the deficit by $507 billion. That's CBO, not me. Now, how do you do that? You grow the economy, and you begin to control spending in a common sense way. Most people can relate to that because they do it all the time. People at home sometimes have to work extra to meet the needs of their family, and they have to tighten their belt. So what have we achieved here in the one big beautiful bill? We're going to make your border as secure as it possibly can be and never go back to open borders. We're going to put in place border security measures to keep it secure. We're going to make the tax cuts permanent so your taxes do not go up in December of this year, and we're going to add additional pro-growth policies to help our economy. We're going to reform Medicaid in a way that makes sense, deal with the waste, fraud, and abuse of that program so that there's more money for the disabled and children, because the more money you give the able-bodied who can work, it's less money for children and people on disability. And one of the most perverse things about what President Obama did is that the reimbursement rates to states are higher for able-bodied adults than they are for disabled people and children. 90%. So President Obama created a system to entice states, lure them in to add people to Medicaid that are not disabled, not poor children, because his goal was to put everybody in the country under government-run health care, and the government reimbursement is higher for an able-bodied person than it is for a poor child or a disabled person. And we're going to stop that, because that's not fair. It's not fair to the taxpayer, and it's not fair to the population that we're trying to help. So we're going to control spending in a common sense way. We're going to revitalize our military at a time of great need. We're going to secure the border, and we're going to make the tax cuts that expire in December permanent so we don't have to deal with this every 10 years. It's a big, beautiful bill if you believe in cutting people's taxes, securing the border, having a strong military, and controlling government spending. It is a nightmare, this bill, for those who want to raise taxes, who want open borders, who want a weak military, and never want to control one dime of federal spending. This bill is your nightmare if you're for open borders. This bill is your nightmare if you want the government to grow without any limitation. This bill is your nightmare if you want a weak military, because it's going to give us a stronger military. So why do we have this debate? That's what they, through years of effort, have done. The military is always the last thing that gets funded when they're in charge. When they're in charge, you have no border. Completely broken, millions of people running through our country, lawless. When they're in charge, there is no limit to growing the government. They entice everybody to grow the government. And when they're in charge, they're never going to cut your taxes in any meaningful way. The tax rates since 2017, the top rate has been 37. If these tax cuts expire, Your taxes, if you're a family of four, will go up by $1,700. And we'll go back to the 39.6 rate. Here's a question for the country. How much should the federal government take of anybody's income? What's a fair share? 37% seems pretty damn fair to me. Over a third of what you make, and that doesn't count state and local taxes. The number they would pick is probably a 90. So is 37% fair? I think yes. Most Americans think 25% is fair. You know, Jesus wants 10%. There is no number they won't embrace. So somewhere between 90 and 10, 37 is fair. This is not rewarding the wealthy, it's creating a number that makes sense. 37% going to the federal government is a fair share. It's over a third of what you make. And that doesn't count state and local taxes. This has been long, it's been hard, but we're about done. In a couple of days, we're going to pass the one big beautiful bill. President Trump's going to sign it. Mike Crapo and his staff deserve at least one day off. I cannot thank you enough for what you and your team have done. To my budgeteers, you have been terrific. You've worked really hard. To CBO and Joint Tax and all these people, hats off to your efforts to get us a quality product. To all of my colleagues who've rowed the boat with us, we're about to reach the shore. And when this boat comes ashore, every family in America can have a sigh of relief. Your taxes will not go up this December. You'll get a Christmas present of not having a tax increase. To those who've been yearning for a secure border, it will be secure. To those men and women in uniform, you're going to get some help and you desperately need it. And to those who think we should do something about the government's growth in a common sense way, we've achieved that. I am very proud of this bill. I'm very proud of President Trump. I'm very proud of the Republican team that has gotten us to this point. And to my Democratic colleagues, we'll work together where we can. But nobody over here ever expects you to do anything about the border because you've proven you can't. Nobody over here believes you're ever going to reduce the size of government because you don't want to. So the bottom line is we're about to make history, Mr. President. This is your first term. I don't know what comes later for you. I hope you're here a long time if that's what you want to be. You're a great senator. You're a good businessman. You've made a real success story. Family from Columbia. You've created a lot of job opportunity. I doubt if you'll ever do anything more important than this. Senator Crapo, you've been here a while. You're one of the smartest guys I've ever met. Everything you've done all your life has led to this moment. This is what you were built to do. This is what you were meant to do. You're the right man at the right time to do what this country desperately needs to stay on track to be safe and prosperous. To all my colleagues who are going to vote for this bill, you should be proud and you should talk about it because it's going to make us all safer and it's going to make us all more prosperous. Me being budget chairman is a quirk in the history of the Senate. This is not my thing normally, but I have really gotten into it. And I've learned a lot thanks to my colleagues, and I'm proud to have the honor of being budget chairman at a time I think it matters the most. Mr. President, I ask unanimous consent that the following staff members from my staff and from Senator Merkley's staff be given all access floor passes for the consideration of the bill. Caitlin Wilson, Lillian Meadows, Scott Graber, Walker Turlock, Taylor Reedy, Democratic staff Mike Jones, Melissa Pistner, Josh Smith, and Tyler Evilsizer. Tyler, Evilsizer. I ask that unanimous consent.
Without objection.
With that, I will yield to my good friend from Idaho.
There's one more behind it.
Huh? Oh, wait a minute.
Nope.
That the use of calculators, whatever they are, be permitted on the floor of the Senate during consideration of the bill.
Without objection.
Mr. President.
I recognize the senator from Idaho.
Thank you, Mr. President. And first of all, let me thank my colleague from South Carolina, Senator Graham, for his very kind words. I return the same kind of compliments to him for his great work in helping to build this bill and get us moved to this point. I'm going to make just a few remarks right now in response to some of the allegations and mischaracterizations that my colleagues on the other side have made about how this bill has been structured in terms of its evaluation and scoring. And then later, I'm going to come and give a much longer speech, sorry, sir, on the bill itself. But the things that were said this morning just have to be responded to. First of all, it is said that the reason that we are going to increase the debt ceiling in the bill is because we are spending so much money and driving the deficit up. Well, first of all, our bill drives the deficit down, not up. And secondly, the reason we are dealing with the debt ceiling in the bill is because under the previous administration's operations, the debt ceiling has already been breached. It was breached on January 2nd. And we are limping along with extraordinary measures, is what we call them here in Washington, to try to keep the government funded until Congress can extend the debt ceiling. This has nothing to do with President Trump. It happened before he even was sworn into office. It has nothing to do with this bill. It has to do with the profligate spending that drove us into a breach of the debt ceiling on January 2. Secondly, my colleagues on the other side try to characterize our choice of the current policy baseline as a gimmick and said it's never been done before. Well, they should have been more careful in their words, because the current policy baseline is currently utilized in the current CBO baseline for many spending programs. In fact, many spending programs, about $2.5 trillion of spending programs, are measured under the current treatment, which the Democrats have been using for decades, to make it so they don't have to count spending increases as an increase in the deficit. They are correct that that policy has never been applied to taxes before, because it was not intended to apply to taxes. That ruling and that system that was set up was intentionally designed to favor tax increases over spending cuts and to force Congress to increase taxes and increase spending. It was a strategy to achieve what we all know of as tax and spend. And no matter how they try to cover it over today in their debate, it comes down to this. They are furious that we refuse to raise taxes in America by $4.3 trillion on Americans. And they claim that our refusal to raise your taxes, America, is going to run up the deficit because they can't get $4 trillion more of your tax revenue into their pockets. Well, the first failure of that rationale is, if you believe that you give them $4.5 trillion by letting them raise your taxes again, if you believe they're going to use that to pay the debt down, let me tell you, there's not a tax increase that I've seen in this Congress in my lifetime that was used to pay the debt down. It was used to increase spending. It's called tax and spend. And it's that bias in our scoring system that we are fixing today. We are fixing it so that current policy is how you treat taxes, just like you treat $2.5 trillion of spending this year in your scoring system. We're evening the balance board between taxing and spending. And America should sigh a sigh of relief that finally we are fixing our scoring procedures so that we don't have a built-in drive to increase taxes. Let's put it another way. One of my colleagues said, you know, just even children can understand the difference between $1 trillion and $0. I think they can also understand that if you don't raise taxes, you're not changing the tax code. You're making it bring in the same revenue that it brought in before. You're not increasing the deficit, you're protecting their wallets. And the bottom line here is very simple. I think every American, at least 90% of them, intuitively understand that the refusal to let your taxes go up by $4 trillion is not a deficit increase. You are not the responsible. Us keeping your money in your pocket is not making you responsible for increasing the deficit. Deficit increases come when Congress keeps spending your money and never, ever controlling its spending. The problem is not a lack of revenue. It is too much spending. So let's make it clear. This is not a gimmick. The gimmick is the one that's been used for all these years. We're making a balance between the treatment of tax and spend so that those taxpayers in America have at least a fair chance against the rules of this chamber. Now, one other thing that I think needs to be made here is there was a lot of talk on the other side, and then I'll stop and bring my longer speech later. One other point that needs to be made here is it was suggested that this has never been done before, even on taxes. Well, there's a president named President Obama who faced a similar situation like we face today. Only then, he was president when a huge tax cut that President Bush had accomplished was expiring. And all of those tax cuts that President Bush had been able to achieve were going to go away, and everybody's taxes were going to go up. And President Obama said, no, I'm not going to let that happen. So he put a bill out on the floor to stop those tax increases from happening. And he was attacked, actually, for increasing the deficit by not letting taxes go up. And President Obama, through his OMB deputy director, said that keeping tax policy current should be scored under a current policy, and that if his act in letting those tax increases be kept in place should be scored as current policy, not as a tax increase. So you've got one of your own presidents from the Democratic Party saying that letting existing tax law stay in place and protecting against huge tax increases on the American people is the appropriate approach to take, that current policy, and those are their words, current policy is the way we should treat tax policy. So I say to everybody in America who's been hearing all of the politics of fear about what we're doing here and running up the deficit, need to remember that only in Washington, D.C. is the refusal to raise your taxes an increase in the deficit. And we're not going to let that happen. Thank you very much, Mr. President. I yield the floor.
If no one yields time, time will be charged equally to both sides.
Mr. President.
I recognize the senator from Michigan.
Mr. President, I rise today in opposition to a widely irresponsible legislation that is before us now. Although our colleagues are calling it the big, beautiful bill, this bill would instead be a betrayal to our economic future, hardworking American families, and some of our most vulnerable seniors, children, and people with disabilities. This bill will blow up our national debt, kick millions of people off of their health care, and take food off of families' tables while cutting food assistance. And for what? What are our colleagues are mortgaging our country's future for? What are they slashing health care and food assistance to pay for? Well, they're doing it for tax cuts for billionaires. So before my colleagues rush to pass this irresponsible, reckless legislation, let's take a moment to go through exactly how much harm this bill will actually cause and hear from the people in my state who are going to suffer if this law becomes law. To start, this bill will blow up the national debt. Since President George Washington gave his farewell address, our nation's leaders have warned against the dangers of accumulating a national debt. 15 years ago, Admiral Mike Mullen, former chairman of the Joint Chiefs of Staff, stated, quote, "The most significant threat to our national security is our debt." The national debt is at an all-time high, $36.2 trillion. And just in the last 16 years, it has tripled. Our annual deficits frequently exceed $1.5 trillion, including a record $3.1 trillion deficit in fiscal year 2020 during the Trump administration. Unfortunately, these are the first of many grave financial milestones that we face. Within the next decade, our country will spend more on servicing the debt than we do on any other federal account outside of Social Security. Our fiscal house is basically on fire. But if our Republican colleagues jam through this bill, it's not going to pour water on that fire, it's going to pour gasoline on those flames. Democrats have tried to make efforts to pay down that debt in recent years. In fact, under the Inflation Reduction Act, a law that this bill attempts to actually gut, we reduced the deficit in that bill by nearly $250 billion. And in 2023, we passed the Bipartisan Fiscal Responsibility Act, which responsibly addressed the debt ceiling and had the potential to reduce deficits by up to $1.5 trillion. But unfortunately, the bill before us basically wipes all of that away. And I have always said that I'm open to making smart cuts to spending, but that those cuts should be matched with increases in revenues. Doing so would put us back on a sustainable financial path. Our Republican colleagues are doing the exact opposite. They are making drastic cuts to revenue, and according to the nonpartisan Joint Committee on Taxation, the tax provisions in this bill alone would decrease revenues by $4.2 trillion and add $3 trillion to our national debt. This is a recipe for disaster. If we face another emergency, like a pandemic or global financial crisis, we will be too hamstrung by our debt to respond effectively. We are on the brink of a financial disaster, and passing this bill could push us over that edge. Also, my Republican colleagues can cut taxes for billionaires. At the same time, our Republican colleagues are not making smart, sensible spending cuts to cover the costs that these billionaire tax cuts will mean. Instead, they're gutting health care for millions of Americans, including hundreds of thousands of Michiganders. It's reckless, and it is wrong. Medicaid is a lifeline for people in every single community across this country. It ensures that millions of Michiganders and Americans can have access to quality, affordable health care. And right now, folks across my home state of Michigan are scared. Scared about what this bill will mean
for their families. I've heard from thousands of my constituents from every corner of the state of Michigan on how these cuts are going to hurt them. So today, I just want to tell you, through my constituent stories, just how detrimental this bill will be for most Americans. Take Isaac from Lansing, for example, who says Medicaid is the only lifeline he has to pay for the medicine that literally keeps him alive. We've also seen how more and more Michiganders and people all across our nation have shouldered the burden of serving as a primary caregiver for an aging parent. It's the ultimate gift that we can give to the people who have raised us. But the cost of critical nursing home and assisted living care continues to rise. Medicaid has become an essential way for our aging seniors to pay for the care that they need. Take Gwen from Grand Rapids, who says she wouldn't be able to pay for an assisted living facility for her grandmother without Medicaid. Many of us know someone, or maybe even love someone, who lives with a disability. Thanks to Medicaid, people with disabilities can get the care that allows them to live healthy and independent lives. That is the case for Wanda from Westland, who takes medication for an eye condition. Without Medicaid, she would not be able to afford her medication, and she could actually go blind. As too many of us know from personal experiences or from friends and loved ones, our country is facing a mental health crisis. Medicaid has become a saving grace for those who desperately need mental health care, but simply cannot afford it. Take Alan from Fort Gratiot, who says losing Medicaid would feel like losing the lives he's been given back through mental health care from Medicaid. Under this bill, rural communities will be especially impacted by cuts to Medicaid. In some counties in Michigan's Upper Peninsula, there's only one health care provider, meaning some Michiganders will have to travel up to 50 miles to get routine or emergency care. Medicaid helps keep these hospitals open. And if this bill passes, people in these rural communities are going to be cut off from basic health services. Medicaid also plays an essential role in making sure that children across Michigan get the care that they need. I heard from Gladys, a mother from Flint, who says Medicaid is the only reason her kids can get their asthma medication or have regular health checkups. Expecting mothers also reached out to share their concerns. While she is busy preparing to welcome a newborn baby into the world, Chelsea from Fenville is now afraid that she will lose her access to both pre- and post-natal care under this absolutely disastrous bill. I simply can't understand how my Republican colleagues would leave thousands of people across Michigan without the care that they need, all so they can give a tax break to billionaires. On top of that, my Republican colleagues are also proposing deep, harmful cuts to food assistance delivered through SNAP. SNAP serves as an absolute lifeline for millions of Americans, including children, seniors, people with disabilities, and working families. So simply put, if this bill is passed, it will mean people in Michigan and all across our country will go hungry. They will not be able to put food on the table while billionaires pay less taxes. That is just wrong. But it also makes no economic sense either. Every dollar in SNAP benefits generates more than $1.50 in economic activity. This supports local grocery stores, farmers all across our country, and the entire food supply chain. So on top of jeopardizing families' ability to put food on the table, to feed their children, these proposed SNAP cuts would also hurt businesses and jobs, particularly in rural America and in low-income areas. This bill produces the most amount of pain for the least amount of gain of any legislation that I can remember in all the years that I've had the privilege of serving here in the Senate. Mr. President, I can't believe that we are standing here debating this reckless irresponsible bill. The harm this bill will do to the American people and to the people in my state of Michigan who are counting on Medicaid for health care and on food assistance to help feed their families is absolutely reprehensible. The damage this bill will do to our nation's economic security is not only reckless, it is unconscionable. This is not what our constituents want us to be focused on. They want us to help make their life better. But instead of focusing on that, here we are on the brink of passing a bill so irresponsible that it will destroy our country's economic health, harm millions of Americans, all so a handful of billionaires, the wealthiest of the wealthy, can have another tax break. Mr. President, I will never support such a reckless and catastrophic plan. Mr. President, I yield the floor. No, this is.
Mr. President.
I recognize the senator from Idaho.
Thank you, Mr. President. You get to be here for my second speech. I'm here to talk now about the centerpiece of this reconciliation bill, making the 2017 tax cuts permanent. The One Big Beautiful Bill prevents the largest tax hike in history and provides groundbreaking new tax relief for middle-class workers and families. This legislation permanently extends the Trump tax cuts, which proportionally benefited the middle class the most. If these tax cuts were allowed to expire, taxpayers in all income groups would see massive tax hikes. And a point that my colleagues on the other side seem to consistently forget or ignore is that the vast majority of them, $2.6 trillion worth of those tax cuts or tax increases, would fall on taxpayers making less than $400,000 per year. And the vast majority of that is on taxpayers making and earning in the middle and lower middle income categories. No. But before I go on to discuss what would happen, I want to address an issue that is just a constant theme on the other side, and that is that this bill is going to be a huge increase in the deficit. Now here's a quick handwritten chart that my colleague from South Carolina made quickly to respond to them. You heard the previous speaker say that CBO has scored this bill to have a huge multi-trillion-dollar deficit increase. The fact is that CBO has scored this bill to have a $507 billion deficit reduction. You heard that right, a $507 billion deficit reduction. And later on in my remarks, I will point out that that score doesn't even take into account the growth in the economy and the revenue that will come to our Treasury from revitalizing and giving a boost to our economy. So now let's go to the next chart. What will happen if we don't do this? What will happen if we do what the Democrats are demanding that we do? And that is to let this tax increase happen so that they can say they're going to use it to pay the deficit down. The average family of four would see a tax hike of $1,700 and their child tax credit would be cut in half. 20 million small business owners would face massive tax hikes, with some of them facing rates as high as 43%. The standard deduction, which simplifies tax filing for 90% of Americans, would be cut in half. Small businesses and farms would see their death exemption cut in half. The Council of Economic Advisors warns us that this $4 trillion tax hike would also lead to an economic downturn and potential recessionary headwinds, noting that the impacts would disproportionately fall on young people, minorities, and workers without college degrees. We've been working for more than a year on legislation that prevents that outcome and provides an opportunity for us to have additional tax relief that is specifically targeted to benefit low and middle income families and workers. Despite the rhetoric of fear, our critics' rhetoric about tax cut as being for billionaires and corporations, the reality of this legislation prevents a massive tax hike across the board and overwhelmingly benefits middle-class households and job creators. According to the Joint Committee on Taxation, this bill provides more than $600 billion, that's $600 billion more of new tax relief for hardworking Americans. How does it do that? $73 billion in inflation tax relief targeted at income brackets below $100,000 per year. $205 billion in tax relief to the 90% of taxpayers who claim the standard deduction. $93 billion in additional tax relief for seniors through a $6,000 bonus exemption. $124 billion investment in children of low and middle income families, in addition to the permanent doubled child tax credit. I'm going to say that again. The permanent doubled child tax credit. The significant tax relief we are providing to hardworking families includes permanent lower tax rates, letting Americans keep more of their hard-earned money, permanent increased and enhanced standard deduction, claimed by over 90% of taxpayers. On top of making that doubled child tax credit permanent, we are also increasing it for tens of millions of families. Tax relief for seniors in the form of a $6,000 bonus exemption for low and middle income seniors, slashing their tax burden. No tax on tips for millions of tipped workers like waitresses, barbers, hairstylists, and taxi drivers. No tax on overtime for millions of America's hourly workers who work overtime and keep America running. No tax on auto loan interest for new cars made in the United States, allowing the hardworking families of America to fully deduct auto loan interest on American-made cars. Enhanced 529 education savings accounts, making education expenses more affordable and accessible for families. New Trump savings accounts for newborns and children set up to the age of 18, building financial security for the next generation. We make child care more accessible and affordable for working families by enhancing the Child and Dependent Care Credit and the Dependent Care Assistance Program. The list goes on and on. We extend the paid family and medical leave credit and expand health savings and accounts for health care expenses. We repeal onerous IRS reporting requirements on gig workers, reduce the paperwork burden for small businesses, and much more. And all of this just on the individual side of the code. The business side of the tax code has the potential to generate phenomenal economic growth. When my Republican colleagues and I began talking about how to best extend and enhance the Tax Cuts and Jobs Act, we agreed that one of our top priorities was to make it permanent. The reforms we made in 2017, including lower rates for corporations and small business owners, along with the international tax reforms, increased domestic investment, boosted economic growth, and increased take-home pay. A growing economy powered a strong labor market. Workers saw record wage growth, and the unemployment rate fell dramatically to the lowest in 50 years at 3.5%. Corporate inversions, which we used to debate endlessly, or businesses leaving America, became a thing of the past. They literally ended. And America became the place to do business again. Capital formation exploded in the United States. Restoring these critical business provisions and making them permanent is a key to driving additional growth and investment in the United States. For businesses that spur investment and economic activity across the country, this bill makes the 20% small business deduction permanent, enabling job creation and spurring local economic activity. Restores and makes permanent full expensing for domestic research and development, encouraging domestic innovation. Restores and makes permanent full expensing for new capital investments, like machinery and equipment, boosting domestic production. Restores and makes permanent interest deductibility, helping to finance critical domestic investments and keep America globally competitive. It includes full expensing for new factories and factory improvements to accelerate domestic manufacturing. Permanently renews and enhances the Opportunity Zone program, driving $100+ billion of investment to rural and distressed communities. According to the Tax Foundation, permanence for the bill's 4 cost recovery provisions I've just reviewed would more than double the long-run economic effect. The National Association of Manufacturers predicts $248 billion in economic growth will come from the manufacturing sector alone, along with over 1 million jobs and over $100 billion in new wages. The National Federation of Independent Businesses says that making the small business deduction permanent will create 1.2 million jobs over 10 years, growing to 2.4 million jobs in the long run. That growth also means more federal revenue created right along the way. And the Council of Economic Advisors estimates that the tax legislation alone, this tax legislation alone, will drive more than $2 trillion in offsetting deficit reduction, thanks to permanent provisions that power economic growth and incentivize investment. Over a 10-year window, with this legislation in effect, the Council of Economic Advisors estimates that debt as a share of GDP will fall to 94%, compared to 117% if the Trump tax cuts expire. And this chart is important to look at. This is what happens to our deficit if we pass this tax legislation and grow our economy. And this is what happens if we don't. The red line is what happens if we don't. Over a 10-year window with this legislation in effect, as this chart shows, the estimate is 94% compared to 117% if the Trump tax cuts expire. So while my colleagues on the other side complain and complain that we will not let taxes go up, this is what will happen if they do go up. Far from adding to the deficit, this legislation will finally put us on a sound financial footing as we power growth and curb spending. For those who claim that this bill will add over $4 trillion to the deficit, it bears repeating. Preventing a $4 trillion tax hike is not the same as deficit spending. And those who say that we should let a $4 trillion tax hike go into effect to pay down the national debt, every tax increase that Congress has adopted for as long as I can remember was not used to pay down the national debt. It was used to increase spending. And that's exactly what is going to happen if the Democrats have their way and force this tax hike to happen. It was used by Congress to spend more money, not to reduce debt. Extending current tax policy means that tax revenue as a percent of GDP will remain relatively unchanged. We do not have a revenue problem in America. We have a spending problem. That's why we asked JCT to score this legislation under a more realistic scenario using a current policy baseline. The Council of Economic Advisors estimates that making the Trump tax cuts permanent, combined with other Trump administration pro-growth policies like regulatory reform and so forth, it will increase federal revenues by more than $4 trillion, far more than offsetting any deficit estimates. When combined with the $1.6 trillion in spending reductions, this bill represents historic savings for taxpayers, far exceeding the spending reductions in the past by hundreds of billions of dollars. And I want to look at this chart. I've talked a lot about tax cuts and protecting against tax increases and economic growth that happens from that. But reducing spending is another critical priority that we must address. And in addition to the pro-growth tax policy that I've just described, we cut spending by $1.6 trillion. This chart shows how other bills have tried to take a shot at reducing spending in the past. We far exceed any spending reduction bill that Congress has ever passed. We're paying attention to the revenue side, and we're paying attention to the spending side. To achieve this record level of savings, we are slashing President Biden's Green New Deal spending and promoting an America First energy policy. We are eliminating hundreds of billions of dollars of the Green New Deal subsidies, including ending wasteful credits like the EV tax credit. We stopped penalizing fossil fuels in favor of unreliable and expensive green energy, and instead support consistent energy sources, making energy affordable again. We are also rooting out waste, fraud, and abuse in federal spending programs, as my colleague from South Carolina mentioned, like those that we have identified in Medicaid. This will not reduce benefits for those who are qualified and for whom Medicaid was intended. It will reduce waste, fraud, and abusive scams that are being used to get the American taxpayer to funnel money into states or into other programs. This program was created to help pregnant women, children, and seniors in America and those with disabilities. We are continuing to protect them. They will not lose benefits, and the politics of fear that you hear constantly are simply false. But in recent years, the Democrats have incentivized Medicaid to enroll healthy Americans and illegal immigrants, driving up costs for taxpayers and risking the program's sustainability for those who need it the most. This is what has happened. This is what's happening to the enrollment and the spending in Medicaid. The fate of this expansion is an unsustainable path and puts the future of the program at risk, including the United States federal debt. As spending has surged, so have inappropriate payments and ineligible enrollments, along with gimmicks and loopholes. People are alarmed by these statistics, but official reports indicate that the federal government made $543 billion in inappropriate Medicaid payments from 2015 through 2024. Some experts think that that number is closer to $1 trillion. That is what we are addressing in this legislation. We have the responsibility to ensure that programs like Medicaid work efficiently and effectively and remain financially viable for those for whom it was designed to help. For months, my Democrat colleagues have engaged in the politics of fear, warning that Republicans are going to rip this critical program from those most in need. Let me be clear. This legislation does not take Medicaid away from any recipients for whom the program was designed to help. Children, the elderly, the disabled or infirm, adults caring for children, and elderly relatives are protected by this bill. We would not be honoring our obligation to these recipients if we allow the program to continue to balloon, forcing vulnerable populations to compete for available resources with able-bodied adults who refuse to work. As one father recently wrote in the Wall Street Journal, Medicaid was created to help people like my son. He is 17, has severe autism and epilepsy, and needs constant attention. Yet thanks to Obamacare's Medicaid expansion, he is stuck on a multi-year waiting list for an in-home care, because able-bodied adults are competing for the same results. CBO estimates that over 1.4 million illegal aliens are receiving Medicaid benefits. I'm talking about those who are not United States citizens and are not legally in the United States, receiving Medicaid benefits, and pushing those like this man's 17-year-old son out of his opportunity to get access to those benefits. Brett Guthrie, the chairman of the Energy and Commerce Committee in the House, correctly notes, every dollar misspent on illegal immigrants and ineligible individuals in the Medicaid program means less money going to our children, our pregnant women and mothers, individuals, and others who are disabled and seniors. Republicans are committed to preserving and strengthening Medicaid for the people Medicaid was intended to serve. That starts with making common sense reforms to eliminate waste, fraud, and abuse in the program. This bill targets rampant fraud in the program by removing illegal aliens, deceased recipients, or those enrolled in multiple states. It eliminates wasteful spending by ensuring that Medicaid payments align with levels in Medicare and other spending programs, and increases the frequency of eligibility checks. It requires more personal accountability and promotes pathways to work for able-bodied adults. The work requirements proposed in this legislation are simple. Many people are amazed that they're so easy to meet and yet so rigorously opposed. If you are an able-bodied adult without dependents, you can qualify for taxpayer-funded Medicaid by spending 20 hours per week working or participating in work training or going to school or participating in community service or volunteer work. The majority of Americans agree that these rules are responsible guardrails to protect a program that was designed to protect America's most vulnerable Americans. The bill also corrects abusive practices by freezing and reducing provider taxes, a financial gimmick used by states to increase federal spending that they receive. For those concerned about funding for rural hospitals during the transition back to responsible funding levels, the legislation creates a bridge funding system to help stabilize rural hospitals and enhance their long-term financial solvency. And while Democrats claim Republicans are slashing Medicaid spending, the reality is that even with these reforms, Medicaid spending is projected to continue to grow by billions of dollars over the next 10 years. Only in Washington is a smaller increase in spending considered a cut. In reality, these reforms will improve, protect, and preserve Medicaid for the most vulnerable Americans. We've had a very robust debate over how to best deliver on President Trump's agenda, and I'm proud of what we achieved in this legislation. The tax provisions in our bill, from permanent extension of the lower tax rate to the increased child tax credit to the permanent tax relief for businesses, will deliver financial security for American families and grow our economy. The health care provisions will protect and preserve Medicaid for the Americans that the program was designed to serve. And while more work remains, this bill's economic growth, combined with deficit reduction that we have in it, finally puts our country on a much better fiscal trajectory. Speaking of work, I would be remiss if I did not take a moment to thank the excellent staff from the Joint Committee on Taxation, the Congressional Budget Office, and the Senate Legislative Council for the hard work and countless hours they have put in to get us to this point. Some of them have been working with us on these provisions for years, and we greatly appreciate your partnership in this effort. I ask unanimous consent to have these individuals' names printed in the record. Thank you. I also have to thank my incredible staff who have foregone sleep over the past several months to provide timely, indispensable insight, facts, legislative text, counsel, and so much more. Without them, we would not be at this point and ready to deliver this much needed growth-focused policy for the American people. I ask unanimous consent to have the names of my entire Finance Committee staff printed in the record.
Without objection.
Thank you. Even with all that, and all that we accomplish in this legislation, there are dozens of additional good ideas, smart policies, and common sense reforms that we were not able to include today. And I commit to working with my colleagues to advance those goals as well as we move forward. But today's historic legislation is more than a good start and will pay dividends for American families, extending good tax policy, delivering targeted relief, and reining in wasteful spending, as achieved in this bill, is the best way to restore economic prosperity and opportunity for all Americans. I look forward to getting it to the President's desk as soon as possible. Thank you, Mr. President.
Mr. President.
I recognize it. Democrat Whip.
Mr. President, we're here today debating a clumsily assembled package, still a work in progress, that would rip away health care from 16 million American families to give tax breaks to millionaires, billionaires, and our largest corporations. Think about that for a moment. The Republicans have decided that the best avenue to generate revenue that they can then give in tax breaks to wealthy people is to eliminate health insurance coverage for 16 million Americans. That's going to have a dramatic impact on their lives. If you have ever been a young father with a baby with a serious medical problem and you had no health insurance, you'll never forget it as long as you live. I know, I've been there. The notion of losing your health insurance leaves you as vulnerable as possible in some of the most important moments of your life. And that they would consider this provision to eliminate health insurance coverage for 16 million families is unimaginable and cruel. Let's not act like there is a unified Republican front on this issue. Even some of my colleagues on the other side of the aisle don't want to be here at this moment, jamming this unpopular bill through this chamber under arbitrary deadlines. One of my colleagues took a look at tax breaks, and you're going to hear them say over and over again, well, the average family, if we don't act, the average family is going to have to pay more in taxes. There's a way around that. If we limit any tax breaks in this bill, in this effort, to people making $400,000 a year or less, $400,000 a year or less, it virtually eliminates 2/3 of the cost of this undertaking. And it means you don't have to take away the health insurance of 16 million families. So there are ways to do tax breaks which make sense. Count this Democrat in with the Republicans for helping working families who are struggling to get by, and a lot of them are, living paycheck to paycheck. And the notion that we would say to them, we're going to take away your health insurance, we're going to raise the cost of health insurance for you, is no answer to their problems. Behind closed doors, my Republican colleagues continue to be consumed with infighting, bickering over the bill's substance, and for good reason. We have a process here which is almost impossible to explain to an ordinary person of how we reach reconciliation. The parliamentarian's office, and she's sitting here, God bless you for what you've been through for the last several months, and all your staff, have to make decisions on a daily basis over and over again as to whether or not provisions of this bill are eligible under the law that governs the United States Senate. We're in the process of debating this on the Senate floor. I see our ranking member on the Budget Committee, Senate Budget Committee, the senator from Oregon. We're in the process of still appealing to the parliamentarian's office on provisions in the bill. This is truly a work in progress. I think what they do know is troubling, and it should be. This bill would be a disaster for hospitals. The Senate Republican bill, unfortunately, is going to endanger hospitals all over the United States. But if you happen to live in a small town, rural area, and I represent a lot of them in the state of Illinois, you're the most vulnerable. You are the target. When they cut back on Medicaid programs, these are the hospitals that will close their doors. What's the impact of a hospital closing its door in a downstate community in Illinois? Devastating. Hospitals are not only the center for emergency medical care, good doctors, nurses, and such, they are also a major economic force in small town America. Take away a hospital and then try to attract a new business to your community. Good luck. This Senate bill cripples one of the main ways that states fund their Medicaid programs and keep hospitals afloat, especially rural and low-income areas. It's called the provider tax. Earlier this week, a Republican senator, circulated a flyer to his fellow caucus members, so they're all on notice, detailing just how much each state will lose in Medicaid provider tax funding under their proposal. Let's take a look at my neck of the woods, the Midwest. Iowa would lose $4.1 billion. Missouri, $6.1 billion. Kentucky, $12 billion. Louisiana would lose $20 billion. North Carolina, $38.9 billion. Senator Tillis and I were in conversation yesterday, and he used that very same figure. His analysis says that to go forward with this bill cuts Medicaid reimbursement in his home state of North Carolina by a whopping $38.9 billion. This list of states and what they will lose was passed around by a Republican senator to his own caucus. They know what they're up against here. If Republicans have their way and pass this bill, hospitals will be forced to shrink or eliminate services. In Decatur, Illinois, one of the major hospitals facing the crunch time had to make a decision whether they keep their doors open. They did, but they eliminated OBGYN, delivering babies, and they eliminated all mental health and addiction counseling, two critical areas for the hospitals. So these doctors, this bill will force hospitals to shrink or eliminate services. Doctors and nurses will leave, and in some cases, the hospital will close. Imagine that in a rural area, a remote area, an extra 45 minutes, an extra hour in the car with somebody in the front seat you love very much who's in a desperate situation. As it stands today, half of the rural hospitals around the country already operate in a danger zone. And it's the same thing for children's hospitals. Do you have one in your community that you've used? I do. These children's hospitals have warned us they can't keep their doors open if Medicaid is cut as dramatically as the Republicans want to cut it. If Republicans have their way, we're going to see massive layoffs, fewer nurses, technicians, and doctors, along with decreasing quality of care. The American Hospital Association has estimated how these cuts to Medicaid could impact not just jobs at red state hospitals, but across the entire economy. Here's what they found. If the Republican provision goes through that cuts Medicaid reimbursement in order to provide tax breaks for wealthy people, Maine, as an example, one state, would lose 5,000 jobs. Kansas, 6,200 jobs. Iowa, 11,000 jobs. Missouri, 26,600 jobs. I've talked to the administrator of BJC in St. Louis, Missouri. The reason is it's not just a Missouri hospital. They have their facilities on the Illinois side of the river. In fact, 1/3 of their patients are from Illinois, and 1/3 of their patients overall use Medicaid to go to their hospital. So he's told me what's going to happen if the Republican measure goes through and the cutbacks to these hospitals. They came up with, incidentally, the rescue fund to solve the political problem. I want to check and make sure Senator Murray can back me up on this. Our overall cut in Medicaid now is at about $1 trillion. Correct. $1 trillion. Imagine, this is Washington, we talk in those terms. Cutting Medicaid nationwide $1 trillion. And the rescue plan for the small hospitals that are in danger, the ones I've talked about, $1 trillion cut. How big's the rescue plan? $25 billion. Do the math. It's a joke. It is a joke. If Republican leaders think this is an adequate amount to alleviate pain all of our nation's rural hospitals are going to feel, then that's like trying to put out a forest fire with a garden hose. This simply won't work. I want to conclude by saying this. We passed the Affordable Care Act 15 years ago. Of all the things that I've worked on in Congress, I think it had more positive impact to help the families across America than anything. We found a way to make health insurance more affordable for families 15 years ago. And to do it, we held hearings, 100 hearings on the Affordable Care Act. Obamacare is what they called it. Roundtables, walkthroughs. 2 committees spent a combined 21 days holding markups so that everyone could offer an amendment. Do you know how many amendments were made to the Obamacare program? 400. 400 votes in committee and on the floor on amendments. 147 Republican amendments were included, though not a single Republican senator ended up supporting the Obamacare when it was all over. What do we have here with this measure? At the end of the day, that legislation, the Obamacare, allowed more than 40 million Americans to gain health insurance. Today, how many hearings have we had on the bill that's before us, this dramatic multi-trillion-dollar bill? None. Zero. Not a single one. Zero markups for senators to offer amendments. 400 amendments on Obamacare. None on this one until it comes to the floor today. Zero bipartisan input. Our friends on the Republican side have said basically, it's a big deal. Take it or leave it. Should this bill become law, do you know what we'll done? Thrown 16 million Americans off health insurance and closed many vulnerable small hospitals, all to pay for tax breaks for millionaires and billionaires. Maybe some of my Republicans are okay with that. I don't think the American people are. I'm hoping that sanity and common sense prevail. We need 4. We need 4 senators to step up and say, stop this train. We've got to sit down and do our homework. We cannot expose the American families and the American economy to do this in the name of preserving tax breaks for the wealthiest people. Elon Musk seems to be doing okay in life, right? The wealthiest man in the world. Do you know what the tax break is for Elon Musk on the bill that's before us on the floor? $346,000, a lot of money. To him, he won't even notice it. Giving him a tax break, he won't notice, and taking away health insurance from families who will be devastated, 16 million around the country. It's an important choice, and it's one we should make the right one. I yield the floor.
Mr. President.
I recognize a senator from Kentucky.
In deciding whether to vote for the big, not-so-beautiful bill, I've asked a very specific question. Will the deficit be more or less next year? The answer, without question, is this bill will grow the deficit. The federal government has fancy formulas and hundreds of wonky accountants who inform us of their projections over 10 years. But you often can't trust these projections. In an excellent piece written by the Foundation for Economics and Education entitled "The CBO's Projections Are Worse Than Useless," Eric Schuler writes, "Long-term analysis and language is commonplace in U.S. national politics, but it achieves no useful outcome. It confuses far more than it clarifies. It does not provide accurate estimates of long-term results. It does not improve the average voter's understanding of policy effects. And it gives politicians a means to claim they are being fiscally responsible without actually exercising any prudence whatsoever. Sometimes the predictions are off because a new Congress is elected and changes the law. Eric Schuler writes that for any projection of a 10-year budget to be accurate, the Congressional Budget Office has to assume that the law won't change for 10 years, even as most of the politicians that make the laws risk being replaced every 2 years, and all of them advocate for changes of one stripe or another. Schuler states that few in Washington will admit Congress has a knack for starting any proposed cuts in the later years while letting spending run wild in the immediate future. Sometimes these predictions are off by $1 trillion or so because the economy grew more slowly or more quickly than anticipated. Bruce Thompson, a former Senate aide and Assistant Secretary of Treasury, writes, "The Congressional Budget Office miscalculated the deficit last year by $1 trillion. So in deciding whether to vote for any big, monstrous bill, it helps to ask the right question. To me, the most pertinent question is how will the bill affect the deficit in the next year? Currently, our deficit is estimated to be a little under $2 trillion this year. What will happen to the debt in 2026 if this bill passes? Well, using the math most favorable to the supporters of the bill, referred to as the policy baseline, the deficit in 2026 will still be $270 billion more than this year. So even using the math, even using the formulas that the supporters of the bill like, the deficit will grow by $270 billion next year. That's just not good if you profess to be fiscally conservative. Why will the deficit grow next year? Well, even if you argue that the 2017 tax cuts don't need to be counted in the calculation at all, the new tax cuts add up to $234 billion to the debt next year. In addition, the big not-so-beautiful bill adds new spending of over $500 billion, military, border, agricultural subsidies, etc. That spending is front-loaded and will be spent in the first 4 years of the 10-year window. Legislative spending is one of the few items in the bill that is exact. It isn't estimated. If they say they'll spend $500 billion, they're going to spend $500 billion, all in the first few years. So in order not to add to the deficit, the BBB, the big not-so-beautiful bill, has to have corresponding spending cuts to counter all the new spending. Unfortunately, the spending cuts are backloaded to the final 5 years of the 10-year window when several tax cuts expire and the spending increases are finished. In addition, elections occur every 2 years and could easily wipe out any perceived savings that might occur in the later years. The only real certainty in this budget drama are the budget years coming in the immediate future. It's the next year or two are the only things that are actually of any certainty. So if we analyze this bill from that perspective, we discover that the bill increases the debt by $500 billion in the first 5 years. This is not the CBO projection that Republicans have not liked. This is the projection they are using, says the debt will add $500 billion in the first 5 years. Now, they say somehow, miraculously, in the last 5 years, it gets to a $500 billion in savings. So it's $1 trillion shift from year 5 to year 10. The CBO scores it differently, not as encouraging, and says it adds over $3 trillion in debt. So which is it? Does this bill save $500 billion over 10, or does it add $3 trillion over 10? The truth is that anybody, that even a person with a magic crystal ball, it's anybody's guess. Which brings us back to maybe we have to judge the effects of the big, not-so-beautiful bill by looking at what happens to the debt next year. Supporters of the bill admit it adds $270 billion to the debt next year. That's the only thing we know for certain. We don't know what happens in year 3, 4, 7, 8, 9, 10, but we know next year this bill will grow the deficit by $270 billion. In addition, the bill increases the debt ceiling by $5 trillion. What does that mean? That is an admission that they know they aren't controlling the deficit. They know that the ensuing years will add trillions more. So we're adding $2 trillion this year, but they're anticipating, the authors of the bill anticipating, adding more than $2 trillion next year. That doesn't sound at all conservative to me, and that's why I'm a no.
Mr. President.
I recognize the senator from Oregon.
Mr. President, joining me on the floor are experts in the budget process, former chairs and ranking members, Senator Murray, who's been Senate Budget Chair from 2013 through 15, Senator Whitehouse, who's Senate Budget Chair 2023 through 2025, Senator Van Hollen, who was the ranking Democrat on the House Budget Committee in 2011 through 2017. We're here to address a fundamental violation of the law, of Law 313, Section 313, and it is the set of rules for reconciliation. To try to summarize this in the simplest words possible, 100 senators voted to have a special fast-track, filibuster-free pathway solely for reducing the debt. First principle was no deficits could be created in a 10-year period. My Republican colleagues blew that up in 1996 when they wanted to do a tax bill that would create massive deficits. Then, a second pillar was no deficits in any title of the bill in any year after the first 10 years. This bill right now, if this passes, that blows that up. And the third was use honest numbers, Congressional Budget Office numbers. I have a letter here from the Congressional Budget Office, and they say, the estimate is relative to CBO's January 2025 baseline. CBO is required to construct its baseline under the assumptions specified in the Balanced Budget and Emergency Deficit Control Act and the Congressional Budget and Impoundment Act. In response to your questions about the cost of Title VII, the question was, would Title VII increase the deficit by more than the $1.5 trillion over the 2025 through 34 period? The answer is yes. CBO estimates that enacting would increase the deficit by nearly $3.5 trillion over the 2025-2034 period, $3.5 trillion. We then asked, would it increase deficits in the years beyond 2034, beyond the 10-year window? The answer was yes. But if you ask my Republican friends, they say, no, no, no. We're inventing a new theory, and that is that anything that the 2017 tax giveaway to the billionaires put into the law that expired after 10 years, we're just going to assume it would have continued, and therefore, us continuing it doesn't cost anything. That's a pretty crazy notion, that if they didn't put it into the bill, the law says it ends, but they say, no, no, it would have continued anyway through some magical way. So therefore, a tax break for the really wealthy costs nothing. This is exactly the type of lying to ourselves, smoke and mirrors that 100 senators agreed to end back in 1974. And that it has continued, that piece of it has continued in place for 51 years until this moment in this Senate by this Republican majority says we're going to start lying to ourselves and lying to the American people about what this bill costs. But we're not going to lie. We're going to tell you the truth. This bill costs well over $3 trillion over 10 years and some $30+ trillion on top of existing deficits and debt because of the provisions that are in this particular bill. Our current debt, national debt, that's been run up since the Declaration of Independence is around $36.5 trillion. This bill basically matches that in creating that much additional debt over the next 30 years. This is a huge assault on the programs that we can sustain as a nation for the people of America. People struggling to get on their feet, so we want affordable housing programs. We want to have fair and quality health care. We want to have an education system that gives every child the opportunity to thrive. We want to create a robust economy through investment so there are good jobs because no government program is better than a good job. All those imperiled by this bill because the Republican leadership is lying to the American people and lying to ourselves. So we're here to tell the truth, and first of all, we're going to turn to Senator Murray, who, as I mentioned, was the Senate Budget Chair from 2013 to 2015.
Mr. President.
I recognize the senator from Washington State.
I thank the senator from Oregon and our other budget chairs, ranking members from previous years, because this is really important. Mr. President, there are some things you can't change with legislation, despite what my colleagues on the other side of the aisle seem to believe. For example, 1 + 1 is 2. And while a trillion might have a lot of zeros in it, it is, in fact, a much, much bigger number. Now, that might sound obvious, but apparently my colleagues across the aisle need a little reminder, because right now, Republicans are pretending not to get it. It is almost beyond belief, and it is certainly beyond common sense. After years of complaining about the debt, in fact, at the same time they're talking about how we need to address the debt, Republicans now are suddenly pretending they don't know how to count. Republicans are suddenly pretending the parliamentarian doesn't exist if they don't talk to her. Republicans are suddenly pretending that precedent doesn't exist if they just fake amnesia, and that norms and consequences for breaking them will disappear if they wish it away really hard. My preschool students had more common sense. Republicans should know if they replace math with magic, if they tear up the Senate process, if they blow off the Senate parliamentarian, that bill will come due. And not just the bill for $4 trillion blown on tax cuts for billionaires and corporations. The bill will also come due for trashing this Senate process and precedent when Republicans are no longer in the majority. Mr. President, if Republicans are serious about plowing forward with rewriting or ignoring Senate procedure and the laws of mathematics, I just ask, spare me the empty excuses. Spare me the explanations that totally ignore the reality of what you are doing. I mean, do they really think it washes away everything to say, oh, it's fine to break the process in half because we say it's fine? Oh, it's fine. We have the authority to ignore math. Give me a break. To every Republican who really thinks that is a convincing argument, to anyone who thinks we can is just an acceptable rationale for going nuclear and pretending the most expensive bill in the history of our country can be paid for by some magic bean counting, here is my challenge to you. Go back home and try that game with your constituents. Tell them, it's okay, yes, the debt's going to be $4 trillion, higher 10 years from now, that's true, but it's fine. We voted on it, and we get to say $1 trillion is actually 0. Go ahead, see how that works for you. And you may as well tell them you are voting against gravity next, because that's just as reasonable. And don't forget, when you tell your families back home that trillions of dollars in tax cuts for billionaires and companies are free because you waved a wand or you said some magic words, don't forget to tell them those are just tax cuts for the billionaires, not for working families. Don't forget to tell the folks back home, yeah, I voted to say $1 trillion is nothing, but we still need to kick people off of their health care. That's just too expensive. We still need to close those hospitals. We have to cut costs, and we still have to kick people off SNAP because the debt is out of control. And don't forget to mention that, no, we can't afford childcare. We can't afford paid family leave. We can't afford to solve your problems. Magic math is apparently just for billionaires. You all are getting less. Please, Republicans, send that message to your constituents. Just see how it goes over. Because you can fool yourself, but you are not going to fool the American people. They don't get to balance their budget with magic math. They don't get to pretend $1 trillion is nothing. And they don't get to pretend that this bill is free. Because at the end of the day, regardless of what policy baseline you all want to use in DC, those families back home, they're the ones who will be paying the actual cost. I yield back to the Senator from Oregon.
Yield to a question.
I would.
In the time that you were budget chair, did you ever contemplate a situation in which you argued that renewing a tax break that was by law expiring would somehow have no impact on the deficit?
To my friend from Oregon, I never would have contemplated and I never would have put it forward, and I happen to know that if I had have suggested that my Republican colleagues would have been all over me telling me that breaks the rules.
Thank you very much. We're turning to Senator Whitehouse, who was Senate Budget Chair from 2023 to 2025.
Thank you, Senator Merkley. I mentioned earlier the history of the section that the Republican budget chairman is using to perform this multi-trillion-dollar magical act of making huge deficit-busting numbers disappear. It's called Section 312. It has been used before, but it has always been minor, corrective, and bipartisan. I mentioned earlier the adjustment that was made on a bipartisan basis to the Power Marketing Administration's numbers to return the CBO to an agreement that the Senate had previously made. That was not enormously consequential. This is almost certainly the first time you're hearing about it. Again, in 2023, as budget chair with Republican Chair Jody Arrington on the House side, we made a $105 million adjustment to a dairy program. Today we're talking about trillions. This was a $105 million adjustment. Again, bipartisan, minor, and corrective, fixing a technical issue on a bipartisan basis. Last year, Speaker Johnson and Leader Schumer agreed to direct CBO to score a fee program with an OMB estimate, and they used this rule again, collaborating on a bipartisan basis with a matter that was minor and corrective. Well, this is different. This is trillions. And Republicans are using this rule to pretend that it's not. Well, there are lots of ways to look at who's right. Time obviously will tell. But this bill actually has a tell right in it. Page 754 of this bill is the reality check on whether or not they're running up the debt by trillions. We know they're running up the debt by trillions because they say so in this bill. You can play Senate procedural fakery. You can wave magic wands around numbers all day long, but someday, soon, you hit reality. And you hit reality in the real world of markets and selling treasury bonds and having a legal debt limit. If this did not raise the debt by trillions, they would not need to raise the debt limit by trillions. Here is the text. Subtitle C, increase in debt limit. Section 72001, modification of limitation on the public debt. The limitation under Section 3101B of Title 31 is increased by $5 trillion. They're dodging the parliamentarians' ruling by letting the budget chair make a $1 trillion magic wand maneuver because they know pretty darn well what the parliamentarians' ruling would be. And how do they know what the parliamentarians' ruling would be? Because the answer's in their own damn bill. I yield the floor.
Would the senator from Rhode Island yield for a question?
Of course.
You mentioned the use of Section 312, which gives some flexibility to resolve, as you put it, minor issues on a bipartisan basis to correct an issue, a technical issue. In those cases you mentioned, were those on a reconciliation bill?
Were they on a reconciliation bill? I don't believe they were.
No, they were not.
They were
In fact,
just...
that power has never been used on a reconciliation bill because the following Section 313 gives very specific instructions. It says each provision must be costed out for its impact on both outlays, the spending side, or revenue, should it be a revenue measure. And if you're saying, well, how do I do that? You say, well, if we pass this provision, what will it cost as compared to not passing this provision, not having the bill? That's a comparison to current law. This ability of the budget chair, and actually the law says the budget committee, to correct technical issues on narrow issues on a bipartisan basis, basically solve snarly little budgeting questions like on the dairy program you mentioned, never used on reconciliation ever, never used on a broad basis ever, never used to create a lie about what a bill costs in this fashion. Now we're turning to a senator from Maryland, who was ranking Democrat on the House Budget Committee for 6 years. So he brings a lot of experience and knowledge about the budget process. Senator Van Hollen.
Well, Mr. President, I thank my colleague and the ranking member of the Senate Budget Committee, Senator Merkley. I just want to start by reading a statement. This is a quote. Anyone that says current policy baseline is the right way to go is engaging in intellectual and economic fraud. It's intellectually lazy. My basic mission in life is just to try to create some honest math, unquote. That wasn't from Senator Van Hollen or anyone on this floor. This was from a Republican member of the House, Congressman Schweikert from Arizona, talking about exactly the issue we're debating here in the United States Senate. Let me read you another quote, a little more colorful. Again, about this Republican accounting fraud. Quote, this is fairy dust, and they're just full of crap, and I'm going to call them out on it. Republican Congressman Chip Roy of Texas. They're right. This is a fraud. This is a fraud that would make the Enron scammers blush. And I quote those House members for a reason, because we can disagree with what they did in their bill, and I strongly disagree with it. But at least they used honest math, and at least they used the math that is required by the rules here in the Senate. The honest math that Republicans here in the Senate want to dodge because it will both tell the American people just how big the deficits are, but also because it will screw up their whole entire plan. Just so people listening have some sense of how these Senate numbers are designed to disguise the real impact of their deficits. Look at, for example, the basic individual tax rates in the House bill. When they extended those tax rates from the Trump 2017 bill, it costs $2.2 trillion. Under what we call the current law baseline, which is the reality baseline, because that's what it will cost when you understand that they sunset at the end of this year, and that's what it will cost to renew them. So under honest accounting, it's $2.2 trillion. Under the Senate fraudulent accounting, that $2.2 trillion deficit miraculously becomes an $83 billion deficit. Let's look at the House permanent extension of key deductions for businesses. That would cost honest accounting $821 billion. Under the Senate accounting scam, $6 billion. So what we're seeing here is this blatant, deliberate effort to mislead the American people about the true costs of this bill, about the deficit impacts of this bill, about how it will impact the debt. And we all know that when the debt goes up and we have to put more of our costs on Uncle Sam's credit card, it puts upward pressure on interest rates. That means Americans will pay higher interest rates on their mortgages, on their car loans, and everything else. So when you try to hide the deficit impact, you really are trying to fool the American people, and we're here to blow the whistle. Now, I just want to show our colleagues something that was put together by the Committee for a Responsible Budget. And if you look at the blue, you can see for each year, starting this year, 2025, 2006, the blue is what Senate Republicans claim their bill will add to the deficit. The red is how much more it will actually add to the deficit. So at the end of this 10-year period, what you see is Senate Republicans are claiming that their bill will add $441 billion, which is still a big number, but the real number when you do honest accounting, when you add up all of these, it's $4.2 trillion, a much bigger number. Now, I do want to point something out on this chart. I think everybody watching should understand it. If you look at these orange parts, these are the additional deficits from tax cuts. Starting here in year 2029, 2030, you'll see that they actually do start going down. Why is that? It's because the tax cut that President Trump promised for no tax on tips, they phased those out. This is all just a make-believe ruse. Yeah, we start providing no tax on tips, but those disappear. The tax breaks for wealthy people, they go on, and they go on not just for this 10-year period, but the reason they violate all the rules of reconciliation is because they keep going on after that. And as Senator Merkley said, if you look at the entire history of the Byrd rule, that's Senator Byrd, it was designed to make sure that 51 senators through a vote could not make these kind of permanent changes in any area, but specifically they were worried about areas that increased the national deficit and debt. So what Republican senators are doing is not only misleading the American people, but they're violating the entire structure that carved out this special procedure that we call reconciliation for the budget, which was intended to lower deficits and debts, not have them go on forever. As Senator Merkley has pointed out, I think if you look over a 30-year period, we're talking about $35 trillion plus additional to the debt. And Republicans want to hide that from the American people. That is budget fraud, pure and simple, and it is a violation of the rules of the United States Senate. This whole special structure that was created not to blow bigger holes in the debt and deficits, but to actually try to constrain them. So shame on everybody who's part of this fraud on the American people. I yield back my time.
Would the senator from Maryland yield for a question?
I will.
I found it very interesting that you pointed out that these tax provisions for the middle class, no tax on tips, is phased out, and no tax on overtime is phased out. And what you're saying, I believe, is that when they put into this bill that a tax break is ending, they're saying that it doesn't cost any more in the following years.
So they are certainly saying that their current policy baseline that they want us to make believe about would say that this wouldn't cost them. In other words, if they extended this, it wouldn't cost anything. It is interesting to note, not only does that expose the fraud behind the current policy baseline, but they made a very deliberate choice. Even though they now say that they can make these tax cuts permanent and still comply with the rules, they decided to make the tax cuts for very rich people permanent. But even though they say it's not going to cost anything anymore to provide, tax cuts with no tax on tips, they're phasing those out. And all of these areas are where President Trump made promises that he was going to take care of some working people. Well, man, those go away fast. Tax cuts for the rich, they go on for not just the full 10 years, but they keep going, which is why this is a violation of the entire reconciliation process.
So I find two things very interesting. They're saying if something was in the law that they passed in 2017 and it expires, they're pretending it doesn't expire and therefore extending doesn't cost anything. But in their own bill, when they say a provision expires, they're saying, no, it really does die, and therefore we're saving money in the years after. How is those two things possibly consistent?
Well, clearly they're not. I mean, this is literally magical
thinking. This is why Republican Congressman Schweithart called this, or Chip Roy called this fairy dust, and why the congressman from Arizona said this was pure intellectual and economic fraud. That's what it is. That's the bottom line.
Well, I really thank the senator from Maryland also pointing out that President Trump, he did, when he was campaigning, say he was fighting for ordinary families. But at his inauguration, who did he have standing behind him? Not champions for health care or champions for housing, certainly not champions for nutrition or education, but in fact a series of like 5 or 6 billionaires. And now you're telling me that in this bill, and I want to make sure the American people understand this, the provisions that were sweeteners to say we were helping working people are being phased out, but they're keeping all the tax breaks for billionaires.
Well, you're right. It was right down this hall, actually, that President Trump was sworn in, and he said it was going to be a new golden age for working people. Well, as you're pointing out, and this chart clearly shows, and their own budget reveals, it's clearly a golden age for billionaires and people who make a lot of money. And in this bill, they make sure that that golden age for very rich people goes on forever. They had a few little crumbs that they were throwing for a little while, we can see, to others, but just for a little while and just small amounts compared to the golden age for the billionaires.
Well, I must say my impression is, and I hope you'll correct me if I'm wrong, is that the Republicans are embarrassed by the fact that they're proposing a bill that creates over $3 trillion in debt in 10 years and over $30 trillion over 30 years, and that the vast bulk of it goes to billionaires. And so they want to say, we're so embarrassed because we mentioned fiscal responsibility when we were running for office. We're going to get the budget under control, and they're doing the opposite. And they're embarrassed that they're doing these cuts in programs to fund tax breaks for billionaires, cutting regular health care, 16 million people losing health care for tax breaks for billionaires that, as you point out, go on and on and on, actually permanent. I would certainly love to yield to my colleague from Rhode Island.
When I was budget chairman and we were trying to focus, for instance, on the impending economic nightmare coming our way through climate-caused property insurance failures, what I would get is nonstop regular lectures from Republicans on the Budget Committee about how we had to take responsibility for the deficit, we had to reduce the debt, nothing else mattered as much, it was absolutely vital. And now, of course, we see that at their very first shot, with the power to do anything through their majority and using reconciliation, they're raising the debt. They're raising the deficit, and not by a little, but by trillions. And I'm wondering if, in your time as chairman, or perhaps in Senator Murray's time on the committee, or perhaps in Senator Van Hollen's time over on the House committee, you were favored with such constant lecturing by Republicans about the debt and the deficit, and how credible that all seems right now.
I'll yield to Senator Murray.
I thank the senator for his question, because it's just stunning to me that the vast majority of debate, in fact, all the debate that came from Republicans at the time I was chair of the Budget Committee trying to put forward a smart budget for the United States of America, the only thing they talked about was debt and deficit. The only challenge they made to us was debt and deficit. The only time we tried to do anything for childcare, for health care, they threw the debt at us. So it is pretty stunning to me that now that they need to raise the debt for giving tax breaks to the very rich people who stood behind the president at his inauguration, then they play with the numbers and pretend it's not real, and a trillion all of a sudden becomes zero, and I'm using some rule you've never heard of to try and pretend that this isn't real. It's fairy dust.
I just want to say, to answer the question from the senator from Rhode Island and pick up on what my colleagues have said, that when I was the senior Democrat, the ranking member on the House Budget Committee, Paul Ryan was the chairman of the committee. And look, We disagreed on many things. We agreed on many things. We both agreed that we should get our deficits and debt under control. We had different ideas on how to do it. He wanted to privatize Medicare. We wanted to close tax breaks for the rich. But we want to close tax breaks for the rich. But the reality is that the holy grail, I mean, the only guiding North Star for Republicans at that time was we've got to bring down deficits and debt. This is not that Republican Party, not in any way, shape, or form. They clearly don't give a damn. In fact, they are worried, as we can see, that the American people still care, which is why they want to engage in this fraudulent scheme. But I'll just close on this. I remember one of those years, I believe it was the 2012 Republican convention. They even put up a debt clock. They put up a debt clock at the convention. I can't find it. Right? I'm looking under my desk for the debt clock here because Republicans seem to have hidden it away forever. They want to wish it away. That's what they're telling us.
But the bill actually is required to raise the debt limit by $5 trillion. So in reality, there's a huge hit to our debt, huge additions to our deficit, and it makes me a little bit frustrated to think back to all those lectures that I had to receive as budget chairman, which the senator from Maryland witnessed as a longtime member of the Senate Budget Committee, which the ranking member witnessed in his time on the Budget Committee, and which Senator Murray experienced when she chaired the Budget Committee. We have been lectured to death by our colleagues, and at the very first instance when they had the power to do something about it, they went 180 the other direction and are cranking the national debt in order to give big benefits to the rich people who fund their campaigns.
For a question, and I know we need to move on here. I just want to add one thing. It's not just that it's going to be debt. It's the cost to families because this debt they are putting in place. I would ask the chair of the Budget Committee now, as he knows as I do, people's houses are going to cost more because their mortgage interest rates are going to go up. Their cars' interest rates are going to go up. This is not just magic numbers sitting out there pretending they're not. Real families are going to feel the cost of this debt and this deficit.
I really appreciate that point from my colleague from Washington State, because in this bill, it creates so much necessitated borrowing that CBO estimates that that borrowing will cause interest rates to go up. And when interest rates go up for the Treasury, it goes up on your car loan, on your adjustable rate, a mortgage on your house, and just in general. These are costs that are borne by ordinary families. And I find it very interesting because the Republicans were demanding what they call the dynamic score, saying, well, won't these cuts produce such a great economy that it will kind of lift all boats and produce more revenue, and maybe the deficit won't be as bad. Here's what Congressional Budget Office found. Again, that's the nonpartisan, honest broker numbers. They found that because of the interest rates rising as a result of this massive sea of red ink that necessitates massive borrowing, that in fact those rising interest rates will hurt the economy. So there's no dynamic score that produces, oh, well, it isn't so bad after all. No, it's the opposite. And in fact, that dynamic argument has always been wrong. And we are looking at the folks who lectured, my colleague from Rhode Island, and I sat through many of those lectures as well. And I went, in my head, wait a minute, aren't these folks who did the massive ocean of red ink in the 2001 Bush tax bill? Aren't these the same folks that produced a massive ocean of ink in another tax bill 2 years later? Aren't the same ones that in 2017 did a massive ocean of red ink, and now they're doing it again? How could they possibly be putting themselves forward as deficit hawks or debt hawks? Not to mention that they cheered on two adventures that were a huge tragedy for the United States of America, trying to occupy Afghanistan and going to war in Iraq, which together added $8 trillion to our debt. And if you take a look at this chart, every time there is a Republican administration, the last deficit while they're in office compared to their first deficit goes up. For Clinton, it went down. That's fiscal responsibility. For George W. Bush, first term, it went up. For Obama, it went down. In other words, the Democratic presidents, time after time after time, Clinton, Obama, Biden, they reduced the deficits while they were in office. And the Republican presidents, while they were in office, every single time increased the deficits. So none of us want to hear any more talk about fiscal responsibility from across the aisle. You want to be fiscally responsible? Vote no on this bill, because this bill takes and fires 16 million people off of health care to finance those tax breaks for billionaires. This bill says 4 million children will go hungry to finance tax breaks for billionaires. This bill is families lose and billionaires win, and the debt goes up, endangering our ability to do basic programs for the entire next generation. It is wrong on every count. And I think collectively, we urge our colleagues to honor the argument they've made over time that, in fact, they were concerned about the deficit. They were concerned about American families. Because if you are concerned about the deficit and debt, if you are concerned about families, you must vote no on this bill. Thank you, Mr. President.
Senator from Washington.
Mr. President, I really want to thank my colleagues. I mean, you just said they used to call themselves deficit hawks. We need to call them deficit robins. They're robbing from you to pay for the billionaires. They are no longer deficit hawks. Agreed? Thank you.
My colleagues, and I think as Senator Merkley said, if you care about deficits and debt and you don't want working families to have to pay for these tax cuts for billionaires and the rich, vote no on the bill.
I'd only add in my last words, watch. Everybody here, watch as this goes forward, because we will give the Republicans a chance to reduce the increase to the debt and the deficit by peeling back just the tax cuts for the greedy billionaires. We would be voting for working class tax cuts, I'm almost certain. We'll have a chance to bring into stark focus through our amendments what really matters to the folks on the other side of the aisle, and that is the tax cuts for the super wealthy, for the billionaires, for the corporations that are offshoring jobs, and for the biggest polluters in the country. That's where their sweet spot is, and we will expose that through these votes.
Those votes, we're not sure when they will start, because the Republicans are redrafting provisions of this bill right now. That's how little time this Senate will have to actually know what's in this 1,000-page bill with all kinds of special deals tucked into it for various members. We will have little time to see because they're still writing it. So those amendments that my colleague from Rhode Island mentioned, stay tuned. We're not sure if those amendments are going to start at 2 in the morning or if they'll start sometime later tomorrow, but stay tuned and pay attention, because you're going to find out who stands with families and who stands to hurt families in favor of helping billionaires. Thank you.
Senator from Washington.
Mr. President, thank you. I think it's really important, the discussion we had right now about the deficit and debt, but I want to talk a little bit more about this bill in general. You know, recent KFF polling shows that this Republican big, ugly betrayal bill is overwhelmingly unpopular. In fact, this thing is more underwater than the Titanic. Nearly 2 in 3 Americans view this bill unfavorably. That goes up to nearly 3 in 4 when they learn it will kick millions off their health insurance. And it goes up to nearly 4 in 5 when they learn it will choke off funding to their local hospital. In other words, the more the American people hear about what is actually in this big, ugly betrayal bill, the more they dislike it. So with that in mind, I want to be here today to say a little bit more about what is in the Republicans' latest version. Spoiler alert, it is still big, it is still ugly, and it is an absolute betrayal of the people who sent us here to fight for them. The Republican plan is still going to mean over 16 million people losing health care as patients get kicked off their ACA plans, kids and struggling families will get kicked off Medicaid. Rural hospitals are going to be forced to shut their doors. The Republican plan is still going to mean more starving families. New red tape is going to cut people off from their SNAP benefits that they need to put food on the table. And it is going to take away kids' school meals. The Republican plan still rips away support from the people in this country who are struggling the most to give away billions in tax breaks to billionaires who need help the least. In short, this latest version of Republicans' bill would still be one of the biggest transfers of wealth from the people at the bottom to the people at the top in our nation's history. When it comes to health care, this Republican abomination will cause millions of people to lose their insurance and see their costs skyrocket in one way or another. It will create mountains of new paperwork and bureaucratic barriers that are positively meant to kick people off their Medicaid and ACA coverage. And there is new sabotage to the ACA healthcare markets, which will mean more people losing their affordable coverage. Meanwhile, there is nothing, a big fat zero, when it comes to renewing the tax credits Democrats passed to lower your healthcare costs. That's right. While Republicans are showering their billionaire donors in new tax breaks, they will not lift a finger to extend healthcare tax credits that are saving millions of families thousands of dollars a year on health coverage. Instead, they're going to make sure people lose health care coverage, including our seniors, people with disabilities, pregnant women, millions of patients who rely on Medicaid. And let's not forget, the cuts in their bill are going to shutter hospitals across the country, especially in our rural areas. Do you have Medicaid, Medicare, employer-sponsored coverage? Regardless, Republicans have some pretty bad news for you, because it hardly matters what insurance you're on when you don't have a hospital to get care anymore. In Washington State, we have 14 rural hospitals that are fighting to survive and would likely close under this bill, mostly in areas represented by Republicans, I should add. Not to mention, we have 6 rural labor and delivery units that could be forced to close their doors under this bill. And you know what the Senate Republicans did? They made that problem worse. They put even more pressure on our rural hospitals. I'm telling you, this betrayal is getting bigger and uglier by the day. And this cannot get lost. Republicans want to shut the doors of one of the biggest healthcare providers in the country. They want to defund Planned Parenthood. That is wildly harmful and wildly unpopular. It would shutter at least 200 health centers that provide a wide spectrum of care, including cancer screenings, pap smears, birth control for millions of women. And let's not forget, Republicans are cutting nutrition assistance too. This big, ugly betrayal would make one of the biggest cuts to SNAP in history. We are talking around a $200 billion cut over the next 10 years. Now, it should be obvious, but that would be devastating for our country and for our kids' future. And yet, Republicans are not giving up on taking dinner off the table, taking school lunch off kids' trays, all so they can shovel tax cuts at billionaires and wealthy corporations. And it is worth underscoring the new red tape in their bill is even targeted at some of our most vulnerable families, because it expands work requirements to apply to seniors and parents with kids in school. Mr. President, when my dad, World War II veteran, got sick with multiple sclerosis, he lost his job. He lost his job. My mom was at home, 7 kids she was raising. My dad lost his job, and they had to spend, my mom had to spend some time getting some new skills so she could go back to work and take care of our family. You know what, during that time? We had to rely on food stamps in my family to feed those 7 kids in my family. But under this Republican bill today, because neither of my parents had a job during those few months, my family would not be eligible for SNAP benefits. We would not have even gotten food on our table at the worst time in my family's life. This is wrong. Thanks to those food stamps, my family did get through that rough patch. And all 7 of us kids grew up to give back to our communities. Whether it's a firefighter or a middle school teacher, or even here as a United States Senator. So I can't emphasize enough. Republicans want to cut families from SNAP and Medicaid, programs that give people a hand up in hard times. Why? So they can give an enormous handout to the richest people and biggest companies in our country. Oh, and at the same time, they're making it harder to afford groceries and health care. I should mention, they are also gutting energy investments in a completely chaotic way that is all but guaranteed to drive away jobs and drive up energy costs for all of American families. And at the same time, in this bill, they're giving billionaires billions of dollars. Republicans are going to give students the short end of the stick. This big mess of a bill would tear away programs and protections that make it possible for many students to pursue a higher education. It eliminates Grad Plus loans. It cuts families off from Parent Plus loans. It punishes students who go into public service or a medical residency, and more. Meanwhile, they are tearing down the guardrails from gutting regulations that protect students whose universities commit fraud, to opening a Pandora's box for Pell Grants with a new loophole that will let low-quality programs suck up our taxpayer dollars. These changes are especially going to hurt students from low-income families and first-generation college students and our veterans. Some of them will have no way to go to college when Republicans take their support away. Some will be driven into predatory private loans they can't afford. And some will get lured into low-quality programs that take their money, waste taxpayer dollars, and leave the student worse off. And if that wasn't enough, if the Secretary of Education wanted to try and stop this kind of fraud and protect students, Republicans will leave them at about as much authority as a school hall monitor. Because in this bill, Republicans prevent any Secretary of Education from making regulations that carry added benefits for borrowers. And it hardly matters if that is a good impact, like saving students money or protecting taxpayer dollars from fraud or making higher education more accessible. Republicans are going to make problems worse and make fixing them even harder. Students in this country should be outraged. And I want to be perfectly clear about something. If Republicans charge ahead with this big, awful mess, which they seem intent on doing, they can kiss any last shred of credibility goodbye, as we just talked about, when it comes to pretending they care about balancing the budget or addressing the national debt. The idea was already laughable. For the entirety of the 21st century, the biggest driver of the national debt has been tax cuts that Republicans championed. But now, as we just talked about, they want to put at least $4 trillion, that is trillions with a T, on the national credit card. Why? So they can shower the richest people on the planet with more money. And then they're pretending all the math works and it's kind of easy peasy if they they can do it if they kick people off health care or take enough meals away from kids or close enough hospitals or better still, use some absurd accounting gimmick to pretend that billions of dollars in new tax cuts for their billionaire donors actually just don't cost anything. Well, I've got some bad news for Republicans. Your math is terrible, and so's this bill. This thing is very expensive, and you don't have to take my word for it. Ask the nonpartisan Congressional Budget Office, which just said The latest version of this bill will add 4 trillion to the debt with just over the next 10 years. If Republicans want to ignore them, you can also ask the fiscal hawks at the Committee for a Responsible Federal Budget. They calculate that the House bill adds $5 trillion to our debt when you include interest payments and the cost of making temporary provisions in this bill permanent. And we are told the Senate bill is even less fiscally responsible. Everyone agrees this thing is not beautiful, but it is recklessly big, and it won't just increase the debt, it will blow it up. Mr. President, this may very well be the most expensive bill in history. I say may because Republicans are still planning changes. We have not yet gotten the final bill. They already cut out even more taxes for multinational corporations. SNAP benefits, they're still on the chopping block. Healthcare, still on the chopping block. In fact, they want to cut Medicaid even more painfully. We may not know how expensive the Republicans will be in the end, but we know who is paying for it. Paying for it is you, working families. And it is important for people to know, as bad as this bill is, Republicans were trying to make it even worse. Now, Democrats have been fighting them every step of the way, and we have notched a few important wins by challenging every single provision we possibly could under the Senate rules. So I want to talk about some of the things Democrats were successful in getting out. Because if Republicans had had their way, not only would this bill take away more food from our struggling families or shutter even more hospitals and kick even more people off their health insurance, it would have also sold off all of our public lands. And if instead of just slashing CFPB funding, it would have completely shuttered the doors of a very important federal watchdog that protects Americans from getting scammed. If Republicans had have had their way, this bill would make it easier to buy gun silencers, harder to get your earned income tax credit or pay off your student loan, and effectively impossible to get insurance plans on the marketplace that cover abortion care. If Republicans had had their way, this bill would have also given Trump more power to deny funding to our constituents on a whim and less power for the courts to stop him. We're talking about a whole smorgasbord of really awful, unpopular ideas and policies that would have hurt our families and weakened our democracy. Ideas that were this close to making it into this bill. But Republicans did not have their way. Democrats have been fighting back at every single step. We got those provisions tossed in the shredder, and we are still doing our darndest to send the rest of the bill to the shredder as well. Now, let's be clear. When we talk about how unpopular this bill is with the American people, the reason is simple. This bill polls like garbage because it is garbage. That's why it should go nowhere except a trash bin. Democrats are going to keep pushing back on this monstrosity with absolutely everything we've got at every step we can. We're not going to stand by as Republicans shutter hospitals so the richest people in the country can build another vacation home. We are not going to sit around and let Republicans kick millions of people off of their insurance and raise working families' premiums so corporate executives can get a bigger bonus. And we are not going to be silent as Republicans take food away from struggling families so they can help billionaires fuel up their private jets. We're going to keep speaking up, we're going to keep pushing back, and we're going to make sure everyone knows exactly what is going on here. This bill is deeply unpopular, that much is clear, but if Republicans keep pushing for this disaster, buckle up, because we are only going to keep getting louder and louder about how big this is, how ugly it is, and it's only going to get more unpopular with the folks back home as these provisions are enacted if this bill passes. I'm pretty astounded by how far some Republicans are trying to stick their heads in the sand on this. One Republican senator told their concerned constituents, and I quote, "We're all going to die. Well, maybe that's a better name for the bill. At least it's more honest. Because when you take health care away from people, when you make it harder to get, when you make it harder to afford, when you close the only hospital for miles, yeah, you're right, people will die. You'd think my colleagues would show a bit more concern about that. Instead, that senator actually doubled down, and in a response video, she filmed walking through a cemetery. I don't know how you get out of touch that much to misunderstand this, but let me be clear about something to our Republicans. Whistling past the graveyard is a metaphor to stop ignoring dangers. It is not a literal messaging suggestion. And if you thought Republicans couldn't be any more dismissive to their own constituents, this week another Republican senator who was speaking about people voicing their concerns about these Medicaid cuts that said they will, quote, people will get over it. Mr. President, I have news for every one of my Republican colleagues who is trying to deny the reality of this bill and pretend the fairy tales they are telling themselves are true. When someone's local hospital closes, they don't get over it. When someone's kid is kicked off health care, they do not get over it. And if Republicans don't want to take my word for it, they can listen to the doctor I spoke with who warned when patients go uninsured, they delay care and it increases costs for everyone. Instead of paying $10 for diabetic medication, we'll pay $10,000 for an amputation. Or Republicans can actually read the countless letters I'm getting from my constituents, sharing their stories. Quote, my dad is a double amputee. He relies on Medicaid. Without Medicaid, we couldn't get my kids anti-seizure medication. Or I'm a full-time caregiver for my daughter with cerebral palsy, or my son with spina bifida, or my elderly mother, and this bill threatens to kick them off their health care and the support services they rely on to survive. Or better yet, Republicans can go out and talk to their own constituents, because I have no doubt they will hear similar stories. They will even come to you. Advocates have been here in DC all week. I've seen them in the halls. I've heard them from my office. And now Republicans can listen to the people across the country who are warning them about this bill, and they can do the right thing and abandon this effort, or they can keep ignoring them. But make no mistake, in the end, the American people will have their voices and their votes heard. Because at the end of the day, this bill, this monstrosity of a bill, is all in the goal of a tax break for multi-billionaires and corporations, and the way they pay for it is by taking away your health care and your nutrition, the things your family or your neighbors or people you know rely on. And that's just wrong. It's un-American, and we're fighting back. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Rhode Island.
Thank you, Mr. President. Mr. President, I rise today to oppose this partisan reconciliation bill. Republicans have named it the One Big Beautiful Bill, but you'd only use that kind of title if you were trying to hide something. And here's the simple truth. This bill takes health insurance and food assistance away from millions of Americans and gives President Trump's billionaire and millionaire friends giant tax cuts. And this bill, it would provide hundreds of billions of dollars in tax giveaways to the country's 902 billionaires and millionaires, while kicking 17 million Americans off their health insurance. Just weigh the balance. 902 beneficiaries with extraordinary tax deductions and tax benefits versus denial of health care to 17 million Americans.
it doesn't balance. And despite slashing health care, somehow this bill will add trillions of dollars to our national debt. It will further weaken our financial position in the world. It will indeed have many countries wondering if the United States is, as it has been since the end of World War II, the place to put their resources, their investments, their reserves. This could have profound fiscal and monetary implications for the United States. And if you tie that together with this tariff battle, we are headed economically in the wrong direction as we are socially. This bill is loaded with outrageous special interest giveaways and President Trump's personal political priorities. For example, $7.5 billion for wealthy developers to use for luxury housing and other high-priced developments at a time when affordable housing for working families is a crisis in every state in the country. $1.7 billion for gun makers who will be able to sell silencers, sawed-off shotguns, short-barrel rifles, and other very dangerous weapons and components tax-free, making our streets more dangerous for police and for the American people, and indeed, especially for the police, because they're the first responders. They're the ones that are typically going to the door wondering if the person behind that door has an automatic weapon or some other weapon designed not to hunt or shoot, but to kill. Hundreds of millions of dollars in new tax cuts for extraordinarily wealthy oil and gas companies, and $40 million for a Garden of Heroes, a sculpture garden to honor President Trump's favorite historical personalities. And at the same time, it slashes the budget for the Consumer Financial Protection Bureau, which makes sure that shady payday lenders, mortgage lenders, and banks don't fleece American families. And in particular, the military division of the CFPB protects men and women in the uniform of the United States. We were able to pass an interest cap of 36% for active duty personnel. And that is going to be ignored because there's no one to enforce it. And we are going to see, as we have in the past, our soldiers, sailors, airmen, guardians exploited, systematically exploited by all those little automobile shops and payday lenders and everything else that surrounds every military fort base in this country. It's a tale as old as time. My Republican colleagues showering the rich with tax benefits and prioritizing favored industries and friends. President Bush joined with the Republican Congress to do that. Of course, I opposed it. And well, by the way, when President Bush did that, we were projected to have, over the next 10 years, a multi-trillion-dollar surplus. Of course, this legislation will lead us to a multi-trillion-dollar deficit. And it's interesting because when I was younger, the Republicans all associated themselves with fiscal responsibility, balanced budgets, surpluses. That's not the case. President Trump exacerbated the situation in his first term by his grand giveaway. But this time, President Trump and my colleagues on the other side of the aisle are depriving millions of Americans of their health care coverage to pay for it. They are intent on punishing the most vulnerable Americans in this bill simply for the crime of being poor. In fact, in many cases, despite working very long hours and being poor. I came here to Congress, to the Senate, after serving my country in the U.S. Army, as the President did with great distinction, in the United States Navy as a Navy SEAL. I came here to serve my constituents and improve the lives of average Americans. And I think most of my colleagues, Democrats and Republicans alike, came with the same goal. And according to press reports, a few of my colleagues on the other side of the aisle are starting to realize that this bill is going to do great damage to their constituents. One Republican colleague has warned that this bill could leave 600,000 of his constituents without health care coverage and blow a $38 billion hole in his state's budget. That would be a devastating effect. One of the other aspects of this attack on our health care system is there's some people that believe, well, Medicaid doesn't touch me. It certainly does. Because when you extract that much money from the health care system, what will private health insurance do? They'll raise their rates. Everyone will be paying more. And some won't be able to afford it. They'll have to go without coverage. And that is going to be a tragedy for this country. Now, knowing the damage this bill is going to do, one must ask, why would anyone support this? But this legislation is more than just numbers. I've heard from countless Rhode Islanders who are concerned about these cuts during meetings, in letters, when I bump into them at the grocery store or the pharmacy. They've been telling me about how Medicaid has helped them and their families. I've been meeting, for example, with Christina from Smithfield, Rhode Island, for many years. Her daughter, Lauren, was born with cystic fibrosis and has endured countless hospitalizations, procedures, medications, and other challenges as she navigates life with this disease. Christina, Lauren, and their family have private insurance, but Medicaid also helps cover the expenses not covered by private insurance for people with serious illnesses who are not able to work. When President Trump and congressional Republicans began proposing these cuts to Medicaid, Christina told me, and I quote, "Lauren was born with CF, a rare genetic progressive disease which affects her lungs, GI, and endocrine systems. I had no idea we carried this gene. When Lauren was born, she spent a month in the hospital. We almost lost her. When she was 5, she contracted a germ that put her in the hospital for a month and almost killed her. Her lung function fell to 70%. At 13, I thought she was going to die. Her hospital stays were every 3 months for 2 weeks with IV treatments. Her lung function fell to 30%. With one of the medicines for CF, she was able to finally get her lung function back to 65% at 23 years old. She still suffers every day. Just trying to breathe is difficult. If she catches the common cold, it could put her in the hospital. She has had a hard time keeping weight on, and her GI is a disaster. She spent hours in the bathroom. She developed CF-related diabetes, which always puts her in danger. Every day is rigorous treatments and medications just to stay alive. It is with the help of the NIH and the FDA that she is still alive. Please do not make these cuts. If Medicaid is cut, when she is 26, 2 years from now, she will have no way to pay for all of her hospitalizations, medications, and treatments. Few could afford to keep her alive. It is this simple. Without Medicaid, she will die. We need your help. Carolina from Central Falls, Rhode Island, shared similar concerns for her daughter. My daughter has special needs, and we rely on Medicaid for her needs. Not having Medicaid would create a sinkhole for us. People with profound autism need lifetime, 24/7 care, As you consider budget cuts, it is important to me as your constituent that you work to ensure that this vulnerable population has access to the critical supports that it needs to survive. I will be looking to you for your courage and leadership. Indeed, and now we're looking across the aisle for courage and leadership to reject this flawed bill. I received an email from one constituent, Wally, in Cranston, Rhode Island. She is a 71-year-old retiree on Medicare. Her husband is 72 with Alzheimer's disease, living in a nursing home under hospice care and relying on Medicaid for his health care. She wrote to me that she was, quote, terrified at all the cuts to programs and services that she and her husband so desperately rely on. Without Medicaid, she wonders if she or her husband would be able to continue receiving care. I also heard from Diane in Coventry, Rhode Island, whose daughter gets life-saving care through Medicaid. Diane said, Medicaid is important to me personally. Medicaid matters to me and my family. My 15-year-old daughter suffered a brain bleed and a stroke at the age of 5. It came out of nowhere and was very unexpected. She has spent a lot of time in the hospital, rehabilitation services, doctor's offices, appointments, etc. over the past almost 10 years. Medicaid allows her to be home and taken care of on a daily basis. Without Medicaid, she would not be able to receive hospital-level care at home. She wouldn't have a wheelchair or any other durable medical equipment. She wouldn't be able to get her life-saving medications or the nourishment she needs through her G-tube. Please, I urge you to save Medicaid, not only for my family, but for millions of others. All of our lives depend on it. Now, my colleagues on the other side of the aisle may say, we're not going to cut these people's Medicaid. We're just going after the fraudsters, the freeloaders who aren't working. Now, who exactly are these fraudsters and freeloaders? Is it the elderly patient who needs expensive nursing home care? Is it the child with a serious chronic health condition? Should we cut off these people's access to health care because they can't work? They physically cannot work? Or because the constant paperwork requirements got lost in the shuffle? Let's be clear. If my colleagues were serious about eliminating fraud, they would be providing states with more resources to investigate questionable claims and bad actors. Medicaid coverage is not extravagant, it is a lifeline. If my colleagues were sincere in their claim that these cuts are about protecting the program, quote, for the people who need it the most, as the majority leader has claimed, then they would be investing the so-called savings back into Medicaid instead of blowing it on tax cuts for the well-off. Instead, this bill is cutting funding to states for Medicaid, and states will have no choice but to pick and choose who will get access to care. But don't take my word for it. The Nonpartisan Congressional Budget Office, CBO, estimates that this bill will cause nearly 17 million Americans to lose their health insurance. 17 million people. That's not fraud. It's just making it harder for people to get health care. On top of that, even if you're one of the lucky ones who gets to keep your Medicaid, will you still be able to get it? Nursing homes rely on Medicaid. More than 6 in 10 nursing home residents in Rhode Island are on Medicaid. As Medicaid funding is cut, what will nursing homes do? I imagine some will have to close their doors or dramatically reduce the number of beds. So you could be one of these fairly well-to-do Rhode Islanders trying to get mom in the Medicaid home, in the nursing home, I should say, and you're willing to pay, but if it's closed, or there's only 5 beds where there used to be 20, she's going to be where, in my generation, grandparents were, in the living room, in a hospital bed, being cared for in those days, typically by your mother. So this approach to Medicaid is going to touch every aspect of American life. And the same can be said about the community health care centers. Medicaid makes up a huge portion of the operating budget for community health centers, which provide primary, dental, and behavioral care to more than 200,000 Rhode Islanders. That's roughly 1 in 5 Rhode Islanders. It's hard enough to find a doctor now. It will only get harder if a community health center closes its doors and thousands of patients don't have a doctor anymore. And where do all those patients end up when they can't get routine care? The emergency room. That means there will be lines out the door, and if you have a serious health event and need to get in, you better get used to waiting a long time. This is not how a health system is supposed to run. And in Rhode Island, our health system is already on the brink. People are just getting by. People are waiting in the hallways of ERs for a bed upstairs. People are spending days on the phone trying to find a doctor. We should be making these things better, not worse. But again, Republicans' main priority seems not the physical or financial health of everyday Americans. It is providing massive tax cuts to President Trump's billionaire and millionaire friends. There's certainly nothing wrong with being successful, and there's nothing wrong with wealth. That's something that has been part of the American dream since our beginning. But what it requires is opportunity. And one of the fundamental opportunities it requires is good health and good education. And what this bill will do is destroy our healthcare system and force the states to make dramatic cuts to the education system. We are shutting down opportunity in America while we enrich the wealthy elite. The American dream, as I believe it, is about the middle class and a government that's focused on them, not taking $1 trillion from Medicaid so Republicans can gift to those who've already benefited from many other gifts. Mr. President, let's put the enormity of this transfer to the wealthiest in perspective. There are about 128 million households in America. Yet somehow this bill gives the top 0.1% of households a $250,000 tax cut, a giveaway that's over 3 times larger than what the median American household makes in a year. When confronted with this point, Republicans consistently try to hide the ball. Middle and working class Americans are getting tax cuts too, they say. Who cares if the rich gets richer? Well, the Senate bill raises taxes on the lowest income Americans, the same families from whom Republicans are ripping away health care and other benefits. While we are voting on this bill without a full analysis of its impact on households, the Congressional Budget Office found that the House-passed version would take around $1,600 away from these lowest income households each year after accounting for tax changes and benefit cuts. And it's not just low-income Americans. Researchers at Penn's Wharton School of Business have found that most Americans lose money under the House bill in future years, too. I want to be crystal clear. We need to reform our tax care system. We need to make it fairer for working Americans, not just for the ultra-wealthy. We hear from people so often that government is broken. They're right. Our tax system is unfair and needs reform. But giving the top 0.1% of Americans an extra $250,000 every year is not fixing the government. It's just adding to the sense of unfairness and brokenness that so many citizens feel. We can do a bipartisan tax bill that is both fully paid for and that helps average Americans. In fact, We almost did that last summer when the House passed the tax bill 357 to 70 that would have extended the child tax credit and reinstated tax cuts for businesses without increasing the deficit. 48 bipartisan senators voted for that bill in this very chamber, but it was blocked because Republican leaders wanted to pass something like this bill before us today. My Republican colleagues have drafted a bill that is neither paid for nor helps most Americans. Worst of all, they have chosen to take from the poor and the middle class and the working class to give to billionaires. This bill is very bad policy. It's almost un-American if you believe that the essence of America, as expressed by one of our greatest presidents, Abraham Lincoln, was to give every person a fair chance in the race of life. This bill denies that chance to millions and millions of Americans while enhancing and filling the pockets of the wealthiest. And I oppose it. I yield the floor.
Mr. President.
Good.
Thank you. I'm honored to follow my colleague, Senator Reid, and he is absolutely right that this bill is almost un-American. In fact, I would say it is un-American because it is so destructive to the middle class, to health care, to education, to basic fairness and decency in our great country, the greatest country in the history of the world. It would balloon the debt and the deficit by $4 trillion, and yet my Republican colleagues have sought to disguise and hide that reprehensible pain and damage to the American system. It would cut Medicaid by $930 billion, which means billions in cuts for Connecticut, hundreds of thousands of Connecticut children and families off Medicaid, food nutrition shredded, and student loans decimated. These kinds of impacts on Connecticut are mirrored through the whole country. And the American people are beginning to get it. That's why this bill, the so-called One Big Beautiful Bill, is so deeply unpopular, in fact, by 2-to-1 majority. And I want to talk not only about Connecticut, but two of the states that are represented by colleagues here. They are so-called red states. But make no mistake, this bill is seismically catastrophic, not just for Connecticut, but for the whole country and for Louisiana, where this measure, if it's passed, will mean that my colleagues from Louisiana are voting to kick roughly 250,000 people in their state off health insurance. They will be voting for a bill that could close 33 rural hospitals in their state alone and cost their state's health care providers $588 million for services that newly insured patients simply will not be able to pay back. Their state program would lose $4 billion. That's Louisiana alone in funding. These numbers are staggering, and they're the reason that every major health system in Louisiana is opposing this bill. Just yesterday, they sent a letter warning that cuts in this bill, and I'm quoting the Louisiana health care providers here, quote, would be historic in their devastation and warrant our shared advocacy to protect our patients and the care we provide them in hospitals and clinics. I could go on about Louisiana. I'm going to abbreviate my remarks and put my full statement in the record if there's no objection, Mr. President.
Without objection.
But this bill also reduces SNAP benefits for 206,000 Louisianans. It eliminates the benefit entirely for 94,000 of them. I want to see my colleagues from Louisiana go home and face their constituents, having cut the legs from SNAP and Medicaid programs and many other benefits. And in Utah, same tragic scenario unfolding in a state where 337,000 children and adults depend on Medicaid. Nearly half of all children in Utah are covered by Medicaid. 59% of nursing home residents. 60,000 people living in rural Utah communities covered by Medicaid. If this bill passes, at least 180,000 Utahns will lose health care coverage, and Utah's uninsured rate will increase by a staggering 67%. If this bill passes, 31,000 of the people in Utah could see their benefits slashed, and 13,000 would risk losing their benefits entirely. Now, I just want to say in conclusion, these numbers for Connecticut, for Louisiana, for Utah, for the state of Washington, where my wonderful colleague, Senator Cantwell, will be talking shortly, they're not just numbers. They are faces. They are lives. They're children who are just beginning to be Americans. And their productivity, their contributions back to America will be hamstrung. Their lives will be financially handicapped. And health-wise, they will be impaired as a result of these irresponsible and reprehensible cuts. I couldn't be angrier about these kinds of cuts in programs done only so that the ultra-wealthy will receive tax cuts. I'm willing to bet that a lot of those billionaires and millionaires would forego those tax benefits if they understood the consequences. But my Republican colleagues, who are in disarray at this moment, they can't come together on a program because they know how abhorrent its effects would be on their states, ought to listen to the people of America, not the ultra-wealthy. And the people are speaking in the polls, they're speaking through their elected representatives, and they are speaking because their conscience simply won't let them support a bill that does such abhorrent damage to the American middle class, the American way of life, American values. And I'm proud to stand here. I wish we weren't here going all night into Monday morning, but I'm proud to stand here with my colleagues, and I just wish my Republican colleagues were on the same sides of these issues, because they're going to go home and they'll have to face the children and families who will be hurt so deeply by this bill. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Washington.
Mr. President, I rise to ask my colleagues to turn down this legislation in front of us, to reject it, and instead work together on fiscal policy that would help us by growing our economy more successfully and not devastating our constituents. Before I start, I want to thank the presiding officer for speaking up about not selling public lands. I very much appreciate his voice in that debate, and it's critical that we were able to successfully get that out of this legislation. I want to work across the aisle to talk about these policies so that we can move our country forward in a competitive fashion. But I'm afraid that what we have in front of us is not the answer to what will make America competitive, particularly at a time when we are putting tariffs on American imported products, when we are basically getting into a trade war, and when we are devastating what I think is the underpinning of the economy of today, that is an information age innovation economy, and here we are devastating all of our investments in NIH and NSF and in the competitiveness that we just implemented in the IRA and the CHIPS and Science Act that is making us the envy of countries around the world for innovation. We do have great capital markets, and those capital markets help us innovate. And I think some of my colleagues think, well, we have a promise to families here to give them a tax break, and while many of us would support that, you're asking us also to give tax breaks to big corporations before they can get their tax break. And that we don't like. We don't like it because it raises the cost on everybody, and that cost for middle class and lower income people will be devastating, particularly at a time when we continue with this tariff policy. This bill would make the entire healthcare system less responsive and more expensive for everyone by dismantling Medicaid and shifting more of the cost burden onto states and threatening the very existence of rural hospital. This bill also sells spectrum out from under our national defense and safety agencies and forces states to choose between protecting their citizens from dangerous AI or providing broadband service, and it just gives away big breaks to companies like Meta, that's Facebook, or Google, who I'm sure at this point in time don't really need that additional tax break. Clearly, though, the most egregious and certainly most destructive part of the bill of this reconciliation is the changes to health care. The fact that 17 million people will be uninsured and raise the cost on everyone. This is from the Congressional Budget Office. We don't need to be raising healthcare costs on our constituents. The CBO analysis revealed that hasty negotiated updates by Republicans discussed on behind closed doors early Saturday morning added that $130 billion in Medicaid cuts to the bill. That's a whopping $930 billion in total Medicaid cuts. That is how CBO got to this number of 17 million people. The challenge is nobody marked up a bill in committee. Nobody even had a hearing where somebody presented this information. No, this is all being changed on a daily basis, and everybody's trying to catch up. But what we're really trying to do is fight for our constituents and make sure that we know the impacts. The impacts of these 17 million people will be severe cuts felt in every corner of the United States. State governments will be the first to feel this tsunami of cuts, and unlike the federal government, they must balance their budget, so they can't borrow the money to make up for the deficit. In our state, the state of Washington, our governor and legislators have to grapple with an estimated $3 billion shortfall that this will bring to them as a result of this many people losing coverage. Yesterday, I held a virtual press conference with a group of Republican state representatives. A Republican Utah state representative who, Ray Ward, who just also happens to be a physician, warned that these cuts will amount to $1 billion budget deficit per year in his state of Utah. That budget shortfall forces his state government to make some very difficult decisions. They have to decide whether to cut reimbursements to providers, cut medical services, cut more people off the rolls, or make drastic measures like increasing everyone's taxes. Kevin Leonard and Steve Hobbs, one of them is the executive director of the Association of County Commissioners of North Carolina, and the other, Missouri representative, basically said as county government leaders and state leaders, they are worried that this bill basically is an unfunded mandate on them. Commissioner Hobbs said where they will feel it most is that services like behavioral treatment will now have to be provided through the jails instead of a medical setting. Our own Peninsula Health expert who was on the call basically said that in their region of our state, this could be as much as a 25 to 45% cut in behavioral health. So that's what happens when you cut people off of Medicaid. The amount of money, since Medicaid is 1 in 5 dollars is a Medicaid dollar, you're going to take that much out of the system. These people do not operate on wild, profitable margins, oftentimes barely breaking even, or in behavioral health, oftentimes losing money. But I guarantee you, if instead of seeing this Medicaid population in a behavioral health setting, you think you're going to see them in the emergency room or a jail, it is going to cost us a lot more money. It's going to cost our state, our county, and the local region a lot more money. Not only will this bill diminish their Medicaid revenues, but it will also increase the uncompensated care. Some are estimating to be $42 billion. Our rural hospitals, our rural healthcare challenges will be devastating. In Washington, over 300,000 people will lose health insurance. And these are people who were easily treatable, conditions that if you treat them, chances are they will be dealt with. But now, if you don't treat them, they're going to go to the emergency room and they're going to raise costs on everyone. These families depend on this care. Last week, I spoke on the floor about one of my constituents. Britton Winterrose talked about his daughter Leda, a 5-year-old girl who had a rare condition that when she stopped breathing, she does stop breathing in her sleep if she doesn't have oxygen. Mr. Winterrose talked about how even though he had a very expensive platinum plan, it didn't cover her costs. And just by doing this Medicaid and covering their cost, basically they have saved her life and they have enjoyed her in the many years enjoy that they have given to them. Why are we making the Winterroses sweat over whether their daughter is going to be able to keep Medicaid, about whether the whole system in their part of our state is going to be able to keep doing Medicaid? Right now, people are estimating that 5.4 million people will get pushed into medical debt because of health care and the cuts in this bill. The total amount of medical debt that Americans will owe will increase by $50 billion. So is it really worth it to take $880 billion, or whatever it is now, $930 billion out of Medicaid so that you're actually increasing the personal debt of people, making counties basically have unsustainable budgets, or having state legislatures come back in to cover our costs? As one of these commissioners said, this is nothing more than cost shifting to the states. It's irresponsible. According to the Center for American Progress, a 60-year-old couple who will be in the affordable care market today, making $85,000 a year, could see their annual premiums raise as much as $15,400. Why? Because when you have uncompensated care and you basically kick people out of Medicaid and off of the Affordable Care Act, what you're going to do is raise premiums on all of us. A low-income Medicare recipient also qualifying for Medicaid could see their costs go up as much as $8,340. So why are we doing this? And the out-of-pocket expenses now that a Medicaid person has to pay for, they could be paying as much as $1,650. You want to do that to give a tax break to Google and Facebook? That's why you're doing this? The tax break that you want to give them, multinationals, and I could just say for a minute about this. You know, when the 2017 tax bill came along and everybody said the corporate rate is too high, we need to have our companies be competitive around the world, I would have considered lowering that rate to something. In fact, my colleague, Senator Kaine from Virginia, proposed something, but we didn't accept that. Instead, they lowered it to a very low rate and then said this year, we'll smidge it back up. That means they'll increase it back up a little bit this year. That was their plan. But somehow these multinational corporations have got to my colleagues on this side of the aisle and basically said, give us the same rate that we had in 2017. Now, the reason I didn't support that in 2017 because it was kind of ludicrous. You were saying to companies like Microsoft, we'll give you a tax break. I don't think they really needed that big of a tax break. But by the way, we're going to raise taxes on the people who work at Microsoft. we are going to raise, because of the SALT deduction, we're going to raise your taxes. So literally hundreds of thousands of people in my state paid higher taxes to do what? Give Microsoft a tax break, which they gave in dividends. Now, did that help our economy? Did that help really grow our economy? I'm pretty sure the innovation at Microsoft helped grow our economy. I'm pretty sure the people who hustled on AI helped grow our economy. I'm sure the investments that we made at agencies across our federal government helped us meet the challenges that we are facing in innovation and competition from China. Not that dividend, but now we're doubling up again. And how much is that multinational tax break? To over $200 billion. So literally, you could take half of that money and you could give it to Medicaid instead and not cut Medicaid. Now let's see. Tax breaks to Meta and Google or paying for Medicaid. Tax breaks for Facebook and Meta, the same company now changing their name, and Google, or a tax making sure there's enough revenue to pay for Medicaid. This is ludicrous. The notion that we are continuing to make big corporations the priority when they knew this tax extension was not coming. And I'm pretty sure if you look at the numbers that you see from Facebook, Meta, and Google, you will see they don't really need a tax break. They're doing pretty well right now. So the budget reconciliation bill really threatens our progress on health care. Now let me explain what I mean by that. It's not enough to just say that this health care issue, that we are really winning the day. When you look at what happened to us in health care, when our whole goal of doing the Affordable Care Act was to basically get more people covered under insurance. Why? Because we wanted to lower all the costs on health care overall. We wanted health care costs to go down, and we wanted the cost of premiums and the cost to individuals to go down and to be more like the rate of inflation, 3 to 4%. That has been our goal forever, forever. And so prior to the Affordable Care Act, it rates on an annual basis. Think about this, on an annual basis, your healthcare premiums, your healthcare costs were generally rising about 5.4% a year. Okay, who could keep up with that? Who could keep up with every year your healthcare costs continuing to rise? And so we did the Affordable Care Act, and guess what? We did get that into the rate of inflation. I think there's more we could have done. Lots of things happened in between, but we literally got it down to 3.7%. And we did that by covering more people. The audacity of my colleagues over here to now claim that Medicaid expenses got too expensive, when in reality we made this choice to drive down these premium costs so they were only rising close to inflation, and that was our goal, and we succeeded. So what are we doing now? Well, under the GOP plan, Wakely Healthcare Institute and the Center for Budget Policy, these are numbers that come from them. The GOP plan will now go back to raising your premiums and your healthcare costs between 7 and 11% a year. A year. So we're going to go blowing way past the 5.4. We're going to go back here. And why? Because you're going to cut off millions of people from health care. You're going to increase the cost of uncompensated care. You're going to make people wait to go to emergency rooms, and then they're going to be sicker, and that's going to cost, I don't know how much it costs, but it's definitely a multiple of 5 or more. I don't know if it's, what do you know? What do you think it is, Kevin, an emergency room? 10. Okay, 10. He says 10. It's 10 times more expensive to deal with somebody at an emergency room than just get health insurance and get covered. Okay, so now we want to know, why are we raising the cost on everybody's health insurance, including these plans? Because this side of the aisle basically wants to cut a bunch of people out of a system that lowered the cost of healthcare plans overall and kept it more in the rate of inflation. Why? Why would you want to do this? So it makes no sense, and I hope our colleagues will think long and hard about that. I also think that you could still take the Google Meta tax break for multinationals and pay for $100,000 and cover the Medicaid. You could take another $100,000 from that big tax break, and you could pay for some of the energy tax credits that were so essential to combating the Chinese in what they are doing on the clean energy front. The Chinese firms are doing everything they can to invest and undercut the United States in EV and battery technology. The U.S. is responding aggressively to that. That's why we did the Inflation Reduction Act. In fact, the Inflation Reduction Act, we basically enacted more than 2,000 new clean energy industrial manufacturing jobs, more than 980 private sector jobs, and more than 3.4 million Americans claimed clean energy tax credits that improve their efficiencies. In fact, the Joint Economic Committee estimated that the typical household could save between $460 and $1,000 in annual energy costs, thanks to the Inflation Reduction Act. But what do we have now? We have President Trump and inflation. We have inflation because of multiple issues, consumers struggling to keep up amid higher prices, mounting debt, and fiscal uncertainty. That's what we have. And so we're reversing the very tax credits that help lower the cost and were going to help us be competitive against China and help us succeed as a nation in the one thing that I always think the United States is really great at, and that is innovation. I don't know if it just started with Ben Franklin or many other people along the way, but you give Americans the task and they will do the job. If you give them the education, if you give them the R&D with a university partner, they will get the job done. And so now, don't take my word for it, take Mr. Musk's word for it. The latest Senate draft bill destroys millions of jobs in America and causes immense strategic harm to our country. Utterly insane, destructive. It gives handouts to the industries of the past while severely damaging the industries of the future. Yeah, he said it best. But back to that chart, we were doing the energy because we wanted to diversify, but we also wanted to lower costs and we wanted to be competitive. Right here it says the vehicle. Okay, natural gas, propane. Okay, that's why we were diversifying, because all those things are going up. So, and this bill is not going to help electricity. You're getting rid of the electricity tax credit. So again, instead of helping Meta and helping Google, you could be helping to lower the inflationary cost by making the investments in these tax credits. But Mr. President, there's more in this bill that I don't like. My colleague from Texas is proposing an AI moratorium. He literally wants to stop states from regulating the rollout of autonomous vehicles like Texas Governor Greg Abbott, who signed a letter last week to regulate how autonomous vehicles are licensed and deployed in Texas. And how do proponents of this moratorium propose to get started? By holding broadband money hostage unless you implement an AI moratorium. Well, I know what the Heritage Foundation said. The Heritage Foundation said that federal AI power grab could end state protection for kids and workers. Again, you are giving states a big, fat bill, and now you're trying to override laws that have been on the books for a long time, protecting consumers from fraud, from abuse, and from protecting, they are there to protect kids, and now you want to get rid of them. So it's no surprise that stakeholders on the right and left oppose this in the bill. They include 17 Republican governors and 40 attorney generals from both Democrats and Republicans. and other organizations ranging from the Heritage Foundation to the Center of American Progress. So anytime you can get the Center for American Progress and the Heritage Foundation on the same side of an issue, chances are you should be listening to what they have to say. But Mr. President, this letter, I would like to enter into the record from the National Association of Attorney Generals.
Without objection.
This bill would affect hundreds, I'm quoting now from this letter, quote, this bill would affect hundreds of existing and pending state laws passed and considered by both Republican and Democratic state legislatures. Some existing laws have been on the books for many years, end quote. Okay, so these are attorney generals from a variety of states who basically know the laws on their books, and they're basically saying, don't do this to us. Don't override our laws. So I'd also like to enter into the record, Mr. President, a letter from 17 Republican governors also against this provision.
Without objection.
Their letter, I'd like to read from, is really about this point I was trying to make about fighting China. I mean, I thought we were here to be competitive against them, to basically beat them in a race on innovation, just like we did with chips and science to try to move for the future. But basically their letter says, quote, we fully recognize that AI is dominant in the next industrial competition between the United States and adversaries like Communist China. States have led anti-Communist China action, banning Chinese affiliated companies from owning farmland and property critical for infrastructure and military bases. But America should not sacrifice the health and safety and prosperity of its people in this fight. We must curb AI's worst excesses while also encouraging growth, which is exactly what states have done through their creation of their own regulatory framework, end quote. So they're basically saying the states are on the front lines of helping to protect on AI. Now, Mr. President, I have no idea why the President of the United States has not protected the American people or the American military from the Chinese scams that are happening on TikTok. No, we would never let China own ABC News and put out Chinese communist propaganda on ABC News, but we let them do that on TikTok. This body and our colleagues said, no, stop that and stop the Chinese. And yet we still haven't stopped the Chinese. So now here we are in this bill cutting out the state's abilities to fight Chinese AI companies like DeepSeek or Alibaba, and they have no interest in stopping the scammers from using their AI products to harm Americans. They have none. And if you think we're going to pass something here, I'm always ready to sign up to get legislation done. But that isn't going to happen anytime soon. And so now you're telling these governors, these attorney generals, yep, I'm not even going to let you fight China because I'm going to take that tool away from you. So clearly, I don't support this part of the legislation, and I appreciate my colleague from Tennessee and her attorney general working on this very important issue. And finally, I come to the issue of spectrum. This is a very ill-conceived plan to auction off our precious spectrum. Such an auction will fundamentally compromise our defense capabilities while endangering aviation and important federal capabilities like weather forecasting and scientific research. This bill would require the FAA would require an auction of 800 megahertz of spectrum critical to our military and civilian infrastructure. It would compromise military radio frequencies and weather and other spectrum issues, most importantly, drone operations. And I know the presiding officer knows how much drones are now at the epicenter and forefront of warfare and is reshaping the battlefields across the globe. So why would we do this? Well, my colleague, Senator Cruz, is pushing for something that experts say would risk military operations. Last Congress, we got the Department of Defense and the Department of Commerce to agree that we should test bed the next generation of technology because we don't like interference. Now, I'm sure most Americans sitting at home thinking, what is she talking about? Well, if you drive in a car and you have a radio station, and all of a sudden the radio station doesn't get its signal or has some interference, you know that there is an issue. The tower, not big enough, not strong enough. This is the same. This radio spectrum has been used by Department of Defense for secure purposes, very important secure purposes. Mr. President, think of the Chinese balloon and the fact that we want to detect when a Chinese balloon is flying through our airspace. We want to be able to stop people from spying on the United States of America. And yet, instead of basically saying, we are going to look at this military spectrum and make sure that it continues to be secure, my colleague is suggesting to all of us that we sell that and basically allow, I believe, for what is going to be a good amount of interference without solving this problem first. Why does that bother me? Because I think we live in a world where you're going to see more and more spectrum, more and more warfare based on satellite and communication, and the landscape is changing. So I certainly don't want our military preparedness to be affected. Air Force leaders warned that spectrum bands are crucial to this radar operations, and I'm not going to go into more about why, but I'm just saying, just like you can't have 4 radio stations basically interfering with each other, my colleagues want to allow the major telcos, mostly AT&T and Verizon, who are so hungry to sell more, whatever it is, $79.99 plans or $59.99 plans. They literally are going to give away national security just so they can sell more telephone plans. In fact, I would ask them, what have you done to clean up the last disaster that you had when the Chinese hacked you on Salt Typhoon? Now, they didn't successfully hack the telecom company in my state because they were smart enough to do all the preparatory work not to be hacked. But these guys didn't do the work, and now they're up here pushing our colleagues to say, give us more, give us more, give us more, without doing the homework required to figure out how to make sure our military is protected. But what's even more infuriating is they want the same spectrum from our airlines as well. They want to cause confusion between the spectrum of aviation and in this telecommunication. Last time the Trump administration did this, there was a major, major debate, and the White House and the Biden administration had to come in and fix it. It's all related to the altimeter on a plane. Again, the presiding officer knows this well. An altimeter helps tell the plane what altitude they're at and what to do. But if you have interference with that altimeter, as we just saw in this helicopter accident, we're pretty sure now that this accident between an American plane, regional jet, and an Air Force helicopter, there were some altimeter issues, and that caused a discrepancy and a crash. So I am not for any interference with an aviation altimeter. I'm not for it. But instead of figuring this out, working together, both commercial and defense, we're jamming into a bill the overriding of the defense interests and saying just give it to these 2 commercial bidders, maybe more, who then will basically just feel empowered to sell more of these telco plans. Mr. President, our competitiveness is too important. Our effectiveness is too important. Collaboration and working together to solve these problems is how the United States is going to succeed. Basically, trying to pit each other against each other in these kind of technology issues is not going to help us win. So, Mr. President, I've outlined many issues here, and I've outlined how you could fund Medicaid without basically doing what we are doing here. There is no reason. According to the Penn-Wharton budget model and analysis, families in the first 40% of earners are on average projected to experience losses in after-tax income and benefit transfers. In other words, Mr. President, yes, extending the 2017 tax cuts does help some middle-class families, and we would support that, but all the hits in other areas, like health insurance, mean they will actually lose money overall. The lowest 20% of income brackets are hit even harder. So in this massive bill, it is those who can least afford it who are going to be hit the hardest. We don't need the Trump inflation. We need to protect health care. We need to make progress in America's competitiveness. But this is not the answer, and I encourage my colleagues to vote against it. I thank the President, and I yield the floor.
Senator from Vermont.
Thank you. Mr. President, President Trump's so-called big, beautiful bill, now on the floor of the Senate, is the most dangerous piece of legislation in the modern history of our country. It is a gift to the billionaire class while causing massive pain for low-income and working-class Americans. Actually, though, Mr. President, I'm wrong. This is not a gift to the billionaire class. They paid for it. This bill is an absolute reflection of a corrupt campaign finance system which allows billionaires to buy elections. And when billionaires spend hundreds and hundreds of millions of dollars trying to elect a president or a senator or a member of Congress, they're not making that investment just for the fun of it. They want something in return, and this legislation, big time, is what they are getting in return. So what is in this bill that they invested in? Well, if you are in the top 1%, you and the class you represent will receive a $975 billion tax break. $975 billion tax break at a time when the richest people in this country have never, ever had it so good. Further, this is really quite unbelievable. If you are among the wealthiest 0.2%, not talking about 1%, talking about the top 0.2%, you will be able to pay zero taxes on your $30 million inheritance. So all of you folks out there who are waiting to inherit at least $30 million, today is a good day for you. Collectively, you will receive approximately $211 billion in tax breaks for the top 0.2%. Congratulations, you hit the jackpot. If you are a large corporation and you want to throw workers out on the street and replace them with artificial intelligence, or maybe you want to shift your profits to the Cayman Islands or other tax havens, you are going to get a $918 billion tax break. Congratulations to the CEOs of large, profitable corporations. But while the rich and large corporations make out like bandits in this bill, what does it do for low-income and working families? Well, let me say a few words on that. If you are concerned about health care, which I suspect that everybody in the world is, this bill throws over 16 million people off the health insurance they have, according to the Congressional Budget Office, by cutting Medicaid and the Affordable Care Act by over $1.1 trillion. In other words, the top 1% getting a $975 billion tax break, and that is coming directly by throwing 16 million people off of the health insurance they have. This bill, for the first time, forces millions of Medicaid recipients who make as little as $16,000 a year to pay a $35 copayment every time they visit a doctor's office. So what is the impact of all of that? You throw 16 million people have health care. You force people who don't have any money pay a $35 copayment. So what's the impact of it? Well, this is not my view. This is what the Yale School of Public Health and the University of Pennsylvania determined based on a study that they did. And this is the result. And it is almost so horrific, so grotesque, that it is difficult to speak about. But they estimate that if this bill goes through with all of these cuts in health care, if 16 million people are thrown off of the insurance they have, over 50,000 Americans will die unnecessarily every year. 50,000 Americans will die unnecessarily in order to give tax breaks to billionaires who don't need them. In other words, this bill is literally a death sentence for low-income and working-class people. Further, if this legislation is enacted, rural hospitals all over the country, and I come from one of the most rural states in America, rural hospitals are already struggling. But when you make massive cuts to Medicaid, many of them are going to shut down or not be able to provide the level of services they do today. In other words, this bill would be a disaster for rural America. It would also make massive cuts to community health centers and nursing homes who are very heavily dependent upon Medicaid funding. Bottom line is that this legislation is the most significant attack on the health care needs of the American people in our country's history. We already have, as everybody knows, a health care system which is broken, which is dysfunctional, and instead of addressing it, instead of doing what every other major country on earth does, guarantee health care to all people, we are throwing 16 million people off the health insurance that they have. But it's not just health care. The future of America rests with our children. And yet, in a nation which now has the highest rate of childhood poverty of almost any major country on earth, this bill wipes out nutrition assistance for millions of hungry kids in America. We are literally taking food out of the mouths of hungry kids to give tax breaks to Mr. Bezos and Mr. Musk and Mr. Zuckerberg and the other multi-billionaires. If we understand that if we're going to compete effectively in the global economy, we need to have the best education system in the world, this bill makes $350 billion in cuts in education, with the result that working-class kids will find it much harder to get the higher education they need to succeed in life. If you are concerned about the existential threat of climate change, and we're seeing heat waves right now all over the world, this bill decimates investments in energy efficiency and sustainable energy like wind and solar, and moves us in exactly the wrong direction with regard to energy. If you are concerned about our role in never-ending wars, this bill makes a bad situation even worse by handing out another $150 billion to the Pentagon, a 15% increase in an already bloated Pentagon budget. We don't have enough money to feed hungry children. We don't have enough money to make sure that people continue to have the health care that they need. Don't have enough money to make sure the kids can get a decent education. But somehow the military-industrial complex is going to get another $150 billion, 15% increase. Mr. President, in my view, nobody in the Senate or the House should vote for this legislation, and I applaud all of the Democrats for voting against it, and I want to congratulate two Republicans, Senator Paul and Senator Tillis, for voting against it, for different reasons, by the way, than I have. But I do find it interesting, and it does tell us where we are as a nation today, that when one of those senators, Senator Tillis, voted against it because he thought it was not a good bill for the people of his home state, North Carolina, suddenly the President of the United States went after him in a very, very vicious way. And today he announced that he will not be seeking re-election. So it appears now that the Republican Party has really become a party of the cult of the individual. The only thing you have to do now as a Republican is say, I agree with President Trump. I love President Trump. President Trump is right all of the time. Hey, that's all you got to do now to be a good Republican. There was a day when Republicans and Democrats understood that they were elected by their constituents. Yeah, you want to work with the president of your own party, nothing to do about that. But there was an understanding that you were also elected to represent your constituents and not simply pay homage and bow down to every wish and whim of the president. Mr. President, during the vote-a-rama, I will be offering several amendments, which I hope will win support. Number one, at a time when 22% of our nation's seniors are trying to survive on less than $15,000 a year, my first amendment would fundamentally improve their lives in two significant ways. Number one, it would cut the price of prescription drugs under Medicare in half by making sure that our nation's seniors do not pay any more than Europeans or Canadians pay for the same exact drugs. And number two, with those savings, we're going to expand Medicare to cover dental, vision, and hearing. In other words, instead of throwing people off of health care, we're going to expand Medicare to provide a number of services that seniors desperately need and want. Secondly, Mr. President, at a time of massive income and wealth inequality, my second amendment would eliminate the $211 billion estate tax for the top 0.2% that is included in this bill. They get a top 2%, as I mentioned, $211 billion tax rate. That is insane. We're going to get rid of that. And lastly, at a time when we spend more on the military than the next 9 nations combined, at a time when the Pentagon cannot account for trillions of dollars in assets, we are going to end the provision that allows the Pentagon to receive another $150 billion. Bottom line, Mr. President, is this country faces many crises: high rate of childhood poverty, kids going hungry, education system in deep trouble, healthcare system completely broken. And in virtually every single area, this bill takes us in precisely the wrong direction. When the wealthiest people in this country have never, ever had it so good, it is totally insane to be offering them $1 trillion in tax breaks so that we can cut health care, education, and nutrition. This bill is not what the American people want, and I hope very much we can defeat it. Thank you very much, Mr. President.
The Sergeant of Arms will restore order. The Sergeant of Arms will restore order in the galley. The Sergeant of Arms will restore order. The Sergeant of Arms will restore order in the galley. Sergeant of Arms will restore order in the galley. The Democratic leader.
Mr. President, I thank my colleagues for coming to the floor. Wait, we'll put this up when we begin. Okay. We'll leave it up. All right. I thank my colleagues for coming to the floor all day today. I thank them for speaking so fiercely, so clearly about what's at stake for the country. And the American people deserve to see this debate. That's why we last night forced a reading of the bill. Republicans don't want people to know what's in the bill. They want to hide it. They know it's not popular. We all know it's not popular. We all know it's totally against what people want. But a small cabal of very wealthy people and hard MAGA people run that show to the detriment of the party itself and, of course, to the American people. So we forced a reading of the bill last night and allowed people to catch up because the bill was just put on the floor right before the reading started, the amended bill. So we're here today to continue to shine a light on how bad this bill is, and this debate will continue. Soon we'll turn to vote-a-rama and bring amendment after amendment after amendment to the floor, so Republicans can defend their billionaire tax cuts, so they can try to explain their massive cuts to Medicaid to people back home, why kids who need health care shouldn't get it so there can be tax breaks for billionaires, why middle-class families who have someone in a nursing home who's now going to be removed from that nursing home because it's going to close, what they're going to do, and to try and to sell to parents and kids why they're making unprecedented cuts to SNAP, taking food from hungry babies for a tax cut for wealthy people. What kind of world do these Republicans live in? It's a slanted world. It's really a corrupt world. Kids will get $5 a day to feed themselves. You can't buy a dozen eggs for $5. And then they're killing millions of good-paying jobs. It's estimated, and by the way, the clean energy cuts are even worse. Before this, it was estimated 850,000 jobs would be lost in America on clean energy alone. Over 1 million jobs in health care. 2 million jobs approximately lost, at least 2 million lost because of this bill. That could create a recession. So this has been a long few days in the Senate, but the hardest choices for Republicans are still in front of them, because we know that so many of our colleagues on the other side aren't happy with this bill. Tillis is not an exception. There are many others who think the same way he does. Well, they ought to vote their principles, their conscience, and what's good for their constituencies. Our side is going to give our Republican colleagues a chance to do the right thing in front of this chamber and in front of this nation. The American people deserve to know exactly what's happening right now in the United States Senate, because right now, Republicans are concocting the ultimate rush job. They're trying to pull off a sneak attack on this chamber and on the American people themselves. The bill before the Senate is utter poison. Some Republicans are trying to rush through a bill that they released less than 2 days ago under the cloak of darkness, written behind closed doors, molded in order to appease Donald Trump and the very special, powerful interests. Earlier today, my colleague from South Carolina came to the floor with a pretty interesting-looking floor chart, where he claimed that his bill somehow reduced the debt by $500 billion. What a joke. The budget chair respectfully needs to check his math, because somehow Lindsey Graham, the chairman of the Budget Committee, said that his bill reduces the debt by $500 billion. The budget chair, respectfully, check your math, Chairman Graham, because not 1 hour ago, the JCT confirmed this bill does not reduce the debt, it explodes it. It explodes it. That's what it does. Here's what his chart should have looked like. $4.45 trillion deficit explosion. According to the JCT, the Republican bill explodes the debt by $4.5 trillion, as this chart, drawn slightly better than Lindsay's, shows. For those keeping score at home, my colleague got his math wrong by a whopping $4 trillion. All this, just so billionaires are rewarded while millions lose their health care break. $4.5 trillion deficit explosion. And that's not just an abstract concept. What does that mean? The average American will pay more to buy a home. The average American will pay more to buy a car. The average American will pay more on their credit card debt, on issue after issue after issue. Prices will go up because of this deficit, because of taxes for the billionaire. That's $4.45 trillion. Also, some people, wealthy people, God bless them, they made a lot of money, okay. They don't need a tax break. Let it be known that this bill is the death knell of the supposed party of fiscal responsibility. We always knew that this was a sham. And now this bill ends the charade of Republicans caring about the debt for all time coming. When they say they have to cut health care on any bill or food stamps on any bill because it reduces the deficit, we will know it's utter hogwash because of $4.5 trillion they're doing now for tax breaks for the wealthy. So, Republicans want to move quickly. That's why we're here on the weekend. That's why they released a bill in the dead of the night, all because they want to hide the truth from the American people. You know, it's hard to believe, my colleagues. This bill is worse, even worse, than any draft we have seen thus far. Every time the bill comes to the floor, a new bill, a new amendment, the hard right handful over on the Republican side, we're not voting for it unless you hurt kids more. You hurt people who need health care more. You hurt rural hospitals more. You hurt clean energy more. And the Republican leadership folds and does it. And the handful of more mainstream Republicans who know how bad this is right now haven't had the backbone to oppose those changes. We hope they find them. So, this bill is worse on health care, worse on SNAP. It'll kill 900,000 good-paying jobs in clean energy. Folks, you don't like paying your electricity bills? You'll pay 10% more on your electric bills because of this big, ugly betrayal. It'll also kill 1 million health care jobs. You put it all together, and there's no other way to put it. At the very last minute, the Senate Republicans made the bill more extreme to cater to the radicals in the House and the Senate. Republicans want to hide the truth so badly, in fact, that they're even ready to blow up the Senate rules to get it done. Senate Republicans are doing something that has never been done before in this chamber, never, by Democrats or Republicans, using fake math and budgetary hocus pocus to make it seem like a gargantuan tax break for billionaires is going to cost virtually nothing. That's insane. It's delusional. Current policy baseline doesn't take into account that our actual budget numbers show these cuts expiring. So when you put them back up again, the deficit increases. It's simple math, second-grade math. But our colleagues, just again, in a frenzy to help the billionaires, are willing even to do that. Republicans know it. That's why they're squirming. You can see sort of the faces come on the floor. They don't look very happy because they know how bad this stuff is. And they can use whatever budgetary gimmicks they want. Republicans can use whatever budgetary gimmicks they want to make their math work on paper. But you can't paper over the real consequences of adding trillions and trillions to the debt in one fell swoop. And CBO, nonpartisan, everyone who looks at this says it's going to increase the deficit. Not the so-called party of deficit hawks. That's out the window. So, what's going to happen when they pass this bill, if they do? Hope they don't. Our children and grandchildren are going to be faced with a lifetime of higher borrowing costs. As I said, mortgage costs, costs to buy a car, costs for a credit card, harder to start a business. Every one of these will get worse. And the economic ceiling of this country will close in on itself. The economic engine that's been the driver of American innovation and growth and optimism for so many generations will sputter and ossify with this $4.45 trillion deficit explosion. It's deeply irresponsible to future generations, to our children, to our grandchildren, to pass this bill. And that's not just members on this side of the aisle saying it. Independent experts across the political spectrum, many of them very conservative Republicans, but who are at least honest about what they're doing, say it too. And plenty of Republicans in both the House and Senate have said it. It remains to be seen if their words and their actions will align. And the question is asked, has to be asked, why is this even happening? Why is this nightmare of a bill moving forward? Why are Republicans forcing our country down this ruinous road when they know the fiscal harms, when they know this is a rush job? Well, we know by now. Tax cuts to billionaires and corporate special interests. And not just another round, but in fact, they make them permanent. Our children, our grandchildren are going to be saddled with these cuts so that a handful of billionaires get a big break, while working people lose their Medicaid, while hungry kids lose access to food funding, while clean energy jobs that support so many Republican communities are taken away. I'd say to my Republican friends, when that plant that makes batteries or wind or solar, or the person who's employing hundreds of people to put panels on people's roofs all fold and the people lose their jobs, don't shrug your shoulders and say, I don't know why that happened. You made it happen with a nasty bill. It just makes no sense. We need more energy. AI, everyone says we need more energy. And to take away the cheapest, quickest way to put more electrons on the grid, solar, makes no sense, except we know Donald Trump has an irrational, infantile mania against clean energy. So they all listen to him. Makes no sense. This bill is sabotaging of America. It's the sabotaging of America. It's antithetical to what the country needs. It's antithetical to what the American people demanded last fall. And our Republican colleagues don't even want to tell the American people the truth. That's why Democrats are here on the floor today, sounding the alarm, setting the record straight. I also must say this. The way this bill is being passed so deeply violates the spirit of the Senate. The majority forgets that this chamber is unlike any other institution in government. It's meant to facilitate debate, careful consideration, sound judgment, honest numbers. We're supposed to resist the passions of the radical extreme. We're supposed to hold the line against policies that will devastate our country. We're supposed to resist the gravitational pull of extremists like Donald Trump, who gets these little bugaboos in his head and then wrecks America because of it, and they all go along. Senate Republicans are turning their back on the Senate's long-standing tradition of debate deliberation. By rushing this bill, by upending the rule of the chamber, by engaging in what amounts to accounting magic to hide the cost of their bill, Republicans, simply put, are accelerating the erosion of the Senate to the nth degree. Senate Republicans are turning their back on what makes this institution great. More importantly, they're turning their back on the people, their own constituents, in their own communities. People struggling to afford going to see a doctor. You have a child with cancer and you don't have health care? How can we put people in that position? or families who have to choose between paying for groceries or paying for prescription drug costs, or families who are watching their electricity bills go up and up, families who are paying more and more costs. This bill, America, you don't want to pay higher costs? We don't want you to on our side of the aisle. The Republicans are making it happen. You will pay more and more and more. And about the future, they're not worried about our kids' livelihood. They're not worried that kids won't be able to find good-paying jobs. The families are worried about the future of this country. But the Republicans are not. And they're worried, Americans are worried about the continued radicalization of leaders in government. And here's the shining example. So the bill is the wrong answer for the American people. By every objective standard, it's deeply irresponsible. It's not only a violation of how the Senate's supposed to work, it's a violation of the promises that Republicans and Donald Trump, when they campaigned, made to the American people to look after their issues, not those at the very top. So I implore my Republican colleagues, there is still time. Abandon these terrible policies. We'll continue to have this debate in a real way, not jamming it through in the dark of night. My Democratic colleagues and I will continue exposing the truth. And if Republicans go down that road, we will continue to make sure today, tomorrow, next week, next month, next year, that the American people know exactly what happened here. I assure my Republican colleagues, I assure them this vote will not be forgotten. Their betrayal will not go unanswered. This bill must not stand. I yield the floor.
President.
Senator from Massachusetts.
Thank you, Mr. President, and thank you, Mr. Leader, for setting the record straight. It's really awful when we hear Republicans come down here and they just don't tell the truth about the bill that they are trying to pass. Maybe that's why they try to pass it in the middle of the night. They think no one will really notice.
Would the gentlelady yield?
I will.
Senator, yield. All you have to do is look at their faces.
Yeah.
They know that what they're doing. They know it's unpopular. They know they're, as Senator Murkowski said, that they're all afraid. But it's time for them to stand up, isn't it?
Yep. So on Friday, I met Vivian. Vivian is an 11-year-old kid from Winston-Salem, North Carolina. Vivian likes school. She likes her friends. She likes reading Harry Potter. She is a lot like any other 11-year-old. But for Vivi, going to school and being with her friends depends on Medicaid, because Medicaid covers the cost for her wheelchair, for her therapists, and for her health aid. Right now, Republicans are trying to rip away health care from kids like Vivian. The cruelty is truly breathtaking. I ask for one Republican senator, just one Republican senator, who plans to vote for this bill to look into Vivi's eyes and tell her that her health care is just not a priority for this country. You know, Mitch McConnell said to Republican senators that he knew they were getting calls about Medicaid, but not to worry about people losing their care because, according to Mitch McConnell, they will get over it. So I ask the Republican senators to look at Vivi and Vivi's sisters and Vivi's mom and Vivi's dad and say, if Vivi loses her Medicaid and her wheelchair and her therapists and her health aid, tell all of them that they will get over it. Because here's the deal. Vivi won't get over it. Her family won't get over it. The people of North Carolina won't get over it. None of us, Massachusetts, Idaho, Louisiana, none of us will get over it. The cruelty here is off the charts. But the part that really burns is the Republicans are trying to slash the health care that keeps kids like Vivi alive so they can hand out more tax cuts for billionaires. It is beyond cruel. It is obscene. I am angry, and we should all be angry. Because instead of playing at the pool or the park like a regular kid on summer break, Vivian had to come here to Washington to beg senators not to cut her health care. In a country as rich as ours, that shouldn't even be a question. Now, I actually don't think that my Republican colleagues have lost their hearts. They have lost their spines. It seems that all they can do now is bow down to Donald Trump and his billionaire donors. They will bow down, even if it means hurting families, community hospitals, and nursing homes in their own states. Trump wants the Republicans in Congress to hand out giant checks to the wealthiest Americans and the biggest corporations, and the Republican senators are willing to do that, even if it means kicking Vivi to the curb. Republicans know what they're doing. They know that this bill will hurt people. They know that this bill will kill people. And though it's hard to believe, they just look the other way. But on behalf of Vivi and millions of other kids and mamas and seniors and families that rely on the life-saving care that Medicaid makes possible, my Republican colleagues should grow a spine and stop this awful bill in its tracks. If it wasn't bad enough that this bill is set to rip away health care from 17 million Americans to pay for tax giveaways for billionaires, it actually has a bunch of other filthy giveaways buried in it, too. Who wins if Republicans pass this big, ugly bill? Billionaires, Wall Street, big tech, big oil, the wealthiest Americans, and the biggest corporations. Big oil will get a special get out of paying your taxes card, while millions of people lose their health care coverage. Billions of dollars for big oil, nothing for Vivi. Meta, oh man, Meta, there's a company that's really struggling. Meta will win $15 billion to incentivize them to do research in 2022, 2023, and 2024. Think about that. Unless a time machine comes with this, what Meta does in those 3 years is already done. But under this bill, Meta gets a $15 billion check on the day this bill passes, simply for existing, while families lose access to their health care. Wall Street wins big with a provision Republicans squeezed in that would slash funding for the Consumer Financial Protection Bureau. Giant corporations want the opportunity to cheat American families again. So Republicans are desperately trying to take the cop off the beat. And who loses thanks to this big, ugly bill? Americans who can't afford health care. Families who need a little extra help putting food on the table. Grandmas and grandpas in nursing homes. Little babies and their mamas. If Republicans pass this bill, 17 million Americans will have their health care ripped away. That number has kept growing as the Republicans keep making more and more changes to the bill. For them, it is just a question of how many more Americans they can rip away health care from. This bill would also make the biggest cut to food assistance for families, kids, and veterans in American history. And here's one to underscore. 1 out of every 4 nursing homes in America would have to shut down under this bill. You know, my Republican colleagues should just call a few seniors who are in nursing homes in their home states and just go over the plans for where those folks are supposed to go next. What exactly do the Republicans have in mind for them? Maybe call the daughter of someone who's in one of those nursing homes and explain how she has to become a full-time caregiver once this bill passes. Maybe call just a few of the people whose lives you plan to tear apart. Budgets are about our values, and Republicans have made their values clear. They are willing to throw millions of Americans under the bus so that they can help out a handful of their billionaire buddies and giant corporations. They should be ashamed. Here's what Democrats believe. Democrats believe that no baby should go hungry so that Mark Zuckerberg can buy another Hawaiian island. Democrats believe that no person with a disability who needs a wheelchair or a home health aide to live independently should have to give that up so that Jeff Bezos can buy a third yacht. And Democrats believe that no grandma should be pushed out of her nursing home so that Elon Musk can take a subsidized rocket ship ride to Mars. It doesn't have to be this way. What if, instead of tax breaks for billionaires, we make the rich pay their fair share? What if, instead of slashing health care for our kids, we make it possible for every American to see a doctor when they're sick without breaking the bank? And what if, instead of giving big oil more giant handouts, we make universal child care a reality for families all across this country? We can tax the rich. Damn it, if Jeff Bezos can afford to rent Venice for $50 million for his wedding, he can afford to pitch in his fair share on taxes so the next kid has a chance to make it big, and the kid after that, and the kid after that. We can make life better for working people. We can make it easier, not harder. We can lower costs for families, not jack them up even more like this bill does. We can put families first, not billionaires and billionaire corporations. Democrats believe this. Democrats are willing to fight for this. We will vote no on this awful bill. And for kids like Vivian, for seniors in nursing homes, for families who rely on home health aides, and for the millions more Americans that this bill will hurt, I urge my Republican colleagues, grow a spine and vote no. Thank you, Mr. President. I yield the floor.
Senator from Oregon.
President, before she leaves the floor, I want to thank my colleague in particular for putting a human face on what this is all about for us on this side of the aisle. That small child, the senior you were talking about, I'm going to pick up on what you said, and I thank you for your leadership. Mr. President, I'm going to get into the specifics of this horrifying bill in a moment, all the details of the healthcare carnage and the clean energy bloodbath that Republicans are dragging America toward. First, though, I want to spend just a few minutes on the state of the Senate and our democracy. As of a few hours ago, the rules of the Senate are whatever Republicans feel like when the day begins. It's democracy defying, plain and simple. The bill before the Senate is loaded with fraudulent budget math that hides trillions of dollars in handouts to corporations and the ultra-wealthy. It's a violation of the rules that used to be followed for years for the reconciliation process. It's a violation of the Congressional Budget Act. It's a violation of common sense. Republicans decided that none of that matters, so they've kind of gone nuclear to advance the bill. Apparently in this chamber, if the Republican chair of the Budget Committee says so, 1 + 1 = 3. That is unsustainable. We are going to be a sicker, poorer, and weaker country if this bill becomes law, and the Republicans have used this process, going nuclear, to pass it. But these moves cut both ways, and there'll be a lot of cleanup for Democrats to handle down the road. Now, in my time in public service, Mr. President, I have never seen a more destructive, regressive, common sense defying bill debated in the Senate. This bill is going to determine the future of health care in America. Millions of Americans will lose their health insurance if Republicans pass the bill. My colleagues seem to be ignoring, for example, the fact that rural hospitals are the anchor of life in much of America. This bill will sever that anchor and set rural health care adrift. Here's how flawed the Republican plan is. The danger they're causing for rural hospitals is so great, Republicans have had to create a rural hospital relief fund. It is a Band-Aid on an amputation. I can tell you one thing I know for sure is only in Washington, D.C. would you create a relief fund to address a problem that you caused. How about you just not cut $1 trillion from Medicaid in the first place? Now, I wanted to get a sense of what rural America thought of this legislation. So last weekend, I held 4 town halls in 3 Eastern Oregon counties. It's as rural as it gets. Donald Trump carried these counties overwhelmingly. One of them was Malheur County, where Donald Trump received more than 70% of the vote. This is where I held an open-to-all town hall meeting. It happens to have one of the highest Medicaid enrollments in the country. The message I heard was very clear and very loud. This bill will be a disaster for Malheur County on rural health. Now, healthcare is a top employer in America. If these cuts go through, the healthcare workforce in rural areas of our nation is going to be decimated. Nurses, doctors, and support staff will lose their jobs, and rural economies are going to suffer. Many of the Americans that will feel the consequences of this legislation today walk an economic tightrope. Many have multiple jobs. Millions more Americans will lose their benefits like home care and mental health and services that already fall far short of what our people expect. These are overwhelmingly kids, people with disabilities, seniors, all to pay for more tax cuts for multinational corporations and the ultra-wealthy. It's not just the cuts. It's also a whole lot more red tape, making it harder for people to get care. At the center of the Republican Medicaid changes is a bunch of red tape thickets designed to entrap people into a never-ending maze of AI chatbots and phone trees that make it impossible for them to get the coverage they need. And even if you manage to get through all that bureaucratic water torture and sign up for Medicaid, the Republican plan says if you lose your job, you lose your health care. Why would the Congress want to inflict that on more people? Nobody I could find wants these cuts, no matter their political persuasion, and I was in places that were bright red. I'm sure most of us can agree there's a real debate to be had on how we can make health care more affordable and accessible, but this bill achieves none of that. Let me mention seniors. My colleagues have touched on the elderly. 2 in 3 nursing home beds in America are covered by Medicaid. If Republicans pass this into law, conditions will deteriorate. Seniors will be forced out of their nursing homes or forced to move in with family that doesn't have the necessary skills to care for their aging parents or grandparents. Nursing homes would be forced to shut their doors as a result of these cuts during a time when states are in desperate need of more nursing home options, not fewer. The bill also repeals nursing home safety standards. That's going to mean fewer nurses in nursing homes. You would think that'd be a concern of Republicans in the Trump administration. But when the Finance Committee was considering the nomination of CMS Administrator Mehmet Oz, he said, and I quote, "I believe we can provide quality of care equivalent to having a nurse in that nursing home using tools and technologies." Dr. Oz was apparently talking about AI. And I said, "You're for cutting nurses. What's going to happen when an 85-year-old woman has to go to the bathroom in the middle of the night and needs some help?" He had no answers, but he's still being a big booster on artificial intelligence. I'm deeply troubled about what the Trump administration has in store for America's seniors. That's on top of the fact that home-based care that most seniors prefer will be one of the first benefits states are forced to cut because it's optional now rather than mandatory. Hundreds of thousands of seniors, Mr. President, are going to see a premium increase of about $200 a month. The bill also applies the worst forms of corporate red tape to the Affordable Care Act. Shorter enrollment periods, more verification forms, more hoops, more bureaucracy, more red tape for Americans who just want affordable health care. And the health care carnage may get worse with the Republican amendments coming up. It's my understanding that they're going to offer an amendment that would lower the federal Medicaid match for new enrollees in what's known as the Medicaid expansion. That was a key part of the Affordable Care Act that delivered affordable health care to roughly 21 million Americans last year. If this amendment is adopted, taken together with the other awful policies in the bill, it would amount to repealing the Affordable Care Act and making good on the 15-year Republican crusade to dismantle that law. Millions more working Americans, Mr. President, are going to lose their health insurance, and it would break a promise to the 41 states that have expanded Medicaid, many of them red states. These health care cuts aren't just going to be felt by Americans with Medicaid, and those who buy health insurance on their own are going to be similarly hit. Emergency room wait times are going to skyrocket, and premiums will spike. Families will be one lost job or financial calamity away from being tossed onto a safety net that has rips and tears everywhere you look. So many are going to fall between the cracks. I also wanted to touch on another horrendous provision on health care buried in the bill, the defunding of the Planned Parenthood program, and they're doing it in a way that's essentially a backdoor nationwide abortion ban. This provision is